Thank you, Mr. Lally. Go ahead.
Thank you. Your Honor, may I approach?
Yes.
Your Honor, the multiple seeks introduced. Well, let me just on that. In those pages that I've just placed before you, do you recognize the content of those?
I do.
And what do you recognize those to?
They are text messages between myself and John.
And from sort of specifically that time period of the early morning of January 29th through the morning of January 29th?
Yes.
And what's contained in those, is that a fair and accurate portrayal of the content of those text communications?
Yes.
Now, with reference to Mr. O'Keefe, this is someone that you knew and you had his information put into your phone as far as a contact?
Yes.
And on prior occasions when you had contacted, or specifically that morning when you left the waterfall and you talked to him on the phone, you called him, and who answered? You called the contact that you had as John O'Keefe, correct?
Yes.
Okay, who answered the phone?
John.
Okay. And then the contact that you had put in as John O'Keefe called you, and you answered, and who was on the other line?
John.
Thank you. Your Honor, may I approach?
Yes.
I'll also seek to introduce and admit as an exhibit.
No objection, Your Honor.
Thank you. And this is subject to what we talked about in sidebar?
Yes.
Understood.
Thank you. That's Exhibit 89. All right, thank you.
Your Honor, with respect to what's now been marked as Exhibit 89, if I could, with the court's permission, publish that. Sure.
Yes.
Okay, what's up on the screen, is that what you have before you as that exhibit?
Yes.
And this is a text communication between yourself and Mr. O'Keefe, correct?
Correct.
Your Honor, I'm sorry to do this. May we approach for...
Sure. Why don't you take that down, Ms. Gilman? And thank you.
Welcome, ladies and gentlemen, brothers and sisters. Thank you for being with us today. It's going to be a very interesting day, a lot going on. We are here for all of the festivities. With all due respect, it could be an emotional day, depending on which side you're on and how this thing plays out, but we'll be here for you. Also recapping how we got to this point, going back through and analyzing some of the evidence, prior testimony. Feel free to join us in the chat. There's also a link in the chat if you'd like to join us on stream, live on the screen, and be involved in our verdict watch party. Pretty interesting, pretty cool. You can come and share the experience on screen with us. We invite you. Meanwhile, let's continue to go back through the testimony.
So, Ms. McKay, with what's for you and what's up on the screen is the exhibits. There are sort of green bubbles and blue bubbles, correct?
Correct.
And can you tell the jury as far as who's communicating which direction, as far as the green bubbles are who and the blue bubbles?
Green is John and blue is myself.
And so the first text from this particular date, if you could just read to the jury as far as from whom the message is sent, what the content is, and then what the time period is.
So John sent to me where to at 12:14.
And it assists you if you have that in front of you.
Oh, okay.
You can look at that and look at that. So the next bubble down is a blue bubble, is that correct?
Correct.
Similar to the one before, can you just read as far as that, well, before I get to that, I'm sorry. So you receive that message from Mr. O'Keefe, you call him, have a conversation, he calls you back for the conversation.
Correct.
And then subsequent to that, could you read the next blue bubble down as far as from whom, what the content is, and what time it was?
So this one is from myself to John, and it says here at 12:27. So at that point, I see a car out front, and I text him here.
You testified to as far as looking out the front storm door, seeing a car, and then you sent a text. That's the text.
Correct.
And Ms. Gilman, if you could scroll down to that. And ma'am, similar, if you could just, who sent it, what's the content, and what is the time?
I sent to John, pull behind me at 12:31.
And what were you referring to when you said hold on?
So at this point, the car had moved from the prior spot where I originally saw it. So I thought, what is he doing? Why don't they just pull behind me in the, in the driveway?
Can you scroll down? And again, with this bubble, if you could read out.
From me to John saying hello, and it was at 12:40.
And at this point in time, as far as, let me ask it this way. When you're sending these text messages over these periodic time periods, what, if anything, are you doing sort of in between?
So I originally went to the front door, saw the car, texted them, then texted John. Then I went back, kind of sat at the table, just either threw my phone probably in my back pocket. And then a couple minutes later, I got up again and saw that the car had moved. So I had sent the pull behind me. And then a few minutes later, I went back to the window, to the front door, I'm sorry.
And when you went back to the front door, what, if anything, did you see at that?
So at this specific point at 12:40, when I say hello, I cannot be certain whether they were still out front or if they had left.
And from any of these text messages that you sent, what, if any, response did you receive from Mr. O'Keefe after the where to?
None.
Ms. Gilman, if you could, to the next level. And similar to the prior one that you just read.
Sure. Jen to John, where are you? And that was at 12:42.
The next level.
Myself to John, hello, at 12:45.
Now, this is later in the morning, and we'll get to that a little bit more in a moment, but at some point you left the residence of Fairview, you went home, and you were awoken by something, and then at some point you texted John later on that morning, the 29th.
Yes.
You know, the next couple of those text messages that you sent at that point,
Correct.
if you could just, similar to the other ones we used.
Myself to John, please answer at 4:59. Myself to John, Karen is worried. We need to find you at 4:59. Myself to John, please answer so I know you're okay. 5:04.
May I approach this retrieve? Now, Ms. McCabe, if I can take you back to at the house on Fairview. Again, you're sending these text messages and going back to the table and then going back to the window at various times.
To the front door.
To the front door.
Yes.
And at any point in time, do you see anybody exit from the dark SUV or the black SUV you see in front of the house?
No.
And at any point in time, did John O'Keefe come into the house?
No.
And at any point in time, did John O'Keefe respond to your text messages?
No.
And at any point in time, did John O'Keefe call?
No.
Now, at some point Subsequent to this, have you had occasion to look at your phone or at your call history?
Yes.
And through review of that, were you able to see phone calls that your phone made to John O'Keefe's phone around that same time frame that you were texting him and going to his home?
Yes.
May I approach, Ron?
Yes.
And I'm showing you a 4-page document. Actually, look at it, look up when you finish, and if I could suggest. Yes, I think it starts in reverse order from page 4, timing-wise, up through page 1. Just generally speaking, ma'am, do you recognize what's contained in that 4-page document?
I do.
And what do you recognize?
the calls between myself and John O'Keefe.
And am I correct that it starts in sort of a ascending order as far as the earliest calls are on page 4 and then the most recent are on the first page?
Yes.
And the phone calls that you were testifying to about before, as far as talking to him on the way from the waterfall to the residence at Fairview, did they appear in those?
They do.
Objection, Your Honor. May we approach briefly?
Okay, may I have that?
Okay, again, thank you, brothers and sisters, ladies and gentlemen, for joining us. We appreciate that you're hanging out with us. What do you think is going to happen today? $1 million question. $1 million question. Will we get a verdict? And if we do, what will it be? Hard to say, huh? Hard to say. Quite possibly, we're looking at a hung jury today, ladies and gentlemen. You really have to continue to analyze the system of justice here and whether or not this is really justice when people have said that they've, done all they can do. They've exhausted, they've been diligent. We've sat here, we've gone through the evidence, we've conferred with each other, we've negotiated with each other. And we've come to a place where a unanimous decision just doesn't seem possible. And then we're told, no, it's not good enough. Go back in there and work it out, and so that's tough. And then you're not able to do it. Then you have to give up your weekend. It's on your mind. And we all know next week, 4th of July, a lot of people just, this is not what you want to be thinking about 4th of July week, and, the kids are out from school now and it's summertime, let's say, people are not trying to still be in this box when they already feel like they've done their civic duty. They sat there, they gave up their freedoms, quote unquote, and they've come to a place where, hey, brick wall. Now, we continue to ask, what does this mean for Karen and what does it mean for John's family? What does it mean for justice if we've come to a place and are not able to resolve, but we have to give an answer anyways? And, this needs to be discussed as far as the process itself, because if we get, let's say, a hung jury, or we get a not guilty straight out, or we have guilty to some of the lesser charges, how do you feel about it? Do you feel like, well, that's justice being served? Is that really how you feel? I mean, you're watching how this transpired, right? You're seeing how it developed. So is that going to be how you see this? Yeah, that's justice. Really? And then some time from now, and we, some jurors may break their silence and tell you, hey, these were the numbers at that point. When we sent the letter, when we sent the note to the judge, this is where we were. So you're celebrating the verdict post weekend, but where we really were, when you hear that, what do you think? And later on, we'll continue to discuss your thoughts on, if we do get a hung jury, do you think the Commonwealth will go at it again? There's a lot of time, there's a lot of money. Okay. And we're going to weigh these things. We really need to weigh, are we setting ourselves up to go through this all again? Now, the Commonwealth could say, hey, this is terrible PR for us. We don't want anything to do with this. We're not, just let it go. We're getting beyond it. We're moving on. The world is putting too much attention on us. It's affecting our economy. It's affecting, our way of life. It's best to just let this be. That's a way of thinking about it. However, you have a law enforcement officer who lost his life. And is that really the time for an unsolved crime? No. I'm saying that, no. And I'm not saying therefore it's Karen, but I'm certainly saying, do you really just want an unsolved murder? Let's use those quotes, murder, quote unquote, of a police officer? Is that really what we want to do? No, you can't do that either, right? So, I mean, it's a very touchy situation for the DA's office and how they're going to do it. And then you've got the Fed investigation, right? So you've got other people looking at this whole thing. So if we do get a hung jury, It's really going to be very interesting where we go from here. If Karen just walks and it's over, no one's, going to bring it back up from the Commonwealth side, or are we setting ourselves up for some more ceiling fan watching? What do you think? We'd like to hear from you. All right, we'll continue to go through some of the previous testimony and dig in here, see how we got to the place that we're in and the veracity of some of the witnesses. It's good to analyze some of this. All right, here we go.
Okay.
So, Ms. McCabe, as far as the first calls that you were testifying about, as far as when you spoke to Mr. O'Keefe on the way from the waterfall to the residence in Fairview, were those contained within those calls?
Yes.
As far as, is there a time that's associated with those calls that you observe in those 4 pages?
Yes.
And what are
12:14 and 12:18.
they? And turning your attention to page 1, that would be sort of the last in line there. What time is the last call between yourself and Mr. O'Keefe, and who's calling you?
I'm calling him at 5:25.
Okay. May I approach him?
Yes.
I'm all seek to introduce him as the next exhibit.
Is there any objection?
There's not, Your Honor. Thank you.
Exhibit 9901. Thank you.
Now, Ms. McCabe, you had mentioned that during the course of the evening, shortly after you arrived at the residence at Fairview, you observed a vehicle outside of your sister's house, correct?
Yes.
And Your Honor, with the court's permission, I would ask to publish with this witness Exhibits 71, 72, and 73.
Okay.
And Ms. McCabe, first and foremost, what's up on the screen is Exhibit 71. Do you recognize that?
I do.
Okay, I think you can just go right to what you want her to identify, please, Mr. Lally.
So, Ms. McCabe, in front of you on the desk, there should be a laser pointer. Just click on the button and point at the screen. And if I could ask if you could direct, well, first and foremost, with respect to this photograph, do you observe in this photograph where you first saw the black SUV in front of the house?
It was directly if I was staring out the front door. So this angle is kind of unique to see it. But if you go from the front door directly straight out, so maybe the edge, if you understand what I'm saying.
Using that just direct his attention.
So if there's the front door and I look straight out, but the perception is almost like a side view. It's not straight on, so it could have been a little over here.
So, Lally, why don't you show another picture if this one isn't helpful?
It's going to flag that Exhibit 7. Is it visible in this photograph?
Yes, so it'd just be follow this and then come straight.
And lastly, Exhibit 73. Now, Mr. Cady testified that at another point you come to the front door and you observe the vehicle in a different spot, correct?
Correct.
If you could, again, using the laser pointer, just direct your attention to where in this photograph, if at all, you observe where the vehicle was a second.
It was right about, right near the flagpole.
Okay. Just come in, you can take that. Now, turning your attention to back in the home, at some point you indicated you looked out and didn't see the black SUV there anymore.
Correct.
And what was your thought as far as where John was or where John had gone at that point?
At that point, I thought maybe they decided not to come in. Maybe they got into an argument, or maybe Kaylee had called.
Did you think much of it at that point?
No.
Now, you leave the home around what time?
approximately 1:30, roughly 1:30, 1:45.
And when you leave, who, if anyone, goes with you?
So it's myself, my husband Matt, and I had offered, when Julie Nagel's brother had come to the house earlier, I had offered Julie and Sarah Levinson a ride home because we had just gotten there and they had wanted to stay later. So I also drove home Julie and Sarah. Well, my husband drove them home.
And so you exit the house, go out to the vehicle, correct?
Correct.
And your husband Matt was driving?
Yes.
And where are you seated in the car?
And the front seat.
And do you recall where Ms. Levinson and Ms. Nagel were seated in the car?
They were in the back seat.
Do you recall which one was on which side?
I do not.
And when you come out of the house and you're starting to go home, what, if anything, had changed as far as the weather from when you had gone in to when you had come out?
The snow had, accumulated more.
And when you get into the vehicle and as the vehicle is pulling away, what, if any, conversation do you recall having with anyone in the car?
When I got in the car, I kind of turned around to Julie.
I'm going to allow this subject to move in strength. There's a portion that's relevant. Go ahead.
I turned around and was facing them and talking to them. And I believe Sarah Levinson had laughed or made a joke because I had bread or something in my car. And we made a joke about that. I had had my niece earlier that week for the week. And so I had brought stuff in the car because I was dragging her from one of my kids' sporting events to the next.
And as, do you recall which direction, or did you observe which direction your husband Matt exited from the residence in Fairview? And by that I mean, did he head towards Chapman or did he head towards Cedar Crest?
Chapman.
And so as far as, I may not have asked this before, but as far as the black SUV that you observed in front of the house, which direction was that vehicle facing?
Chapman.
Each of the times that you saw it?
Yes.
And so as with that vehicle, as with the one that your husband was driving, which side of the vehicle would have been closest to the house in Fairview?
Passenger.
Now, as you're driving past the house, heading to the house, how were you positioned within the car?
I'm turned chatting to the girls.
So, and when you're turned, are you turned towards the window or are you turned towards the console? Which way are you turned?
Turn the console towards the back seat. So my back is to the window.
And either of these girls, did you know where they lived?
No.
Do you recall whether or not you found their homes by way of sort of yes, or was it just sort of verbal directions?
I'm assuming they just gave Matt directions to where they lived.
And so you drop each of them off. Do you recall which order they were dropped off in?
Julie, then Sarah.
And then following dropping off Sarah, where did you and your husband go?
What do you think of her style of testimony? Do you find her credible? Do you find her credible? You know, we have seen several different styles of witness, and those that are very, very plain spoken. We've seen the expert witnesses. She's doing something a little, it's kind of a hybrid, right? And she seems to have an amazing recall of certain details, where we've seen countless times. I mean, even in other trials where the details that she's recalling and testifying to, we've seen many times where that was I don't know. I can't recall. It's been a long time, I just don't remember it. But there are several things that this witness, she knows. Jennifer, or at least she's testifying to. Jennifer saying, yes, this is who was in the car, and even where people were looking. I mean, that's different, right? Where a person was looking at the time. That's a different thing, exactly where this happened at, exactly what people were doing at the time. It's just interesting. So do you find that more interesting than the other styles of, do you find it more credible than the other styles of testimony? It's an interesting thought. Let us know.
Home.
And this whole trip sort of from Fairview to dropping off Miss Nagel, Miss Levinson, and then going home, about how long a period of time did that take?
It could be 20, 30 minutes, maybe about approximately 20 minutes. I'm not exactly sure.
You arrived home sometime after 2 a.m., is that correct?
Yes.
And when you and your husband Matt got home, went inside the house, and where did you go?
I went upstairs to bed.
And at some point, did your husband come up as well?
He did.
Was it a long period of time between when you arrived home and when your husband came up?
I don't think too long. I think he had like some cheese or something because he was on a crazy diet, and then he came upstairs.
Now, did you go right to sleep, or what, if anything, did you do when you went up to bed?
I asked him to watch a show. He said no, he was going to fall asleep, which he does usually immediately, and I went on my phone.
And what, if anything, do you recall doing on your phone as far as going on?
I was researching, my husband and I did briefly talk. My daughter had gotten an offer to play on a club
Just tell us what you were doing, please.
Sure. I was researching a basketball team, and I believe I also texted my sisters, and I texted in a group chat with my husband and another individual.
Now, if I could just turn your attention back to when you were at the house on Fairview that evening, and I believe this is the last time, so I apologize for the back and forth, but when you were there, what, if any, videos or any music or anything did you pull up on your phone to share with the group that you were there?
So one of my sisters loves this song "Raining Men," and she always, well, not always, maybe every once in a while, she has a little too much to drink and takes out an umbrella and sings and dances, and it's like a big family joke. And my other nephew had previously been over and showed me the video from whenever, I don't know if it's the 1970s, of It's Raining Men. So I just was playing it, showing my other nieces and nephews, and we were just like laughing because they all have umbrellas, and it's just something, it's like an inside family joke. So I played that, I think, a couple of times.
And so after you get home and you're looking at the basketball program and things of that nature, what, if anything, else did you do before you slept? Or went to sleep, I should say?
Nothing. I possibly could have gotten up to go to the bathroom. I do that almost every night.
Now, at this time you had an iPhone, is that correct?
Yes,
Did you also have an Apple Watch?
I did, yes.
And do you recall whether or not you were wearing the Apple Watch that evening or when you went to bed or anything like that?
I do not recall.
And as far as the Apple Watch is concerned, is that something that you routinely or always take off before you go to bed?
Mostly, but not always. I mean, there are times I go to bed with it on. More often than not, I take it off, but there are times that I do sleep with it.
And with respect to this particular evening, do you recall whether you had it on or whether you took it off or even had it on at all that night?
I don't recall if I had it on that night.
Now, turning back to that last exhibit as far as the phone calls were concerned, were there certain phone calls that you made to Mr. O'Keefe's phone around the time that you were observing the vehicle outside?
Yes,
Do you recall making any phone calls to Mr. O'Keefe at that time?
I don't.
Fair to say that at no point while you saw the vehicle outside did you have any conversation with Mr. O'Keefe?
I didn't.
Now, you go to sleep, and at some point later on in the morning, you wake up, correct?
Correct.
And what is it that wakes you up, and when about was that?
I am woken up to my phone ringing.
And do you know what time it was?
4:53.
And according to your phone, who was calling you at 4:53 a.m.?
John's niece.
And And so that would be John's niece, Kaylee, is that correct?
Correct.
And how old was she at the time?
I believe she was 14.
And she had just gotten into Bishop Thean, correct?
Correct.
So she was in 8th grade going in, finishing up her 8th grade year of middle school, correct?
Yes.
Is that a normal thing, that Kaylee would be calling you at 4:53 in the morning on a Saturday?
No.
So you answer the call, is that correct?
Yes.
When you answer the call, who, if anyone, is initially on the other end?
Initially, it's Kaylee.
And what, if anything, did Kaylee say to you?
That John didn't come home and Karen and we wanted to talk to me.
And even in that initial call, when you're speaking to Kaylee, what, if anything, do you hear sort of in the background when you're talking?
Karen screaming.
And could you hear what she was screaming?
She was just screaming, Jen, Jen, Jen,
Fairly loudly, is that correct?
extremely.
Now, at some point, does the defendant get on the phone with you?
She does.
And what, if any, conversation do you have with her at that?
She proceeds to scream my name multiple times, and she tells me that John didn't come home, they got into a fight, and that she left him at the waterfall.
And how do you respond to that?
I had just woken up. I was confused. I didn't know what she was talking about. I was like, what are you talking about? And then she, told me that they had gotten into a fight and she left him there and now where is he? And she was just kept screaming my name over and over. And so then I remembered that Chris Albert had still been at the bar. So I thought, well, maybe John walked home with Chris because Chris lives close to the waterfall.
And so, at some point, that conversation ended, and you recall how that ended?
I told her that I was going to call Julie and see if John had ended up with Chris.
And so, you hang up with her, and then what did you do then?
I called Julie Albert.
And did Julie pick up the phone?
She did not.
And as you were calling Julie, did you have any conversation with your husband, Matt, around that time?
Yes. He, had kind of shot up out of bed when Karen had called. When Kaylee had called because Karen was screaming. And then he was,
Yeah, she certainly has a lot of details. Jennifer had a lot of details. Does that go well with you? Do you think that her ability to recall the intricacies of the night, who did what, how they did it, when they did it, again, it's just very rare from what we've been watching that people would have that much detail that they can testify to. It's just rare. People do it. Don't get me wrong. There are those who do. There are those who are very well prepped, right? They're very prepared. They've had a chance to rehearse, and they've been given that chance by their side, whether, defense or the prosecution, it's your witness. It's different once they have actually taken the stand, once they are actually testifying. But, you can prepare your witness. You can show documents and you can go over, how you intend to approach the information, how you intend to go through the documents, etc. So, she clearly has something going where she's able to give a lot of detail. So how do you think that played with the jury? Does that strengthen at times like this when they're trying to bring it all back and they're trying to maybe parse through or trying to convince someone, or someone's on the fence and the other person is, not wanting to change their view even after the weekend, right? Even after the judge sent them back, they, what resonates? What do you recall? Oh yeah, that Jennifer, she was pretty sure though. She was pretty sure. Is it just a feeling that lingers as days go on and you're trying to deliberate? What's left? the aftertaste, right? So much subjectivity. So much. What do you think?
What's going on? And I said, well, I'm calling Julie because Karen, they got into a fight, and I was trying to explain it to him. And he said, what are you talking about? We saw them outside of your sister's house. And at that point, I hung up.
And when you hung up, Julie had not answered yet, is that correct?
Correct.
Now, as far as Miss Reed is that someone who had your phone number? Did you have her plugged into your phone as a contact before that date of January 29th?
No.
So never had any kind of conversation with her over the phone as far as a text or a phone call or anything. You didn't even have her information.
Correct.
And so after hanging up while calling Julie, what, if anything, did you do then?
And then I'm not sure if I called Kaylee back or if Kaylee called me back.
But at some point you get back in touch with Kaylee, or at least her phone, correct?
Yes, I get in touch with Karen again, and I say, Karen, we saw you outside of my sister's.
And what was her response to that?
She told me that she didn't remember going there, and then she started yelling, Jen, Jen, and then she was saying, did I hit him? Could I have hit him? And then she proceeded to say that she had a cracked taillight.
And this is while you're still in your home.
Are you buying that? Are you buying that? Because if you are, then, right? I mean, if you're accepting that, then, I mean, you can see. So again, this is why, it's helpful to go back through this, because, you can see, say, well, how in the world could anyone feel that Karen, was guilty? How is that even remotely possible that anybody in their right mind, this deliberation should have taken 5 seconds? There's no way, right? But think about what I'm saying to you. I mean, we're still dealing with just human frailty, right? I mean, just dealing with the subjectivity. People have, their own way, their own style, and, how they process information, what they believe is credible or not. And if she is coming across to you as credible, the way she recalls versus the I don't know, I don't remember, well, I don't, okay? So if you put up 5 witnesses on the other side that are doing a whole lot of, I just don't remember, for instance, right? And then you get someone who seems sure, right? And even animated, Jen, I mean, who puts all that into their testimony. Now, to some people, it may just be a total put off, right? I mean, you're just very offended, you just can't stand her. Think about what that means. That means she's resonating. She just irks me, that Jen McKay, see? So she's touching a chord. That's what you gotta be careful of if you're on, which side are you on? On one side, you say, well, wow, I just can't stand. On the other side, it's like, I believe in her. There's something about her and the way she testifies. I believe her testimony. Why would she lie? She's confident. She knows what happened. She wouldn't lie about this. I accept her explanations for things. I like her style. I like the way she presented the information. And if you do believe that, then let's back up a second, right? Because if you do believe that, then there's certain other things of, how are you going to get to not guilty? If you do believe her, how do you get to not guilty when she's saying what she's saying?
You wake up, correct?
Correct.
And what is it that wakes you up, and when about was that?
I am woken up to my phone ringing.
And do you know what time it was?
4:53.
And according to your phone, who was calling you at 4:53?
John's niece.
And so that would be John's niece, Kaylee, is that correct?
Correct.
And how old was she at this time?
I believe she was 14.
And she had just gotten into the Shafian, correct?
Correct.
So she was in 8th grade going in, finishing up her 8th grade year of middle school, correct?
Yes.
Is that a normal thing, that Kaylee would be calling you at 4:53 in the morning on a Saturday?
No.
So you answer the call, is that correct?
Yes.
When you answer the call, who, if anyone, is initially on the other end?
Initially, it's Kaylee.
And what, if anything, did Kaylee say to you?
That John didn't come home and Karen and we wanted to talk to me.
And even in that initial call, when you're speaking to Kaylee, what, if anything, do you hear sort of in the background when you're talking?
Karen screaming.
And could you hear what she was screaming?
She was just screaming, Jen, Jen, Jen,
Fairly loudly, is that correct?
extremely.
Now, at some point, does the defendant get on the phone with you?
She does.
And what, if any, conversation do you have with her at that point?
She proceeds to scream my name multiple times, and she tells me that John didn't come home, they got into a fight, and that she left him at the waterfall.
How do you get to not guilty if you believe Jen? If you believe Sister McCabe, how do you get to not guilty? And again, I'm exposing just the thought of it all for people who, they just can't get over they just can't see it, right? Well, that's a problem, because it is a skill to be able to walk a few miles in someone else's shoes, right? It is a skill to be able to do that. So, we're talking about a skill set here where you set aside your emotion for a second or two, and you can begin to appreciate the complexities and the subjectivity of having a jury of your peers. You can appreciate, right, that this thing, yes, you can get to a hung jury. Yes, you can get to a guilty verdict. The same way you sink your teeth into certain pieces of information that you believe that, whichever side you're on, right? Whatever side you're on. The same way you say, well, hey, because of this, I know this happened. I know that happened. And then you can tune out the rest of it. Like, it doesn't matter what else. It doesn't matter what else they say. I believe A, B, and C. So it doesn't matter what else is said. You just tune it out. Be careful with that, right? Be careful with it. Say, it doesn't matter. Just tune it out. Because if a person did that same thing with Sister McCabe, where do they end up? Where do they end up? And how are you going to convince them otherwise? She knows times. She has the names. She has the ages. And then she's going to just lie about the rest of it. They had a fight. Jen. I mean, she's right there with it. And if you believe that she's credible, who's going to change your mind?
And how do you respond?
I had just woken up. I was confused. I didn't know what she was talking about. I was like, what are you talking about? And then she, told me that they had gotten into a fight and she left him there. And now where is he? And she was just kept screaming my name over and over. And so then I remembered that Chris Albert had still been at the bar. So I thought, well, maybe John walked home with Chris because Chris lives close to the waterfall.
And so at some point that conversation ended and you recall how that ended?
I told her that I was going to call Julie and see if John had ended up with Chris.
And so you hang up with her, and then what did you do then?
I called Julie Albert.
And did Julie pick up the phone?
She did not.
And as you were calling Julie, did you have any conversation with your husband, Matt, around that time?
Yes. He, had kind of shot up out of bed when Karen had called. When Kaylee had called because Karen was screaming. And then he was, what's going on? And I said, well, I'm calling Julie because Karen, they got into a fight, and I was trying to explain it to him, and he said, what are you talking about? We saw them outside of your sister's house. And at that point, I hung up.
And when you hung up, Julie had not answered yet, is that correct?
Correct.
Now, as far as Miss Reed is that someone who had your phone number? Did you have her plugged into your phone as a contact before that date of January 29th?
No.
So never had any kind of conversation with her over the phone as far as a text or a phone call or anything? You didn't even have her information?
Correct.
And so after hanging up while calling Julie, what, if anything, did you do then?
And then I'm not sure if I called Kaylee back or if Kaylee called me back.
But at some point, you get back in touch with Kaylee, or at least her phone, correct?
Yes, I get in touch with Karen again, and I say, Karen, we saw you outside of my sister's.
And what was her response to that?
She told me that she didn't remember going there, and then she started yelling, Jen, Jen. And then she was saying, did I hit him? Could I have hit him? And then she proceeded to say that she had a cracked taillight.
And this is while you're still in your home and you're in your bedroom, correct?
Correct.
And what was your response to that?
I thought she was honestly like just talking crazy. And then she said, oh my God, I left him there. Like, she was extremely irrational. She said that it told me again that they had gotten into a fight. So now she was just kind of all over the place, just screaming. She was very hard to understand. So my brain started going, okay, well, if she left him there, where could he be? Who could he be with?
And as you're going through that sort of process, what did you do next?
So then earlier in the night, there was another individual who we had been in contact with, or my husband had been talking to, and he had mentioned that he was gonna meet up with John at Waterfall as well, but he never ended up coming. I knew he was at a house close to Fairview, so I thought, well, maybe if they got into a fight, like John might have texted this individual, and maybe he just ended up on his couch.
Who was that individual?
Tom Beatty.
And who is Tom Beatty in relation to, how did you know him?
He has 2 daughters that are the same age as my daughters.
One of those daughters, at least around the same age as Kaylee?
Yes.
And so, based on sort of that process, thought process and what you're doing, what did you do then?
So then I start calling Tom.
And at any point in time that you call Tom, did Tom pick up the phone? Did you speak?
He did not.
And so, following that, what did you do from there?
So I know at some point I was starting to call John. My husband was as well. At that point, I get up and I'm like, okay, well, we got to go out and look for him. And in my head, I was thinking I'll drive over to Tom's and maybe he's there. I then go downstairs. Matt gets up. He's starting to get dressed. I go downstairs. I make a coffee. And I'm not sure how much time passed. But then all of a sudden I hear screaming out front.
Now, if I could just take you back for a second, as far as a decade or so that you had known and been friends with John O'Keefe, with his either his niece or his nephew or both home, is him not coming home, is that something that had ever happened before, you were ever aware of before?
I was never.
Ask it differently.
Had John ever gone out at night and then not come home when the kids were home?
Objection.
I'm gonna allow it.
Not to my knowledge, no.
So at some point you make your way downstairs, is that right?
Correct.
And then what, if anything, did you hear once you were downstairs?
Screaming
And where was the screaming coming from?
out front.
And when you heard that screaming, where did you go?
I ran to my front door.
At some point, did you open your front door?
I opened my front door, correct.
And then what did you see when you opened the front door?
Miss Reed came running up my walkway.
And prior to, during any of the other conversations that you had had with Miss Reed, did you know where she was when you were talking to her?
No.
What do you think of the Miss Reed versus Karen? You know, how she uses that Miss Reed, talking about Sister Jen McCabe here, right? How does that play to you? Miss Reed came running up my, right? I mean, Miss Reed. How's that play to you from her?
Obviously, the first call was Kaylee calling from the house. That was
Yes.
the assumption.
Mm-hmm.
And then
So
subsequent.
is that a yes or no?
Yes.
And as far as the second call that you were talking about, do you know where she was when she was talking to you then?
The first couple calls, I know she was at the house, and then I don't know.
So was opening your door, hearing the screaming from out front, was that something that surprised you?
Yes.
And when you hear the screaming, if you could just explain to the jury, how loud was the screaming that you were hearing?
Very loud.
And what, if anything, was she saying at this point?
It was more of the, Jen, did I hit him? And then she would yell, did I hit him? Could I have hit him? And then she was yelling, we have to go to Fairview.
And in addition to Miss Reed, what, if anything, else did you see when you opened up the door?
Just,
Ask in a better way.
Yeah.
Did you see a vehicle?
Interesting place. We're going to take a quick pause. We're going to check in with our moderator here. There is a document from 2009, and the Commonwealth may have updated certain of their policies and procedures, but we want to add some value here and give you some details as to what is going on with this hung jury and possible instructions that the judge will issue and what that means, right? So there, you know, obviously this is, as they say, this is a land of law, not people, right? So supposedly, you know, this stuff has all been mapped out and we robotically have to just follow certain things, presumably. So there's actually an order to how this hung jury possibility can play out, what the judge can listen for from the jury, what she can instruct them, how she can instruct them. It's not just totally on her own. There is some subjectivity, as we're going to cover, and you're going to hear it. You know, there's she has some discretion, but if she hears certain terms or she validates certain things, then the clock starts to tick. And that's going to be very interesting if we are pushing towards the possibility of a hung jury. Now, again, you know, I mean, we could get guilty, not guilty. I mean, you know, straight up and down, we could get that. But the jurors clearly let us know last week on Friday that wasn't their natural inclination. On their own, that's not what happened. So if the judge is going to push towards getting guilty or not guilty, then, you know, if she continues to push, there's a way in which she has to, according to the law, there's a way in which there are parameters to how she can push. So we'll go through some of that for value for those of you that are hanging with us on the channel, and it'll be good for all of us to up our curve here. So we're going to bring on our moderator, and also let's take a moment and let's see if we can also that way you can see the document as well as go through it. You're welcome. That's so cool. All right, so this is what we'll do. We'll bring in our moderator and she'll walk us through some of the document here. All right. Okay, Ms. Moderator, take it away, please.
Good morning. So my understanding is that once the judge decides to read this to the jurors, she can only send them back twice. So this is what they will hear. When jurors cannot agree, Our Constitution and laws provide that in a criminal case, the principal way for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking, in all cases, absolute certainty cannot be attained or expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusion of the other jurors. Still, in order to bring 6 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that the case be decided. You should consider that you have been selected in the same manner and from the same source as any future jury would be. There's no reason to suppose that the case will ever be submitted to 6 persons, or 12, who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced on one side or the other. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on one side or the other. In this criminal case, the burden of proof is on the Commonwealth to establish every part of it, every essential element beyond a reasonable doubt. If you are left in doubt as to any essential element, the defendant is entitled to the benefit of that doubt and must be acquitted. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is no disagreement, those jurors who are for acquittal should consider whether a doubt in their own minds is a reasonable one, if it makes no impression on the minds of the other jurors who are equally honest, equally intelligent, and who have heard the same evidence with the same attention, with an equal desire to arrive at the truth, and who have taken the same oath as jurors. On the other hand, those jurors who are for conviction ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment, if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or adequacy of the evidence if it has failed to convince the minds of their fellow jurors. I would ask you now to return to your deliberations with these thoughts in mind. And then there are some alternate instructions available that the judge can use, and those read: the verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree to that verdict. Your verdict must therefore be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement, if you can do so without violating your individual judgment and conscience. Each of you must decide the case for yourself, but you should do so only after considering the evidence impartially with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if you become convinced that it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors, or
pause
with
you
a
right
mere...
there. Let me pause you right there. That's good. That's good. Thank you. I'll just hold on for a moment. So this right here, let's dig in a little bit. Let's rehash that last bit. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if you become convinced that it is erroneous. Okay, I mean that's That's what we talk about just in general. Well, you're being sent back, and have an open mind. If you are of one persuasion, make sure you're listening to the other side, and feel free to change your mind. Feel free. Okay, now that's that. But then hopefully you keep listening. Hopefully, again, this is justice and the subjectivity of having human beings deciding the fate of other human beings. Did you stop listening right there? Because there's another sentence that qualifies, that entirely could change what you just were thinking. So the judge is going to let you know in this alternative jury instruction, hey, you have a chance here. It's okay. Feel free. You're not breaking any of your rights, roles, and responsibilities, right? I mean, you're still a great member of the Commonwealth. It's okay if you find someone else to be reasonable. It's okay to change but keep listening. Next sentence. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors, or for the mere purpose of returning a verdict. So I want you to go back there. I want you to get a verdict. But, see, the but, those buts will get you. Those buts will get you. So I hope you're hearing that. And we hope that the jury is hearing that, right? I mean, because if the jury is digging into this and they see and they hear and they say, okay, well, I get it. All right. We can think about this again. It's okay for us to, parse, and it's okay for us to negotiate. It's okay for us to debate. It's okay for me to even change my mind. It's all right. The law says it's all right that on Friday I thought one thing and on Monday I think something else. Cool. Law's giving me that. So I get to go home. Y'all are reasonable. It's reasonable. You're reasonable people. No reason to think that anybody else is going to be more reasonable than me, than you, than anybody. Okay. There's no reason to think the evidence is going to come in any better than it already is. Okay, great. We're good. I'm out of here. See ya. Oh. But, see, I still have to have that moral conviction, right? I still have to be convinced, and I still cannot, according to this, do not surrender your honest conviction. Don't do it. It's almost a code of life in there, isn't it? I mean, we like to do that on this channel anyways, right? I mean, there's almost a way of living that this speaks to for those of us who want to live by a code, right? Do not surrender your honest conviction as to the weight or effect of the evidence. So if there's evidence, if there's truth, if there's something out there that is the truth, okay? Now this is just, something for your worldview. How do you live? What do you base your life on? What are the foundations that move and groove within your soul? Because when you have that truth, like let's say, I believe in God, right? So let's just say, you have that truth. Then this is something that you can, attach as a code part of your life, right? You can listen to others and you can try to hear the reasonableness, but do not surrender your honest conviction. And hopefully you based it on what? The weight and the effect of the evidence. It didn't say your emotion, or else I wouldn't call this a key for life, right? I wouldn't call this something to use. It didn't say, because you just felt a certain way, hang on to your conviction. Don't let nobody control you. Don't let nobody tell you different because you feel a certain way. That ain't what I said. That's got the world going crazy. That's certainly not what I said. That's you being petty and someone else manipulating your mind. I'm talking about people that want to be based on truth. See, I'm not even talking to you right now. I'm talking to other people. Brothers and sisters, I'm talking a whole different thing, right? When I say this is something you can use, if you have the ability and you spend the time and you are carving out your understanding of that which is true. And if you have that and you are in the pursuit of that and you come across things that may seem reasonable in your deliberations, you can re-examine, and you ought to re-examine. You ought to be ready to give an account of yourself because you have examined yourself and because you are studying, right? The Bible says, study to show thyself approved, a workman who need not be what? Rightly dividing what? The word what? So you know what you have. And it's based on what you believe and know to be because you've examined, you deliberated, it is the truth, let's say. All right, then don't surrender that as to the weight or effect of the evidence solely because of the opinion of your fellow co-worker, your fellow family member, plug in the blank, your neighbor, your political party. And don't do it just to get along. You see, don't do it just to, hey, well, okay, I'll just make the peace. We'll all just get along. See? For he to have an ear to hear, or she to have an ear to hear, let him hear. I'm giving you something here. So there's something inside of that for you in your life if you are a person of conviction. You may still, what's the first part? The course of your deliberation, the course of how you go through life, the course of how you examine the world, the course of how you interact with others. It's okay. You can examine. You can listen. We don't have to be of the persuasion like, this is what I think, so therefore I'm not even going to listen to anyone. I could care less what anyone. I don't even want to hear your side because you might be wrong. But let it be based on the truth. You may have misunderstood the truth. It's possible, right? But don't do it for the mere purpose of returning a verdict. Don't do it for the mere purpose of just getting along so we can go home, so we can get on with this. I don't want to argue anymore. You see the life lessons I'm giving you here? I'm just, there's other things I want to deal with. I don't want to deal with that anymore. I just can't do this anymore. How many movies have they made like that? And you knew her line was coming. I just can't do this anymore. We need to talk. I just can't do this anymore. That comes out of a different thing. And maybe we'll talk about that more and more on this channel. But why do those lines get said so much? Why does that work in so many sitcoms, so many movies? Why does it work? Because it's the opposite of this. And you have opposing teams in this world. I'm helping you here if you can hear me. If you can hear me, I'm helping you. Now, those of you that are stuck there, we need to talk. I can't do this anymore. For those of you that are stuck there, then they won. They got you. That was a plot. See? They got you. You don't even realize that though, right? It's part of the matrix. People do things for a reason. I don't make a TV show because I don't want people to watch. I need to sell this commercial space, right? I made the TV show to touch certain things in you that I know I've already programmed in you to keep you engaged so that I can sell you some toothpaste. Because you're not going to do this. You're not going to weigh it, and you're not going to hold to what you believe. You're going to be swayed by what I've taught. That's why I can have a movie with the part 95, right? Grandma used to watch that cartoon, and we're still making the movie today. Why? Because the programming, it's so deep. I'm not going to spend $150 million on a movie guessing. I'm going to go with what's already been proven to work on you, whoever the you might be. Those that can be what? Easily swayed. They will surrender their honest conviction. They may not even have one, based on truth to begin with. And then on this channel, we take it to the next level and we say, where did you get these people from? The jury pool is made up of the same people. That's who the jury pool is made of. These same people, your fellow citizens. That's who comprises the jury. So what do we expect then? Should we really expect people to be following this if they don't have a history of that in their life? They don't live this way anyway. War dear, we have a process here. Let us not forget there's a process. These people didn't just get on the jury. There were people who showed up for jury duty who were disqualified. Don't forget, the people we're looking at, well, we're not saying their faces, but the people we're waiting on, there were others that could have been sitting there. Some have left anyway, but these are the ones, once you've weeded out other ones, you can't weed out everybody. Think about that too. So there are people here on this jury that one side, they like them over other people. They could have sent juror number 3, let's say, I'm just throwing out a number. They could have sent juror number 3 home. They didn't. They sent the other one home instead. There's something they liked about this one. What is it that they liked about them? Maybe they liked that they knew they were the type of person who would connect with Jen McCabe. See how deep that is? I know what Jen McCabe is going to say, and I'm going to make sure I've got people on this jury that connect with her. And once they've connected with her, boy, hot knife through butter. All right. Hope you got something from that. Okay, Miss Moderator, let's continue.
All right. We'll start with that over there. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if you become convinced that it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. You are not partisans for one side or the other. You are judges, the judges of the facts. Your sole interest is to ascertain the truth from the evidence in the case. I would ask you now to return to your deliberations with these thoughts in mind.
Hold on for a moment, please. Hold on. Thank you, Miss Moderator. It's interesting. This is just not a little life lesson. Remember when we were going back and forth in school, or, people who you wanted to try to convince of something in life, and, you're not supposed to judge. You're not supposed to judge. I mean, they were so confident in that. Where did you get that from? You're not supposed to judge. Are you hearing me or not? So there's an instruction here from the Commonwealth, 2009, right? You are judges, the judges of the facts. You're not a judge. You're not supposed to be judging. You shouldn't be judging. To evaluate. Judge everything, brothers and sisters, ladies and gentlemen. Yes, you are, and you ought to be judging. That's what you should be doing. You should be evaluating. But that's that same thread I was trying to tell you about earlier. Did you catch it? Don't be judging. You're not supposed to be judging. But then you get in this environment and you're told, no, you are a judge. Well, how can I be a judge when I've spent most of my life thinking that's something I shouldn't do? Huh? Did you hear that? Did you hear that? Where's my practice in that? It's almost like if you take a person and has never seen a healthy marriage. They've never been apart. They haven't even been around people that have a good marriage. And you say, why aren't you a good wife? Why aren't you a good husband? They have no frame of reference. So since I've been 13 years old, I've been telling people they shouldn't judge. Stop judging, stop judging, stop judging. And now all of a sudden, somebody's life is in the balance. Their freedom's in the balance. There's a family that wants answers and justice, right? Millions of people watching. And now all of a sudden you're going to tell me I'm now, let's say 45 years old, which I'm not, but let's say I'm 45 years old. And since I've been 13, I've been saying, don't judge, don't judge, don't judge. And now at 45 in a murder trial with the world watching, somebody tells me you are a judge. The law says, no, you are. Well, wait a minute. I thought that was something wrong. I'm not supposed to do that. I'm not supposed to be a judge. I'm not supposed to judge. See how twisted this stuff is? But when you get down to the nitty gritty, when it's not just selling you toothpaste, when it's not just selling you a new car, when you get down to the nitty gritty, you get back to the truth. And when you get to the truth, you start to hear certain principles that you've been taught are bad. Oh, but now that I get to the real deal, you have to operate based on what? Solid principles. So then they have to tell you. See? And this is not even what I tell you initially. See, this is what I'm going to tell you when there's a problem such as right now. And I need to separate the wisdom from the foolishness, truth from falsehood. Now I've got to go ahead and tell you part of the other matrix. Now I have to go ahead and expose to you how you should be living your life to begin with. Otherwise, we're going to be here forever because there are too many opinions. There's too much going on. Now, if y'all can just get there by yourself, then I don't have to tell you these other secrets of life. I don't have to worry about messing up my toothpaste cells. I don't have to do that. But when the rubber meets the road and we need to, really make things happen, there's going to be some separation. If it's the military and it's wartime, all that other stuff starts to, look real suspect when the bullets are flying. All right. When the bullets are flying, all those little emotions or the way you see it or what you feel about it. No, the unit has to get from that building to that building. And everybody's got to play their part right here, right now. Precision. I hope you've practiced that. Hope you spent some time practicing that. And know how to hold to your convictions, know how to evaluate the terrain, know how to keep each other safe, know how to follow instructions. Otherwise, if this is all new to you, you are not partisans for one side or the other. You are not partisans. That's really great for this political climate that we're in right now, right? When you're trying to get to the truth, when you're really trying to be of value to the universe, you are not partisans for one side or the other. You're the judges of what? Facts. Supposedly you're standing on the truth. That's supposedly. So forget about if your Democrats are wrong, they're just wrong. In other words, right? You can't just stay on your side because it's your side. If your side is wrong, then your side is wrong. Why? Because you're a judge. You're a judge of what? The facts. What are the facts? The truth. We hope. We hope, right? It is your sole interest, right? Is to ascertain the what? The truth from what? The evidence in the case. I don't know who wrote this, but I can hear it. And I'm trying to share it with you so you can hear it. Your sole interest is to ascertain the truth from the evidence. The truth from the evidence. The truth from the evidence. So you can have evidence, doesn't mean you have the truth. So that's where your skill as a judge would come in. So if you hadn't been saying that since you were 13 years old, I'm not a judge, I'm not a judge, I'm not a judge, and you actually had, in my other example, you had actually seen healthy relationships throughout your life, you can employ those skills so that you can actually hear the truth from the evidence. You can take the evidence and get to the truth because you've honed those skills as to how to get to truth, how to take facts as evidence and then get to the truth from there. You see? Those are skills. That's wisdom. That's something that you should be practicing. That's a way of life. That's how you should be living your life. So that in these moments, you know what this means. You can hear that. But for those that don't have that as a way of life, this is going to be, a foreign language. And what does that mean for justice then? If this is a foreign language, what does it mean for justice? Let's know what you think. You're doing great, Miss Moderator. Let's continue, please.
You are not partisans for one side or the other. You are judges, the judges of the facts. Your sole interest is to ascertain the truth from the evidence in this case. I would ask you now to return to your deliberations with these thoughts in mind. And there are some restrictions. Should we take a look at those?
Yes, we can add some more value to the listeners.
All righty. Restrictions on sending out jury more than twice. If a jury, after due and thorough deliberation, return to court without having agreed on a verdict, the court may state anew the evidence or any part thereof, explain to them anew the law applicable to the case, and send them out for further deliberation. But if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent, unless they ask from the court some further explanation of the law. And then the pre-Tui Rodriguez charge. When the jury prematurely suggests that it may be at an impasse, but the judge...
Hold on. Let's you're doing good. Let's back up a second. Read that first restriction. Read that first part again, please.
Restriction on sending out jury more than twice. If a jury, after due and thorough deliberation, return to court without having agreed on a verdict, the court may state anew the evidence or any part thereof, explain to them anew the law applicable to the case, and send them out for further deliberation. But if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent, unless they ask from the court some further explanation of the law.
Yeah, good. Thank you. So what I was seeing there in that is that first part is still where the judge, okay, this is my understanding here. This is still where the judge has an opportunity to have this go on and on and on, because after due and thorough deliberation, they return without having agreed on a verdict. So what I'm showing us here is that that's where the judge comes in. So if somebody says, well, wait a minute, I've seen them get sent back 6 times. What do you mean they can't be sent back? And here's why, and here's how. That's why the judge says, I have not found, that's why she used that phrasing. She said, I have not found that there's been due and thorough deliberation. So the clock hasn't started yet, ladies and gentlemen, brothers and sisters. The 2 times that we're speaking of haven't started yet because she has not found. So if she finds that there's been due and thorough deliberation and she utters those words, now we're into a different ball game. That's a key point, ladies and gentlemen, brothers and sisters. That's a key point. So when people talk about she can only do it twice, that's not accurate. To the best of our knowledge, that's not accurate. That's why she uses the phrase due and thorough deliberation. So if they come back right now and with another note, and she says, I still don't think there have been due and thorough deliberation. Lunch is already on the way. Y'all, if she says that again, the clock still hasn't started ticking, ladies and gentlemen, brothers and sisters. And that's a key point. Now, we may not get there. We may not get there. But those of you who are hanging with us, you'll have a one-up on people because you'll understand how this thing could be extended. And there'll be people saying, it can't. She can only. But there's a caveat. There's an exception, and you'll know about the exception. All right. Read that one more time, please, Ms. Bod, and then you can go on to the pre-TUI. Thank you. You're muted. No problem.
Thank you.
No problem. Go ahead and start over.
Restriction on sending out jury more than twice. If a jury, after due and thorough deliberation, return to court without having agreed on a verdict, the court may state anew the evidence or any part thereof, explain to them anew the law applicable to the case, and send them out for further deliberation. But if they return a second time without having agreed on a verdict, they shall not be sent out again without their own consent, unless they ask from the court some further explanation of the law. And then number 2, the pre-TUI Rodriguez charge. When the jury prematurely suggests that it may be at an impasse, but the judge concludes that the jury is not yet deadlocked and that a full TUI Rodriguez charge is not yet called for, the appeals court recommends that the judge instruct the jury using the ABA recommended language in the first 2 paragraphs of the alternate instruction. It seems reasonable to us that the jury's perception be acknowledged in some fashion. In doing so, a judge must exercise caution that the jury not be encouraged to give up the effort to reach unanimity, while at the same time ensuring that the jurors understand that conscientious disagreement is nevertheless acceptable. The ABA's language is plainly intended to serve the useful function of communicating to jurors the nature of their obligations in circumstances short of the true deadlocks that require use of the TUI Rodriguez charge, and there should be resort to it at appropriate times. Regardless of which instruction is utilized, after the jury has twice engaged in due and thorough deliberation, the judge may not send them out again without their consent. To avoid subsequent problems with S34, it is suggested that the judge state clearly for the record whenever the judge determines that a potential impasse has not occurred, quote, after due and thorough deliberation, unquote.
Well done. And that's exactly what we were just describing to you, that the that language, and the judge understood it, And that's exactly the way she put it out there, that the due and thorough deliberation. If you don't have that, clock hasn't started ticking. Clock is ticking for us, right? I mean, appreciate the mind putting in there. We're in hour 22 of deliberations. So there is some type of clock ticking, right? There's certainly some type of clock ticking. But as far as our understanding of this hung jury, the possibility of a mistrial, there's a little bit of goofiness going on, and quote unquote goofiness. And we want you to be aware of it, because this thing can go on and on as long as she, the judge, does not feel, does not believe, has not stated clearly for the record that due and thorough deliberation has taken place. If that hasn't happened, clock's not ticking. All right, we're doing good. So we'll dive back into Sister McCabe, and we'll see how Sister Jen continues to present. And again, you can see if people believe in her, if they like her style of testimony, it's going to be hard to break them from the impasse. They believe, they connected with her, potentially. It's going to be hard to sway them. How are you going to sway them? When people believe, how are you going to change their mind? And if this charge starts to get, to the point where they hear it differently, some people are going to hear it like, oh, well, I can just, agree. I can let other people are going to hear that, but very strongly. They're going to say, no. But I'm not going to change my moral conviction. I have a moral certainty in the correctness of my position. If that's where they are, whoa, then that's where we may be, heading towards a hung jury. So we'll see. Hang in there with us. So very, very interesting. Shout out to the mod, giving us the value there, reading through all that. We appreciate that. And we will continue with going over the previous testimony. And, we're the virtual jurors over here, examining, looking at things and getting life lessons from it. Don't forget to like, subscribe, hit the notification bell. We appreciate you, giving you some value here as we do on this channel. Thanks for being with us.
Yes,
And where was the vehicle and what did the vehicle look like?
it was in my driveway. I believe the driver door was left open.
And what kind of vehicle was it?
A black Lexus.
Consistent with what you had seen outside of Fairview the night or earlier in the morning?
Yes.
And so as she's coming up your walk towards your front door,
Running, yes.
and then what, if any, conversation did you have with her there in reference to that?
I just said, Karen, I was trying to calm her down. Matt came, I believe, and was yelling down that she was going to wake up the neighborhood. And then she was yelling that we had to go to Fairview. So I told Matt that I was going to go with Karen.
Initially, before that, what were your plans as far as going to look for John before Miss Reed showed up at your house?
My husband and I were going to go to Tom Beatty's.
Now, once you decide that now you're going with Miss Reed, the defendant, where did the two of you go?
So as we walked out, there was a car pulled up and then a plow.
Recognize the car that pulled up?
No.
And I'm sorry, I interrupted. So the car pulls up and then the plow, and then what happened?
So in the car was Kerry Roberts. And so she kind of rolled down the window and was like, Karen, what are you doing? And then the plow was behind her. So Kerry pulled up, and I told Karen that I was going to drive her car because I didn't want her driving because she was hysterical. So we got in her car, and then Kerry Roberts called Karen. And then Karen was screaming and, saying that she had cracked her taillight. We need to go to Fairview. Could I have hit him? Did I hit him? And then she would just scream our names. Kerry was telling her to shut up, that we needed to just go back to John's and we'll drive in one car and let's go to John's. Maybe he's there and he's passed out and you didn't see him.
Now, when you open up the door initially and you come outside and you see the defendant out there screaming and all of that, again, with respect to the weather, what was the weather at that point?
It was like dark and it was almost like a whiteout.
And so you get into Ms. Reed's vehicle, correct?
Yes,
And you're driving that vehicle from your house to Meadows Ave, is that correct?
yes,
That's Mr. O'Keefe's house?
yes,
You're familiar with that residence? You've been there plenty of times before?
yes.
Now, with respect to Kerry Roberts, did you know Kerry Roberts prior to this morning of January 29th?
I had met her once before.
And can you describe for the jury sort of the circumstances of that or how you knew her prior to January 29th?
Way back when, after John's sister and brother-in-law died, I would have Kaylee a lot and Kerry would have Patrick. And one day John said, I get a discount at Reebok. I'm going to take you guys for sneakers, get all your kid sizes. So he took Kerry and myself and we went to Reebok and bought sneakers for all my girls and me. And then he took Kerry and I to the hillside for lunch just to thank him for, helping, because that's what he did.
Now, was Kerry Roberts someone that you had as contact saved in your phone? Had you ever texted her or called her or talked to her over your phone before?
No,
So you indicated that Ms. Roberts then calls Ms. Reed's phone while you're in Ms. Reed's car, correct?
yes,
Now, as far as that, Ms. Reed's phone, was that similar to your phone that earlier in the morning? Was that hooked up in any way or matched or paired with the vehicle that you were driving?
yes,
So fair to say you could hear both sides of the conversation as far as Ms. Reed talking next to you and then obviously Ms. Roberts on the other end?
yes,
So the conversation that you were talking about as far as Ms. Roberts saying, shut up and we're going to Meadows Ave and all that, you could hear Ms. Roberts saying that?
yes.
Now, the vehicle, when you get into the defendant's vehicle, she pulled in straight into your driveway, is that correct?
Yes,
So fair to say you had to back out of the driveway, correct?
correct.
Now, when you were operating Ms. Reed's vehicle in reverse, what, if anything, showed up in sort of the center console area of that vehicle?
I do not remember. I don't know.
Do you recall anything as far as a camera or anything like that?
I don't remember. I don't remember.
You backed the vehicle out of the driveway, and you proceed to Meadows Ave, correct?
Yes,
And about how long a drive is it from your house to Mr. O'Keefe's?
Very
approximately
infrequently.
5, 6
When
minutes.
she says she doesn't remember.
And when you get to Mr. O'Keefe's house, where do you park?
I pull in straight in the driveway.
And after you pull into the driveway, at some point you all get out, correct?
Yes,
Do you recall who pulled in first as far as who was in front of who on the way to Meadows, yourself or Ms. Roberts?
I believe I was in front.
You would have pulled into the driveway and parked, and Ms. Roberts would have pulled in and parked behind you, correct?
Yes.
And so after the three of you get out of your respective vehicles, what happened then?
Karen brings us to the back of the car and says, look, see, I have a cracked taillight.
And where on the vehicle was she directing yourself?
What do you think? What do you think? I mean, the testimony of Jennifer McCabe is just really, it's really strong if you believe, and find her credible. Very, very strong if you find her credible. If you don't, then, but if you find her credible, she's putting it on pretty well for the prosecution as far as connecting the dots and giving you a good narrative for that story, if you believe it.
Self and Miss Roberts' attention.
The back right.
So passenger side, rear part of the vehicle.
Yes.
And you looked at that area of the vehicle, what could you see at that?
I saw that there were missing pieces, but there was also snow covering it. And Karen was screaming, look, look. And then Kerry was screaming back at her. It was very chaotic. So I didn't stare in depth, but what I can tell you is there were I saw missing pieces from the taillight.
And then at some point, about how long a period of time is this that you're out in Mr. O'Keefe's driveway looking at the cracked tail?
Not long, because then Kerry's, yelling at her, telling her she's crazy and that she was driving around drunk and she could have hit anything, and kind of rushes us to go into the house to look in there for John.
Your Honor, with the court's permission, I would ask if I could publish on the screen what's been marked as exhibit number 2.
Okay.
And Mr. Cave, do you recognize what's up on the screen?
I do.
What is that?
That is Meadows Ave, John's house.
And the driveway that you're talking about as far as where you pulled in, that's not visible in this photograph, correct?
Correct.
So from facing Mr. O'Keefe's house on Meadows, which side of the photograph would the driveway be, the left or the right?
The right.
And Your Honor, may I approach?
Yes.
I'm just showing you another photograph. Just ask you to look at that, look how it's finished.
Okay.
And do you recognize what's in that photograph?
Yes,
And what do you recognize?
that's John's car.
And where is John's car in relation to John's house?
It's parked to the side of the driveway.
And you also see sort of the garage area in that photograph?
Yes.
Your Honor, may I approach?
Yes.
I'm going to seek to introduce in a minute as the next exhibit.
No objection.
Your Honor, with the court's permission, if I could publish that to the jury now as well.
Okay.
Now, Mr. Cave, with reference to what's up on the screen, is that the photo that you just had before you?
Yes.
And there are 2 garage doors on the house at 1 Meadows Ave, correct?
Correct.
Left and a right, is that fair way?
Yes.
And you've been inside Mr. O'Keefe's house a number of times before, correct?
Yes.
Now, with respect to the garage door on the left, what was contained within that part of the garage?
His old-fashioned car.
The one that Kaylee didn't like?
Yes.
And on the right side of the garage, what, if anything, was in there?
It's pretty open.
How would you describe Mr. O'Keefe as far as how he kept things around his house, either in the house or the lawn or things around his house?
John was very meticulous. Everything had its place.
Now, when you arrived there on the morning of the 29th, Mr. O'Keefe's vehicle wasn't parked in that position, correct?
Correct.
From sort of the outside of the residence, were you aware of there being any sort of security cameras or anything affixed to the house of 1 Meadows Ave at that time?
Yes.
And how were you aware of that?
John told us he was, I don't remember, years prior, I believe, he came over and he was so excited that he got in a ring and he would always show us it. He just was always watching.
And when he would show you that, how would he show you? Like on what kind of device?
On his phone.
So he had the ring application hooked up to his cell phone.
Yes.
Now, with respect to that morning when you arrived, if you could, using the laser pointer, just sort of delineate for the jury whereabouts you had parked Ms. Reed's vehicle when you pulled in and you see it in this photo.
So it would be right there because John's car was further over
So Mr. O'Keefe's car was further over toward the fence.
towards the fence, yes.
And so when you arrive there, you're looking at the taillight, and at some point you go in the house, correct?
Correct.
How did you get into the house that morning?
The right garage door was open.
Now, is that something normal as far as when you get to Mr. O'Keefe's house and the garage door is open in a snowstorm?
No,
And so you go in through the garage door and then you go into the house, correct?
yes.
And Ms. Gilman, you can take it. So, Ms. McCabe, if you could describe to the jury sort of how you, when you come in through that right garage door and you start to go into the house, what is it when you see when you first come into the house, and what is sort of the layout of Mr. O'Keefe's house?
You walk in from the garage and there's a mud room.
And typically when you would walk into Mr. O'Keefe's house, what, if anything, would you or anyone else?
Take off your shoes.
And why was it?
He didn't want dirt or that morning snow probably getting all over his house.
And so that was a pretty well-known rule for anybody that spent any time at his house on Meadows End.
Yes.
And so when you and Ms. Roberts and Ms. Reed walk into the home that morning into the mudroom, what did you do? What did Ms. Roberts do? What did Ms. Reed do?
I took off my boots or shoes, whatever I had on. Carrie Roberts took off. Karen just ran straight in the house.
You and Ms. Roberts both took off your shoes, and Ms. Reed then just walked into the house with boots or shoes or whatever she was wearing on.
Yes.
And then once you get into the house, where is it that the three of you went respectively once you got in?
We all dispersed. I looked in the TV room where there is a couch. Then I kind of walked through a dining room, and then I peeked into a living room. I went upstairs. I looked in John's room. Carrie was also running around different rooms. And then I went into Kaylee's room.
And during this time when you and Ms. Roberts are sort of going around room to room, what was the defendant doing?
I'm not sure.
When you see her doing the same thing that you were doing?
No.
Now, with respect to, you went at least peeked into John's bedroom, is that right?
Yes.
What, if anything, did you note about the bed when you looked in?
It was made.
And so then you go into Kaylee's room and check on her, correct?
Yes.
And at any point in time, did you see Patrick at any point?
No.
And were you aware of where Patrick was, or did you know at that point?
At that point, I believe Kaylee told me he was at a sleepover.
So you have some conversation with Kaylee, is that right?
Yes.
And about how long a conversation did you have with Kaylee?
Probably about a few minutes.
And when you left from Kaylee, what is it that you said to her as you were leaving?
Objection.
I promised Kaylee. I promised Kaylee that I would find John and everything was going to be okay.
So after that, where did the three of you go from there?
After that, the three of us got in the car and we drove to Fairview.
And when you say you got into the car, which part of the game?
Kerry's.
Now may I approach?
Yes.
Okay, I'm showing you two photographs again. If you could just look at those and look up when we're finished. Did you recognize what's in those photographs?
Yes,
And what do you recognize those to be?
the defendant's vehicle.
And, may I approach?
Yes.
Your Honor, the Commonwealth will seek to introduce and minutes the next two exhibits.
No objection, Your Honor, thank you.
Thank you.
Your Honor, with the court's permission, if I could publish those to the jury as well. Ms. McCabe, what's depicted in this photograph is the defendant, Ms. Reed's vehicle, correct?
Correct.
And in sort of focus here is the right rear passenger side of that vehicle, correct?
Correct.
And the tail light, if you could, with the laser pointers, just direct the jury's attention to where you observe that. Now, ma'am, with respect to what's depicted in this photograph as far as any damage that you observed to this tail light area on the rear passenger side, is that consistent with what you observed in the driveway at One of Meadows Ave when the defendant was showing?
Correct, minus the snow, etc.
And Ms. Gilman, if I could have the next exhibit. And again, do you recognize what's depicted in this photograph?
Yes,
And this is essentially a closer image of that same rear passenger side taillight area, correct?
yes,
Again, what's depicted in this, is that consistent with what you observed minus sort of the caked in snow when you were in the driveway of Mr. O'Keefe's house on the morning of the 29th?
yes.
Thank you. Gentlemen, you can take that down, and Your Honor, with the court's permission, I would ask to publish just a short portion of, actually, I'm sorry. If I could publish a portion of what's been marked as Exhibit 6, which is the ring camera from the driveway.
Okay.
Ms. Gilman, if I could have video number 154 from the driveway. Pause that just for a moment. Ms. McCabe, directing your attention up to the screen, what's been marked as Exhibit 6, or video from Exhibit 6. Do you recognize what's depicted in this video?
I do.
What do you recognize it to be?
That's myself getting out of the car at Meadows Ave.
Is that essentially where you parked Ms. Reed's vehicle when you pulled in?
Yes,
If you could, just direct the jury's attention with the laser pointer as to where Ms. Reed's vehicle is that you parked, and if you see Ms. Roberts' vehicle.
that is Miss Reed's, and that would be Miss Roberts.
And as far as the right garage door that you entered into the house, if you could direct the jury's attention to whereabouts that would, I know it's not on the video, but where would it be with respect to this?
Walk straight.
Gentlemen, if you could run this into the track. Ms. McCabe, what was depicted in that video, is that consistent with what you observed the weather conditions to be around the time that you arrived at Mr. O'Keefe's house?
Yes,
And lastly, in this line, Your Honor, if I, with the court's permission, could publish just a very short portion of what's been marked as Exhibit 41. Gentlemen, if I could ask you to fast forward this to about 2 hours and 10 minutes. If you could play from there. Stop it there. And again, what's in this video, do you recognize that, Mr. Kidd?
Yes, I do.
What do you recognize that?
That is John's house.
Ms. Gilman, if you could play from there. Now, what's depicted in this video, sort of the screen directly in front of you, do you recognize what that is?
Yes,
And what do you recognize that?
John's driveway.
As far as what, if anything, do you observe in John's driveway?
John's car and Karen's car.
And where, if you could, using the laser pointer, just direct your attention to where is the defendant's car and where is Mr. O'Keefe's car?
Mr. O'Keefe's car and the defendant's.
And where you observe the defendant's car to be, is that essentially where you parked it at that time?
Yes.
Now, may I have a moment?
Okay.
You may just call me on.
Sure.
I'll see counsel at sidebar for just a minute. Jurors, I just want to tell, I appreciate counsel trying to work together for this. It's probably going to take too long, so we're just going to make do. We've had enough interruptions today, so.
Now, Mr. Cade, as far as what you observe from what you can on the screen right now, the condition of the passenger side taillight, is that consistent with what you observed when you parked the vehicle there sometime earlier that morning?
It's kind of hard to see from this distance.
And just, if you could, lastly, just with the laser pointer, direct the jury's attention to where in the video you see the rear passenger side taillight. Yeah. Ms. Gilman, you can take that. Now, Ms. McCabe, you then, yourself, the defendant, and Ms. Roberts then get into Ms. Roberts' vehicle, is that correct?
Yes.
Who's seated where within Ms. Roberts' vehicle as you're going from Meadows out? Or what was the plan and where were you going sort of first when you left Meadows out?
We were going to Fairview
And why were you going to Fairview?
because Karen kept screaming, "We need to go to Fairview."
Now, who was seated where within the vehicle when you did it?
Kerry was driving, I was in the passenger seat, and Karen was in the back.
And what were the lighting conditions at this point that you're driving over there?
It was hard to see out the window. You really had to be kind of staring out. It was dark. The snow was coming out the car.
And as you're making that drive, or as Ms. Roberts is making that drive from Meadows Ave to Fairview, about how long a drive is it?
Approximately 10 minutes. I mean, with the weather, the lights, the street lights, I would say about 10 minutes, give or take.
And as far as during the drive from Meadows Ave to Fairview, what's going on inside the car over the course of that ride?
Karen is in between us, like from the back, kind of pushing up in between Carrie and myself. And she's just screaming, "Carrie, Carrie!" Her name over and over, my name over and over, and repeating certain phrases. Could I have hit him? Did I hit him? Carrie is yelling at her to shut up, to sit back, to buckle up, to look for John.
And while this is going on, what, if anything, are you and Ms. Roberts doing in the front seat of the car?
She's slowly driving, and I'm just peering out the window looking for John. I mean, it was a crazy situation. She's screaming, "He didn't come home. Could he be walking home? Where is he?" So we're just looking out the window, looking for John.
Now, during the time that this is going on and Ms. Reed is sort of screaming in between you, was that continuous, or what, if anything else, did you see her doing in the back seat while you were going from Meadows Ave to Fairview?
I didn't see her doing anything. She just continuously screamed that. And then as we got by different landmarks, she then started, screaming, asking if John could be at certain people's houses.
And whose houses was she asking if John could be at?
If she could be at Bella's house.
Referring to the directions that you had provided the night before?
Correct.
And so that would have been, Bella was a child who was around the age of Kaylee and your daughter, correct?
Yes.
And there have been some years in the past dating relationship between Mr. O'Keefe and Bella's mother, correct?
Yes.
And so Ms. Reed is saying that in the car that morning as you're driving over to Fairview?
Yes. She asked, could he have been with Ashley? And I looked at her and said no, because to me that was a crazy idea. And then Carrie had mentioned, oh, do you think he could have called somebody else that lived on a street over? And she started screaming, who's that? Who's she?
And you recall who Carrie referred to?
Yes.
And who was it?
A woman that John had previously dated.
And was that anywhere recent in time to when you're driving around on January 29th? When they had dated?
No.
So similar to Bella's mother would have been years before?
Correct.
And so when Ms. Roberts said that, what, if anything, did the defendant say?
She was just spiraling, yelling about Ashley, who was Bella's mom, and just talking what I thought was very irrational about John maybe being with her.
So you're looking around outside of the vehicle as the vehicle is going down towards Fairview, is that correct?
Yes.
And do you recall how it was that Ms. Roberts came about coming to Fairview, similar to the night before? Did she come in from the Chapman side or from the Cedar Crest side?
Chapman.
And as the vehicle turns from Chapman onto Fairview, what, if any, conversation was going on at that point?
Well, Bella lives on that street, so that was when that conversation was being had. Also, just a continuation. It was just like continuous screaming of our names. Carrie screaming at her to sit back, and then sometimes she would sit back and almost like be quiet for a minute, and then it would start all over again.
Now, as you were coming down Fairview Road, what, if anything, were you saying to Ms. Roberts did Ms. Roberts know where she was going as far as where your sister lived?
No, I told her that my sister lived at the bottom, and then as we got closer, I said, you know, just past, see where those trees are? Just past the trees is my sister's house.
And as you got in that area, sort of the trees, from the residence of your sister at 34 Fairview Road, trees that you're talking about, where are they in relation to the property?
They're at the start of the property is the trees, and then their property begins.
And so the flagpole area and fire hydrant that you were talking about in earlier exhibits, is that in the same area as the trees?
Yes, it goes the tree and then the fire hydrant, you know, then further up is the fire hydrant and the flagpole.
As you're coming down Fairview now, approaching 34 Fairview, the house would be on which side of the vehicle, on the driver's side or the passenger side?
The driver's side.
And as you approach that area where the trees and the flagpole and the fire hydrant were, what, if anything, happens then?
We drive past the flagpole area, and all of a sudden, Karen starts screaming, there he is, and she's banging to get out.
And banging on the door in the back seat?
Yes.
And at the time that she's saying this, were you able to see anything outside of the vehicle?
I saw nothing.
And what, if anything, when she's banging and kicking or banging on the door, what did Ms. Roberts do?
Miss Roberts unlocked the door. Karen got out. Miss Roberts looked at me and said something like, she's crazy or she's batshit crazy, something like that.
And when the defendant gets out of the vehicle, where is it that she goes?
She just runs
And runs with?
straight to John.
And again, when she's running, at this point in time, can you see what she's running toward or where she's going or anything that she's talking about seeing?
I was on the passenger side, so as I got out, she was already at John.
So she gets out and essentially makes a beeline over to where John was,
Correct.
and you're getting out of the passenger side, and by the time you come around the car, she's already there.
Yes.
And when she gets over there, what, if anything, could you see at that point?
She straddles John and she lifts up his shirt, and then she lifted up her shirt and went to lay on him. And Miss Roberts went over and she was removing the snow from his face.
Let me take a step back from that just for a moment. And Your Honor, with the court's permission, I would ask to publish just a portion of what's been marked as Exhibit 12.
Okay.
Now, Mr. Cave, I'm going to direct your attention up to the screen and what's been marked as Exhibit 12, and I know this is not something that pertains to your vehicle or anything else. But what I'm going to ask you as it plays through is if what you observed in this video is consistent with what you observed during the drive to Fairview Road that way. I'm just going to, if you could play. As this video is running, Mr. McCabe, if I could just ask, what you see in this video, is that consistent with sort of the lighting and the conditions weather-wise that you observed when Ms. Roberts is driving from Meadows Ave to Fairview Road?
Yes.
Mr. McCabe, do you recognize whereabouts in the town of Canton this is perspective-wise as far as what street or where it is, any landmarks that you observed in the video?
Yes, that is Cassie. We just passed Cassie's Corner Store, and that is Chapman Street.
I'm gonna be good. Again, Ms. McCabe, do you recognize whereabouts in the town of Canton we are in this portion of the video?
Yes,
Where are we?
this is the top of Fairview.
So this will be from Chapman coming on to Fairview, is that correct?
Correct.
And prior to that, along that ride along Chapman, is that the period of time that you're looking out the window and trying to see if you can see John on the side of the road?
Yes, but we didn't drive that way.
You came from the other direction?
Yes,
You would have been taking, instead of a right onto Fairview, you would have been taking a left onto Fairview?
yes.
And, Ms. Gilman, if you could. And while I believe they've been out for somewhere in the vicinity of 22 or 23 hours, what I would submit to the court based on all of that, as well as the complexity of the issues presented to them, they really haven't even had 1 hour of deliberation equivalent to 1 day of testimony, to each of the days of testimony that they've heard. So while they have been at it for a while, I would submit that based on the evidence and testimony and witnesses and the complexity, I would say that they have not done a thorough deliberation up to this point.
Ms. Gianetti?
Our view is that it's time for Tui Rodriguez, Your Honor. They've come back now twice indicating essentially that they're hopelessly deadlocked. The content of this latest message is that they have been over all the evidence. The previous message said that they did an exhaustive review. This time they said that they have fundamental disagreements about what the evidence means, and it's a matter of opinion. It's not a matter of lack of understanding. This court, when you sent the jury out, encouraged them not to take a straw vote, encouraged them to go over all the evidence in a very methodical manner. I think all indications are that they've done that, and this is what Tui Rodriguez is for. We asked the court to get it.
Yeah. All right. I think this has been an extraordinary jury. I've never seen a note like this reporting to be at an impasse. I do find that they're now, with the additional time that they went out without coming back Friday saying that they were deadlocked, is doing thorough deliberation. So I'm going to give Tui Rodriguez. So are they ready to come in, Jody? So why don't I take a recess? And then Nancy.
Okay, ladies and gentlemen, here we go. They're bringing the jury back in, and the Dewey that we talked about, the Tui, excuse me, Tui Rodriguez with a T. Looks like we're going to be hearing that. And if you were with us earlier, we read through the conditions that need to be in place to do thorough, and the judge is now given the words. She's used the correct verbiage. So the countdown begins. We are now at a different stage of this entire process, because the restrictions on how many times they can go out again starts with the reading of this. Many believe that once you have given the TUI, that it's quite possible that you're going to receive a not guilty verdict. Excuse me, a hung jury. It's quite possible that you're receiving the hung jury, a mistrial, not guilty. Run that back, please. Run that back. So the understanding is common knowledge, the way things can go, the typical way things will go from here is a hung jury. All right, so rewind what I said. That's where you want to be, right there. And now there's no guarantee, because we don't know how they are deadlocked. We don't know where the impasse is, and once the instruction gets read, how that will be then received. Because as we read through it, there are still conditions that they may hear differently. They may hear, okay, well, it's okay if I change my mind. Then they may or may not put emphasis on the but. All right. Then there's the moral certainty. So there are other phrases that will still impact how they will proceed from here and how they view these instructions. So that's the X factor. That's why, I'm saying to you that if you're looking at how it may play out from here, there's still no guarantee. They still have the ball in their hands as far as what they choose to decide from here. And we don't know where the impasse is. We don't know who the numbers, right? The quantitative contrast. How many people are on one side, how many people on the other? Exactly. So all these are still variables. But it looks as though we're pushing towards a hung jury. The defense, it seems that they understand. They've weighed it out in their minds. They've been watching this jury for a long time. Read it. Why? Because, it looks like we're going to be pushing towards the hung jury. The prosecution, who had a chance to argue first in front of the judge just then, is real quick, so he didn't miss much, real quick. And the state says it hasn't been long enough. So then back, essentially, right? Wants more time, more deliberation. And you understand that the essence here is because you don't want the declaration of due and thorough deliberation. You don't want that phrase to be uttered if you're the prosecution. because now the clock starts to tick. And once the judge declares that there's been due and thorough deliberation, when she then sends them back, after reading them the Tui Rodriguez, when she sends them back, clock is ticking. And we do not find 5, 6, 7, 8, 9 more times of sending them back, right? Unless the jury has a question on their own accord, you can only send them back twice. After they have twice engaged. So there's a question. Okay, so we're reading again. Can she send them back one more time then? So let's clarify. Regardless of which, I'm reading from the instructions that we had earlier from 2009, regardless of which instructions utilized, after the jury has twice engaged in due and thorough deliberation, the judge may not send them out again without their consent. Okay, without their consent. Okay. So she believes that they've engaged once, right? This is what her declaration is right now, that they have engaged once. We're working through this together. We are not bar members. We are not lawyers. We're working through this. We're working through it. We're doing pretty good though. We're doing pretty good. All right. So she is now establishing that due and thorough deliberation has occurred once. Okay. So according to the law in the Commonwealth, the judge may not send them out again without their consent after they have twice engaged. So if they come back again with a question, that's okay. They can have a question. All right. That doesn't count. You know, they come out and they want a clarification. That doesn't count as the second time. But they come out again, then she can't send them out without their consent. So we could potentially have them come out and she says, whatever's in the legal framework, because you see right now, I mean, now the words are very, very particular, right? So specific. So they come out and she hears what she hears. She's like, she can't send them. Now they can say, we would like to go back and try some more. We wanted to update you, let you know, we're done for the day, but we want to keep trying. With their consent, right? They could do that. She can't send them again. So it's coming to a point here. Now, hung jury, the odds are going way up that we're looking at a hung jury here. I mean, the odds are going up. But it's not a guarantee. The reason it's not a guarantee because we're still dealing with human beings. And they are going to receive a new directive. They're going to receive this verbiage now from the judge. And they may or may not all hear it the same way. They're going to receive some instruction right now. The legal framework of, the words are already printed. They're going to receive certain words as an instruction right now, particular words. And again, how do they hear those words? What do they feel is their civic duty after receiving this information, after receiving this instruction? Does it make them more or less likely to do what? To now come to an agreement, or to certainly no way in the world am I going to change my mind? Now, we were able to pick up a little bit of insight there from the defense in the argument for reading the Tui Rodriguez is, hey, reading this note, they have gone through it. The judge says something very interesting. She says she's never seen a note like this. Speaking of this type of an impasse, that's very interesting. So it would appear, I mean, it was enough so to convince the judge, say, hey, it's been enough. I can stamp that they have had due and thorough. So she's reading. So that note, we're looking to get the exact verbiage of the note that was received. But she is saying after she read it, she can concur. Yes, there's been due and thorough deliberation. They're at an impasse, serious impasse. A fundamental is one of the words that the defense attorney used. Fundamental. I mean, this stuff is at the core. Man, I ain't changing my mind. I don't care what you say. You can leave me in here for 10 years. I ain't changing my mind. I mean, that's what you're talking about now, right? You're talking about fundamental. It ain't changing. You can forget it. You can forget it. I ain't going nowhere. I ain't changing my mind. Wow. So here we are. So we continue to wait now, and we're trying to stay with the live view so that we can be right here for you once the jury comes out, and we can hear the judge give the, again, very scripted verbiage. And we're hanging out and waiting for the judge to give the Tui Rodriguez, which will instruct them as to how they are to go, how they are to proceed from here, what is their responsibility, how they should view this moment, reminding them of their duty, reminding them of that they still have the opportunity and the responsibility to give each side a chance. They still have that right and responsibility. Yet they are not to get swayed just to go along. I'm paraphrasing, but don't just say, okay, well, it's been long enough. We tried, and we'll just what you read to them is going to let them know that's not cool either. So you have a right when you go back to try to work it out. Don't feel like you can't work it out, but also don't just get swayed because of the group or because you want it to be over with. All right, here we go. Jury should be back, and we're going to hear the instructions, and she's going to send them back to continue deliberation.
Court is in session. Please be seated.
All right. So, jurors, I am in receipt of your note. Judge Cannoni, despite our commitment to the duty entrusted to us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. We recognize the weight of this admission and the implications it holds. So, Mr. Foreman and members of the jury, I have an instruction for you. Our Constitution and laws provide that in a criminal case, the principal method for deciding questions of fact is the verdict of a jury. In most cases, and perhaps strictly speaking, in all cases, absolute certainty cannot be attained, nor is expected. Verdict to which each agrees, of course, be his or her own verdict, her own convictions, and not merely an acquiescence in the conclusions of the other jurors. Still, in order to bring 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with the proper regard and respect for each other's opinions. You should consider that it is desirable that this case be decided. You have been selected in the same manner and from the same source as any future jury would be selected. There is no reason to suppose that this case will ever be submitted to 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced at another trial. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on the Commonwealth to establish every essential element of each indictment beyond a reasonable doubt. If you are left with a reasonable doubt as to any essential element of any indictment, then the defendant is entitled to the benefit of that doubt and must be found not guilty on that indictment. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, those jurors who would find the defendant not guilty should consider whether the doubt in their own minds is a reasonable one, if it makes no impression upon the minds of the other jurors, who are equally honest and equally intelligent, who have heard the same evidence with the same attention, who have an equal desire to arrive at the truth, and who have taken the same oath as jurors. At the same time, those jurors who would find the defendant guilty ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or sufficiency of the evidence if it is able to convince the minds of their fellow jurors beyond a reasonable doubt. I will now ask you, Mr. Foreman, and members of the jury to return to your deliberations with these instructions in mind. And as with my final instructions and the supplemental instructions I sent in, I will send in a copy of this charge as well. All right, so may that be marked, Madam Court Reporter, please. All right, so thank you. We'll send you folks back out to deliver.
All rise for the court, please. Jurors, follow me.
So just as we spoke of earlier, she read the Tui Rodriguez, and we read those exact words to you earlier today. So the copy we had was from 2009. So the Commonwealth has not made any changes or substantial changes from 2009, because that's exactly the verbiage that we had for you. So for those of you that are just jumping on, is pretty interesting developments here. And let me go ahead and pull that up for you so you can see. So this is exactly what was just read, word for word. And, you know, I mean, if she misread a word, but I was following along and it looked like, I said exactly, but I mean, you know, I mean, we're talking 99.9 is what it appeared to be. The exact verbiage. And this link is in our chat. If you would like to, you know, there's no secret here. We're here to give you value. So we're not trying to hold anything from you. The link is in the chat. You could check it out yourself. And get this exact document, but I'm just going to let you look at it here, and so that you can see. And matter of fact, I'm going to make it. Yeah, there you go. There you go. All right. So I'm just roll through it, you know, just real quick, and you can see what was said. If you want me to read it, I will. But you just had her give it to you. Our moderator blessed you with it earlier, read it beautifully for you. But I will cover just a little bit. So let's pick it up. Let's pick it up here. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. When there is a disagreement, those jurors who are for acquittal should consider whether a doubt in their own minds is a reasonable one, if it makes no impression on the minds of other jurors who are equally honest, equally intelligent, and who have heard the same evidence with the same attention, with an equal desire to arrive at the truth and who have taken the same oath as jurors. On the other hand, those jurors who are for conviction ought to seriously ask themselves whether they may not reasonably doubt the correctness of their judgment if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or accuracy of the evidence if it has failed to convince the minds of their fellow jurors. I would ask you to return to your deliberations with these thoughts in mind. What do you think? Where do we go from here? What do you think? Those were the jury instructions that were just read. And again, you can check in our chat. We have the same link in the chat. We also have it in the description for this stream. Feel free to check it out for yourself. The interesting thing that just jumps out right away is they don't necessarily know the strength of their position right now. And most juries wouldn't know the strength of their position. So they have written an incredible note to the court. The judge has read it. She has said she's never seen something like it. She validates that, yes, they deserved to hear this, but do they really know what it means? Do they really understand that they are almost back to their families? They're almost home, right? This thing is almost over, but she can't say that to them. She can't say to them, hey, I heard what you said, and therefore we just need to cover up a couple of things, and we need to just kind of make you jump through a couple more hoops, and then you can go home. Then you can get back to your family. She can't say it like that. Now, she gives the admonishments, and most the judges have to do it. The courts do it all the time. Hey, have you checked on any social media? Have you been watching the news? Have you been doing any outside investigation? Because she sent them out back this weekend, right? So there are people, hey, did anybody actually dig into the law a little bit and see, well, what does it mean that she keeps sending us back out? What does it mean that we already sent the note and said, how long is this going to go? Did somebody do a little research and find out what's ahead? Because she just sent them back out again and gave them the instructions that she did the legally proper thing. Don't get me wrong. I mean, this is the law. This is the law in the Commonwealth, and she read it. So she found that there had been due and thorough deliberation, and she gave them the law. She gave them the verbiage. Okay. The instruction was given, no problem. But inside of that, because she gave it to them, now the clock starts to tick. She can't keep doing the same thing anymore. Once she has found, which she did, and she put on the record the phrase due and thorough deliberation. That was the key. On Friday, if you recall, what did she say? I have not found that there has been due and thorough deliberation. So the clock hadn't started ticking. She could have sent them back out right now if she didn't put on the record due and thorough deliberation, and the clock still wouldn't be ticking. But now the clock is ticking. She can't send them back again without their consent. If they have a question, that's different. They can come on and have a question. But if they come back again and they say, we can't do it, without the jury's consent, she has to honor that now. She has to honor that. What do you think about that as far as justice is concerned? Is that justice? Oh, man. Is one thing we talk about, the process and whether this is justice. But let me ask you a question. if withholding that knowledge is justice. Like, okay, let's say, well, we can't tell them, like what we just explained about how many times she can go back and forth, right? The judge can't legally tell them that right now. But what if somebody got an A in physics or in civics class, civics class, physics, right? What if someone got an A in civics class and they actually knew this? So now the jury, I mean, they're in there talking. So what if one of the jurors actually knows, or they had watched enough crime TV or enough court cases, or, you know, they had already been looking at hung jury mistrial possibilities? Then they know. And if they know, then the jury knows. So then when she sent them back out, they were like, cool, she gave the instructions, so we almost out of here. Cool. But if you don't know, then you're like, what in the world? We can't write a better note than this. And she still sent us back out to deliberate. Man, we ain't never going home. This stuff is going to go on forever. We're letting her know we can't do it. It's not going to be unanimous. We have fundamental disagreements. And we understand the gravity of this stuff. It's not going to work. And you sent us back to keep on fighting with each other? It's not going to work. What do you think about the fact that they may not know that they could be on their way home soon? And yet, how is that okay that they don't know? How is that okay that they don't know? Some may know, some may not know. You know, I mean, keeping information from the jury, is that all right? You understand what I'm saying? So there's information, but, you know, we can't, you know, don't tell the jury. Don't tell the jury this one. What do you mean? Don't tell. Yeah. You know, don't tell the jury this one. Wow. Okay. Okay, you say so. Boy, that's rough, man. Rough business right there, baby. Okay, so we're back to waiting, and now, and I'm going to tell you something else. You know, I mean, they got to do what the instructions told them to do, but there's no time limit on. Don't get me wrong when I was talking about the clock ticking. They could come back in a few minutes and say, hey, okay. We gave attention to each other's thoughts again, and we're still at this total impasse. So that's it, Your Honor. That's it. But, you know, doing thorough deliberation. So as long as they continue to cover that, they're on their way home. And if we get a hung jury, then we go back to those possibilities of, what does the Commonwealth do? Will they take the chance, the expense, the negative PR, and will they try Karen again? The ball's going to be in their court. Or, I mean, there are other options, smaller, you know, they could say, well, we'll try to reduce the charge and see if Karen will just accept Karen and her team, right? You know, I mean, you know, if her attorneys and her will accept a smaller charge so that we don't have to go through all this again. I mean, these are all possibilities that the Commonwealth's going to be faced with if we get a hung jury. But the flip side of all of that, not only the Fed case that may come into play, right, and change things around and change the landscape a little, but there's that other side of, even if the Commonwealth doesn't want to do it because they hate the expense, they hate the negative PR, they hate the other things that are, you know, dragging the Commonwealth down with this whole case and all of the innuendos and allegations of impropriety, etc., and corruption. Canton doesn't want this stain anymore. Let's say that. But you can't just have what? A murdered police officer and you haven't found the culprit and you haven't brought justice for the family and the community. You can't do that either, can you? So as much as you may not want to do this again, if the Commonwealth truly believes that Karen did this, do they really have an option? You know, maybe, again, possibly a lesser charge, but to just let her walk? You're going to just let her walk if you really believe it? Justice demands, law enforcement demands, the family demands, etc. That if you truly believe she did these things, then don't you have to try again? No pun intended. Don't you have to try again? Don't you have to try her again? I mean, regardless of the cost, regardless of the political cost, regardless of the reputation, regardless of the actual economics of it all, do you really have an option? If you truly believe she did what you claim she did. And, you know, we get to this hung jury, as it looks like that's where we're headed. If we get there, then what? It does also say there are citizens who believe, like you believe, prosecution. Doesn't it say, hey, y'all, how off base are you? There are citizens that agree with you. I mean, why else do you think we're at this? There's enough where people believe beyond a reasonable doubt she did it. And we know that's a high threshold. That's the highest, right? So beyond reasonable doubt, there are citizens of Canton who are saying, yes, and I'm not going to change my mind. My mind can't be changed. I understand the gravity of this case. I understand what it means. I've been through the evidence. I sat the trial. I've done my duty, and it's not going to change. It's not going to change. She's guilty. And for those people, well, that's fuel. That's fuel. That's more stimulus to say, well, yeah, you have to try her again then. Supposedly the Commonwealth believes it. Supposedly the evidence paints to it. Supposedly people who heard all the evidence, jurors, the true triers of the evidence, they agree with us. And then we're not going to do it? How do you get away with that? Ladies and gentlemen, brothers and sisters, Karen may be in for a marathon here. And this doesn't mean she's guilty or innocent. But that might be where this is headed. For various reasons. And, I'm going to share with you just another little wrinkle. From me to you. Check this one out as a possibility. Just check this out and see what you think. We're talking about like pressure, right? Pressure on the Commonwealth, pressure on the DA's office to retry this case, right? In spite of the apprehensions, in spite of the economics, in spite of the bad PR, right? So we're talking about the, doing it anyway, right? Here's another side. What does it say? What does it say to your political future? What does it say to the overall tranquility of the community if those who are in our political leadership believe she did it, those who are connected to law enforcement believe that she did it, have firefighters who were on scene gave, testimony. I mean, look at the other pillars of the community, right? Because remember, she's a quote unquote outsider anyway, right? No disrespect, but we're just weighing it out. So how do you go and have a cup of coffee and think it's okay if you're the person who says, nah, we're just going to let this go. I mean, where do you have that cup of coffee at? I mean, this is real life that we're talking about now, you know? I mean, how do you show your face if you're the person who says, well, we'll just let one of our men in blue, one of our women in blue, in this case, a man, you know, be murdered or however it happened, and we're going to just let it go because it's inconvenient. Who wants to work for that place? So you're talking about pressure, and it's not coming from just the so-called little people. It's coming from the leadership. It'll be the leadership, those who have sworn to serve the community, many of which want Karen to be found guilty. And at least if there's a hung jury, at least try it again. I mean, you know, you're going to use our tax dollars for something. Here's a good something. You know, you can see people saying that and meaning it and voting that way, or causing a lot of disruption amongst the ranks, high and low. So you're almost put in a position where you have to try her again. Even if, you know, well, we might not win in the Fed case, and, you know, there may be different people who have different, you know, they've been tarnished in different ways. Yeah, where you gonna have that cup of coffee though that you didn't even try? Your compromise might be that other option we talked about. Your compromise might be, again, if it's a hung jury, it might be try to get them to agree on a lesser charge, and then try to save face with the leadership in Canton, et cetera, and the people who really believe she's guilty, and go with that and say, hey, you know, well, we just don't think we can get this guilty verdict. We believe she did it. We can't get the guilty verdict. You know, we have still to prove beyond a reasonable doubt. And, you know, looking at what it's doing to the community, look at what it's doing to society. We just, you know, we can't continue to do this, but at the same time, we have to do something. So we understand. And so therefore we're reducing the charge to ABC. Of course, they'll, you know, counter with, you know, XYZ and meet somewhere in the middle. And then tell the community, hey, this is the best we could get. You see what happened. You see, we tried, you know, we put everything we had into the case and it fell apart. You know, you see what happened. So it's the best we can do. And I mean, maybe some people will go for that. Maybe. It's tough call. Because, you know, you're still thinking justice. You're still thinking John's family. You know, I haven't. So it's this or nothing, right? Okay, so jury has been deliberating. They've come back with another note, and the judge has agreed that they have been working hard and they've done their due diligence. And so legally at that point that she's put on the record that there's been due and thorough deliberation, she has agreed to read the Tui Rodriguez that we've been hearing about and that we've been covering on this channel, and that we also read the instructions earlier to you. So essentially the jury's back to deliberate again, and this process now has limitations as to how many times it can go back and forth. And without the jury's consent, the judge can't keep sending them back. And that's all in the link that we put in the chat, so you could check that out if you want to read it for yourself. So it looks like we're headed towards a hung jury. It could change, though. It could change. The instructions still could resonate with individual jurors a different way, and they may or may not feel like their duty is accomplished by not just saying, okay, well, let me try to convince you one more time. Let me try to convince you, this other person one more time. And there might be enough pressure that after that instruction, they feel like, oh, okay. There may be others who feel like, no. Inside the instructions, it's also clear that I'm not supposed to just change my mind just to get to a verdict. I'm not just supposed to do that. So therefore, let's tell the judge, we're still at this impasse. It's not going to change. We're not going to get to anything unanimous. And at that point, the other deliberation starts. And that's behind the closed doors of the Commonwealth DA's office. What are you going to do now? What are you going to do now? You still have an unfortunate murder of a cop, and you claim you have the one and only suspect. So what do? You have people who heard the case, deliberated over the evidence. You have people who are saying she did it, and they're not changing their minds on the jury. They believe she did it beyond a reasonable doubt. So how do you not try again? How do you not try again? And that's going to be tough. That's going to be tough. Tough for Karen, tough for the community. Wow. A lot going on. All right. We're going to go back to, we were analyzing Jennifer McCabe while we wait. So as we just did, if something happens, we'll cut in live and go through it together on our verdict watch party. Don't forget to like this video. We are not only just showing you the live and leaving it with the fan, but we are also showing you some of the prior testimony, analyzing that, and seeing how the jury reached what they've reached, which is an impasse. Because, as we're pointing out, you can see that if they believed in certain witnesses, such as Jennifer McCabe, if you believe in her testimony, it's going to be awfully difficult for someone to convince you that Aaron was innocent. It's just going to be very difficult. So it's good for us to go through these, and we're happy to do it with you. So, okay, let's jump back in. Actually, back it up just a little bit. Jennifer's testimony here, and again, very, very specific. She has so many details. It's, you can see where a person who has these many details, which most people, I don't know, I don't recall, I don't know, I don't recall. That's not her style. That's not how she testified. She's very detail oriented, which is, what does that mean to you? That, well, she's that well coached. I mean, you answer this for yourself, but you've seen as many, you've seen it many times where witnesses, hey, I don't remember that. I don't know. Whoa, I don't recall. No, not this one. And she's also giving some very key evidence, quote unquote, right? Quote unquote, if you see it as evidence, but she's certainly giving definite testimony that doesn't look good for Karen at all. So if you believe in her and you connect with Jennifer, then you can see how some jurors, hey, they don't see this not guilty thing. They just don't see it. And witnesses like this solidify that position if she connects with you, if you find her credible. And that's how we get to spot, that's one of the ways that we get to this type of an impasse. All right. The thumbnail, hung jury. Yep, that's the way it looked. All right, here we go. Thank you for being with us.
and Miss Roberts. Miss
We're gonna
Roberts went
back that
over
up again.
and
I
she was
apologize.
removing
We had it muted there, so let's back it up.
the
a little
gas.
bit.
Could he
Apologize for
have
that.
been with
All right, here we go.
Ashley? And I looked at her and said no, because to me that was a crazy idea. And then Carrie had mentioned, oh, do you think he could have called somebody else that lived on a street over? And she started screaming, who's that? Who's she?
And you recall who Carrie referred to?
Yes,
And who was it?
a woman that John had previously dated.
And was that anywhere recent in time to when you're driving around on January 29th? When they had dated?
No,
So similar to Bella's mother would have been years before.
correct.
And so when Ms. Roberts said that, what if anything did the defendant say?
She was just spiraling, yelling about Ashley, who was Bella's mom, and just talking what I thought was very irrational about John maybe being with her.
So you're looking around outside of the vehicle as the vehicle is going down towards Fairview, is that correct?
Yes,
And do you recall how it was that Ms. Roberts came about coming to Fairview similar to the night before? Did she come in from the Chapman side or from the Cedar Crest side?
Chapman.
And as the vehicle turns from Chapman onto Fairview, what, if any, conversation was going on at that point?
Well, Bella lives on that street, so that was when that conversation was being had. Also, just a continuation. It was just like continuous screaming of our names, Carrie screaming at her to sit back, and then sometimes she would sit back and almost like be quiet for a minute, and then it would start all over again.
Now, as you were coming down Fairview Road, what, if anything, were you saying to Ms. Roberts did Ms. Roberts know where she was going as far as where your sister lived?
No, I told her that my sister lived at the bottom, and then as we got closer, I said, just past, see where those trees are? Just past the trees is my sister's house.
And as you got in that area, sort of the trees, from the residence of your sister at 34 Fairview Road, trees that you're talking about, where are they in relation to the property?
They're at the start of the property is the trees, and then their property begins.
And so the flagpole area and fire hydrant that you were talking about in earlier exhibits, is that in the same area as the trees?
Yes, it goes the trees and then the fire hydrant, then further up is the fire hydrant and the flagpole.
As you're coming down Fairview now, approaching 34 Fairview, the house would be on which side of the vehicle, on the driver's side or the passenger side?
The driver's side.
And as you approach that area where the trees and the flagpole and the fire hydrant were, what, if anything, happens then?
We drive past the flagpole area, and all of a sudden, Karen starts screaming, there he is, and she's banging to get out.
And banging on the door in the back seat?
Yes,
And at the time that she's saying this, were you able to see anything outside of the vehicle?
I saw nothing.
And what, if anything, when she's banging and kicking the door, banging on the door, what did Ms. Roberts do?
Miss Roberts unlocked the door. Karen got out. Miss Roberts looked at me and said something like, she's crazy or she's batshit crazy, something like that.
And when the defendant gets out of the vehicle, where is it that she goes
She just runs
and runs with?
straight to John.
And again, when she's running, at this point in time, can you see what she's running toward or where she's going or anything that she's talking about seeing?
I was on the passenger side, so as I got out, she was already at John.
So she gets out and essentially makes a beeline over to where John was,
Correct.
and you're getting out of the passenger side, and by the time you come around the car, she's already there.
Yes.
And when she gets over there, what if anything, could you see at that?
She straddles John and she lifts up his shirt, and then she lifted up her shirt and went to lay on him. And Miss Roberts went over and she was removing the snow from his face.
Let me take a step back from that just for a moment. In Your Honor, with the court's permission, I would ask to publish just a portion of what's been marked as Exhibit 12.
Okay.
Now, Ms. McCabe, I'm going to direct your attention up to the screen and what's been marked as Exhibit 12, and I know this is not something that pertains to your vehicle or anything else. But what I'm going to ask you as it plays through is if what you observed in this video is consistent with what you observed during the drive to Fairview Road that day. Ms. Gilman, if you could play. As this video is running, Mr. McCabe, if I could just ask, what you see in this video, is that consistent with sort of the lighting and the conditions weather-wise that you observed when Ms. Roberts is driving from Meadows Ave to Fairview Road?
Yes.
Mr. McCabe, do you recognize whereabouts in the town of Canton this perspective wise as far as what street or where it is, any landmarks that you observed in the video?
Yes, that is Cassie. We just passed Cassie's Corner Store, and that is Chapman Street.
Again, Ms. McCabe, do you recognize whereabouts in the town of Canton we are in this portion of the video?
Yes,
Where are we?
this is the top of Fairview.
So this will be from Chapman coming on to Fairview, is that correct?
Correct.
And prior to that, along that ride along Chapman, is that the period of time where you're looking out the window and trying to see if you can see John on the side of the road?
Yes, but we didn't drive that way.
You came from the other direction?
Yes.
You would have been taking, instead of a right onto Fairview, you would have been taking a left onto Fairview?
Yes.
And, Ms. Gilman, if you could. Now, what's up on the screen and what you just observed as far as the drive down Fairview, is that fair and accurate portrayal or consistent with what you observed in Ms. Roberts was driving down that morning?
Yes.
And at this point in time, as you're coming sort of down the hill from Fairview, is this the point that the conversation occurs as far as Bella's mother and prior dating relationships and things like that?
A little bit more towards the top of the street.
So Bella's mother lives more closer to the top by cabin?
Midway down, yes.
Ms. Gilman, if you could. The vehicle in the roadway there, do you recognize that?
Yes.
And what do you recognize that to be?
Miss Roberts.
Just for clarification purposes, with the laser pointer, if you could direct the jury's attention to where you see Ms. Roberts.
Oops.
Now, the area where you observed Mr. O'Keefe, can you see that in this particular pause frame of the video?
Not in this frame, I cannot. It's not clear.
Just tell me if you could. You see that area now?
Yes.
Go ahead using the laser pointer, just direct the jury's attention to where that. Ms. Gilman, if you could play this for.
Do you have a problem? Accused of what? Huh?
Fast forward just about a minute. Right. And then you pause. Okay, do you recognize any of the individuals up on that screen?
Yes.
And if you could, with the laser pointer, direct the jury's attention. Who you recognize and who you recognize next?
Carrie Roberts, myself, Karen Reed.
Thank you. Gentlemen, you can take that. Excuse me. Now, Ms. McCabe, if I could just take you back to when you arrived there. You indicated Ms. Reed goes over to Mr. O'Keefe. Ms. Roberts, what is it that you were doing at that time?
I got out of the car and I came around, and for a second or two, I completely just froze. I couldn't believe what I was seeing. And then Carrie and I made eye contact, and I called 911. And Carrie was asking me to go to the car and get, she was yelling to get towels or blankets or something out of the back of our car.
Is that why the back of the car is opened up in the video that we just saw in reference to Ms. Roberts' vehicle?
Yes.
Did she direct you sort of where to go within the vehicle to find the blankets or the towels, whatever it was?
Yes.
Now, you called 911, you spoke to the operator and told them essentially where you were, correct?
Yes.
Now, as far as that initial, what you saw, that you froze and couldn't believe what you saw. Can you describe to the jury what it was that you saw?
I saw Carrie wiping the snow off of John's face, and I could not believe that that was John laying there.
And how was John positioned, or how was his body positioned when you saw him?
He was just laying flat on his back.
And as far as the snow Miss Roberts was wiping off his face, was there any other snow on his body at that time?
Yes,
And if you know about how much?
there was enough that his body was covered in snow.
And could you tell at that point how far Mr. O'Keefe was from the roadway as far as Fairview Road was concerned?
I mean, I remember kind of a little ways in. I don't know exactly.
And so you make that call to 911, and what is sort of going on with respect to Ms. Roberts, the defendant, and Mr. O'Keefe while you're on that 911?
So I run the blankets over to Miss Roberts, and she's kind of lifts him up, put the blankets underneath him, and she's screaming at Miss Reed to get off of Mr. O'Keefe. And they're kind of yelling back and forth. Karen's screaming, "Is he dead? Is he dead?" I, at some points, walk over towards the car, Carrie's car, to get away because they're so loud. And I was trying to be calm and get help there for John as fast as possible. Carrie starts yelling about doing CPR. She tells Karen to do mouth to mouth. Karen's yelling because as they start, blood starts coming out of John's mouth.
As far as the CPR, that's what you're talking about?
Yes,
So during this time, the defendant's yelling and you're on the phone with 911, correct?
yes,
So you're trying to back up or distance yourself a little bit so that you can hear what's going on with the 911 operator and they can hear you.
yes.
And after you complete that 911 call, what's going on at that?
I go over, and at that point, Carrie asks if I can take over doing the compressions.
And did you do that?
I did, yes.
And at some point after you call 911, do either police or fire or someone responds and arrives on scene, is that correct?
Yes,
Do you know about how much time it was in between when you hung up with 911 and when the first responders start to arrive?
from when I hung up, maybe a few minutes, I'm not exactly sure.
And do you recall whether or not it was police or fire or who showed up first?
Police,
And is that the officer that was in that video or that cruiser that was just up on the screen as the last visit?
I didn't see the officer in the video, but I know it was Officer Sarif was the first officer to arrive.
And so then, after the officer arrives, what happened then?
He was trying to figure out what had happened. Karen just ran around screaming my name, Carrie's name. Is he dead? Is he dead? It was on repeat. Could I have hit him? Did I hit him? More officers started to arrive. The EMTs, they began to work on him.
And by him you mean Mr. O'Keefe.
Yes,
And Mr. O'Keefe's still on the ground and they're working on him there, is that correct?
yes.
And could you see anything about sort of what they were doing or what was going on with that?
No, I just saw a bunch of them around Mr. O'Keefe.
And then what happened then?
More officers began to arrive. And Miss Reed just continued to run around screaming. As more officers and EMT arrived, they asked what happened. One EMT asked, they
I'll allow it.
one EMT had asked, his name, his age, things like that. If she knew what happened, Miss Reed stated that she hit him. Besides running around saying, I hit him, did I hit him, could I have done this? Is he dead? Is he dead? At one point, one of the police officers put Miss Reed in the back of her cruiser, and he asked for myself to go over with her, and Carrie came over with us as well.
I'd like to just take you back to when the paramedic is asking for information, biographical information, things like that. You indicated that the defendant said, I hit him, is that correct?
Yes,
Is that something that she said once or more than once?
3 times. I hit him, I hit him, I hit him.
Now, before you had made reference to statements she made with sort of qualifiers or questions as far as could I have hit him or did I hit him? Is that what she said at that time when she was speaking to the paramedic?
No, she was earlier, it was could I, did I. When she spoke to the paramedic, it was crystal clear. I hit him.
Now, one of the officers takes her over to the back of her cruiser, is that right?
Yes,
And you were over in that area as well?
yes.
Who, if anyone else, was over in that area?
Miss Roberts.
And while you were over in that area, what was going on over there?
We were in the back of the police cruiser. Karen was sitting in there. I kind of scooched myself in. Miss Roberts came over. Karen grabbed our hands. She asked us to pray. She looked at her hands and she had blood. She asked us if she could have gotten her period. We told her no, that was John's blood. Then she said, what if he's dead? Promise me you'll take care of the kids. Someone's going to take care of the kids. Then we prayed. Then at the end, they were moving John. And at that point, Karen told Carrie, go over, look, is he dead? Is he dead? Is he dead? Over and over. And Carrie said, I'll go over and check on him. And she was yelling, are they working on him? And then at that point, she grabbed my hands and she said, Google hypothermia, Google how long it takes to die in the cold. And so I had my phone out and it was cold and my hands were frozen and I have MS, and I took my phone out while she was screaming and shaking my arm, and I attempted to Google how long does it take to die in the cold.
And when you conducted that search, that was at the defendant's request on scene sometime after 6 a.m. on that day, correct?
Yes.
You recall whether or not that came up as far as your search in Google? Is it something that you typed once or more than once, if you know?
I believe I did it multiple times because as I was typing it, I don't know what else was coming up. She was screaming. My hands were shaking.
And do you recall anything as far as what the search results were, or did you click on anything, or did you get an answer to the question the defendant had posed to you?
I don't even think I got an answer because as I kept Googling and she kept yelling, and then they were moving John, and the next thing I knew we were kind of moving because she wanted to see if they were working on him.
And so you were moving along with the defendant over towards where Mr. O'Keefe had gone to the back of the ambulance?
Yes, we kind of just moved to see what was going on.
When you moved over, what did you see then?
They were just putting him in the back of the ambulance.
Now, after Mr. O'Keefe was put into the back of the ambulance, where did you go then? What did you do?
At that point, different police officers, I believe, were arriving, and they were asking questions about what happened.
And did you speak to those officers?
I did, yes.
And at that point, did you know what happened?
No, to be honest, it was like I was there, but everything was just going on, and I was completely just in a state of shock and disbelief.
And that sort of period there, how long did that go on?
So I talked to a few officers. We tried to just give them, he didn't come home. We went out looking for him, kind of just the brief overview. And then one of the police officers asked me to go into the house and to wake up my sister and my brother-in-law.
And at some point while you were outside, did you try to contact your sister and your brother-in-law?
I believe I called my sister, Nicole.
And when was that in relation to everything as far as medically that was going on with Mr. O'Keefe and all of that?
I think I might have called her right after I got off with 911 possibly, and then, she didn't answer, and that's when I was walking over, I believe, to John.
And she didn't answer the call when you called her initially?
No.
And you recall calling either your sister Nicole or your brother-in-law Brian Albert prior to going into the house?
I don't recall. I know I did call Nicole at one point. I'm not sure if I called Brian or not.
Regardless of if you called or you didn't call, do you recall having any sort of phone conversation with either Nicole or Brian Albert before you went in the house?
No.
So you at least called your sister Nicole, she didn't answer, and then one of the officers directed you to wake them up.
Yes.
And when you went up to the house at 34 Fairview, how did you get in?
The front door.
And the front door was unlocked?
Yes.
Is that typical from your experience at that residence?
Yes.
And so you went to the house, and where did you go?
I went up the stairs to their bedroom.
And the bedroom door, when you arrived there, was it open or closed or something?
Closed.
And you opened it?
Yes.
And when you opened it, who, if anyone, did you see in the room, and what were they doing?
I saw my sister and Brian, and they were both asleep.
And you familiar with a dog that they have?
Yes.
What was the dog's name?
Chloe?
Was Chloe in the bedroom as well at that time?
I don't recall.
You come in, they're both sleeping, and what happened then?
I go over to the bed, and I'm calling out their names.
And how long were you calling out their names before you got any kind of response?
Brian responded first, and he was very, startled and looked at me like, what is going on? Nicole took a little, and, I think it took Nicole a little bit longer than Brian to wake up.
And what is it that you're telling them as you're coming into the room and they're waking up?
I'm telling them that we just found John out front, and I could have possibly said, John has died. We just found John out front. They were very confused. At one point, I think Brian was like, who's John? I mean, they had just woken up, and they had no idea what I was talking about.
Now, as far as when they're first waking up and you're explaining to them, how would you describe sort of their demeanor as you're talking?
They were both shocked. I think they thought, like, why?
Not what you think they saw.
Okay.
So what I'm asking them is just sort of when you observe them, how would you describe your physical observations of what they look like, their demeanor in that respect?
Shocked, confused, not understanding.
Objection, move to strike.
Strike the last one.
Now, as far as this conversation that you're having with your sister and your brother-in-law in their bedroom, how long was that going on for?
A few minutes, at least.
And then following that, where did you go?
They got up, got dressed, and then we walked down the stairs.
And when you got to the bottom of the stairs, what, if anything, did you see when you got?
There was a police officer at the bottom of the stairs.
And do you know who that police officer is?
Yes, Officer Lank.
At that time, did you know who that police officer was?
I did, yes.
How did you know?
He's from Canton. He was, 5 years older than me. I knew him kind of growing up, who he was, and met him through the years.
You're aware of who he was?
Yes.
And were there any other officers with him initially?
No.
Now, before you go into the house, do you know where Ms. Roberts and the defendant were, or what they were doing when you went to the house?
I believe they put Karen in a car, and
Only if you know, only if you.
okay.
If you know. Do you know?
Karen was in a car. Kerry was walking all around.
Now, as far as the ambulance with Mr. O'Keefe, at the time that you go into the house, was that ambulance still there?
I'm not 100% sure, but I believe it had left.
And when you come downstairs with your sister and your brother-in-law, and the officer's there, you have a conversation, is that correct?
Yes.
Where did that first conversation occur?
In the hallway and then into the kitchen.
And from there, you mentioned that there was Officer Lank at one point. Were there any other officers that joined that conversation at some point?
Hours later, yes.
And so during that initial conversation, you're talking to the officer, who, if anyone else, not what they said, but who, if anyone else, is speaking to the officer?
Brian and Nicole.
Now, the conversation initially with the officer, do you know about how long that went on?
I don't. A few minutes.
And following that conversation, what did you do, or what happened?
My husband arrived.
And had you called him?
Yes.
And when had you called him?
I called him when I was walking in the house to wake up my sister and Brian.
So as you're walking in, you call your husband Matt, and then he arrives at some point after. Is it after you're done talking to the officer, or while you're talking to the officer?
The officer was still in the house, yes.
And so in that vein, as far as when your husband comes in, the officer's there, correct?
Yes.
Did you see your husband talking to the officer as well?
Yes, the officer asked him to step outside or step to the side, and they spoke.
And then what happened then?
The officer told me to stay.
I'll allow that. I told her to stay.
The officer told me to stay, and that he said that the state police would be coming to talk to me.
And so you stayed at the house at 34 Fairview, is that right?
Yes.
You know where Ms. Roberts and the defendant are?
Yes, Carrie came up, and she had told me that she...
Not what she told you. Next question, Mr. Miller.
At some point, did you see Ms. Roberts and the defendant go somewhere?
Yes, to pick up John's parents.
Section move to strike.
I'll strike that.
And as far as they left Ms. Roberts' car, is that right?
Correct.
Ms. Roberts was again driving.
Correct.
And at some point, did you observe them come back to the house?
Yes.
And about how long was it between the time they left and the time they came back to the house?
5 minutes, approximately.
And after they came back to the house, what, if any, other activity did you see outside as far as first responders?
I was in the house, so I didn't see Miss Roberts pull back up.
So you were in the house for most of the rest of the time that you were there, is that correct?
Correct.
And how long were you there that morning waiting for the state police?
I believe I left approximately 11:30.
During the time that you were there, you're there, your sister Nicole Albert's there, your brother-in-law Brian Albert's there, and your husband Matthew McCabe's there, correct?
Correct.
And was there anybody else that arrived at some point over the course of the morning while you were there at the house?
Yes.
And who was that? And if you know about what time was it that they arrived?
Julie Albert.
Now, with reference to when Julie Albert arrived, at some point around that time, did you have occasion to look out and see sort of what was going on outside?
No.
Were you aware whether or not there were any police or fire or anything that was still there at the time that Miss Julie Albert arrived?
There wasn't.
And she comes in the house, and at some point, I'm assuming she's informed of what had transpired there before her arrival, correct?
Yeah. Yes.
And when she's informed of that, what, if anything, did you observe about sort of her demeanor or how she reacted?
Shocked.
Now, in addition to Julie Albert, who, if anyone else, was at the house that morning while you were?
Officer Lank and Gallagher were there. And Brian Higgins came that morning.
And do you know how Brian Higgins came to know, or how Brian Higgins came to be there that morning? If you know.
I don't know.
Now, you mentioned that Officer Lank came back to the house, is that right?
Yes,
That was after some period of time when he had left?
yes,
He came back with another officer named Gallagher, is that right?
yes,
And why did they come back to the house if you know?
because I called Officer Lank.
And did you have his number, or how did you get his number if you did?
Julie Albert gave it to me.
And so you called Officer Lank, he then comes back to the house on Fairview, is that right?
Yes.
And when he came back, why had you asked him to come back?
Well, as I was sitting there and I was waiting for the state police to come, I was slowly trying to piece together what had just happened in the last couple of hours. And he had told me, if there's anything that you remember, if you remember anything, please, give me a call.
And so there was something that you remembered and you gave him a call.
Yes.
And when he came back to the house, what was it that you told him?
I told him about the comments and the remarks that Karen Reed had been stating that morning.
And specifically, what type of remarks are you referring to that you told Officer Lank when he came back?
I said that she told one of the EMTs that she hit him.
Now, at some point, you indicated that you left the house on Fairview, is that right?
Yes,
And with your husband, I presume?
yes.
And where did the two of you go?
We went home.
And your children were still there without either you or your husband there, is that correct?
Yes.
And once you arrived back home, what is it that you did at that point?
We went in the house and Officer Proctor was coming over to speak with us.
And that Officer Proctor, is that someone that you knew previously or had ever met before?
I had never met Officer Proctor.
And did he come alone, or was he with someone else?
He had another officer with him.
You know who that officer is?
Yes, Yuri Buchanan.
And had you ever met Yuri Buchanan before?
No.
When you get home, about how long was it at the time from when you arrived home with your husband to the time that the officers from the state police came by?
It was pretty quick.
Now, in addition to the officers from the state police, did anybody else come over to your house on that day, late morning, early afternoon?
Yes, my brother-in-law, Brian.
And do you know why he came over that?
Yes, he came over. I had asked him. He's like a big brother to me, and I was all shaken up and nervous and overwhelmed, and so I wanted his support.
And he obliged and he came over, correct?
Yes.
Now, at some point after the officers from the state police came over, you spoke to them, is that correct?
Yes.
And do you recall where in your home you spoke to them?
In my dining room.
And when you spoke to them, was it both of the officers that were present?
Yes.
And was there anybody else present in the dining room when you were talking?
No.
And as far as your husband or your brother-in-law, Brian, do you know where in the house they were when you were in the dining room?
Yes, they were in my bedroom.
And at some point later on that day, did those same officers talk to both your husband and your brother-in-law, Brian?
Yes.
And during each of those respective conversations or interviews, do you know where you were in the house when those were going on?
In my bedroom.
And when you were in your bedroom, could you hear anything that they were saying downstairs in the dining room?
No.
May I have a moment, Your Honor?
Yes.
May I approach, Your Honor?
Yes.
I'm showing you two separate pages, just ask you to look at them and then look at them when they're finished.
Okay.
Do you recognize each of those documents and what the content is?
Yes.
And those are essentially, one contains text messages that morning of the 29th between yourself and Ms. Reed, correct?
Yes.
And the other one is sort of the list of phone calls between yourself and Ms. Reed from that morning as well.
Yes.
Now, before I get into those, as far as after you had gone inside the house and Ms. Reed had got into Ms. Roberts' car, what if any other communication or what if any other communication did you have with Ms. Reed that morning?
I texted her asking for Carrie's phone number because I didn't have it. And I also had a phone conversation with Karen when she was in the ambulance.
And that text communication that I placed before you essentially has one bubble on it, and that's you asking for Carrie Roberts' number.
Correct.
And the phone conversation that you had with the defendant, when was that, and you know where the defendant was at the time that you spoke?
Yes, she was in an ambulance.
And if you could describe to the jury sort of what, generally speaking, what was the content of that conversation? What did the two of you talk about?
She just was repeating, asking if he was dead. Is he dead? She brought up the kids, and then she also asked if I would visit her.
And how did you respond?
I said yes.
Now, following that phone conversation, did you have any further communication in any form that you can recall with the defendant?
No.
Your Honor, may I approach?
Yes.
Commonwealth seeks to introduce and admit each of those as the next two exhibits.
Is there an objection, Mr. Jackson?
No objection, Your Honor.
Any particular order?
Doesn't matter, whichever.
Text first, please.
Oh.
Is it 94? 95.
Just a couple more questions, ma'am. Now, you had asked the defendant, Ms. Reed, for Ms. Roberts' information because you didn't have it, correct?
Correct.
And at some point, did you receive that information from the defendant?
No.
And did you receive that information from any other source?
I must have, but I don't recall how.
And as far as asking for Ms. Roberts' information, why were you asking?
She was on the way to pick up John's parents and to bring him to the hospital. And I wanted to check in on them and then further updates from Carrie about John and how he was.
You wanted to know how your friend was doing, correct?
Yes.
No further questions for this witness, Your Honor.
4 minutes of 4, I think we're way too Monday morning.
I don't think I can get it done in 4 minutes.
All right, jurors, I'm going to, we're not in session on Monday, so we'll come back Tuesday morning. So Tuesday will be a half a day. Someday next week, I might ask you to think about maybe revising some of these Tuesday, Thursdays to longer days, but I'll give you plenty of notice of that. I need to make sure that I'm just asking you to think about it. All right, so please, those same cautions, do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it. Again, leave everything here, literally, figuratively. Clear your heads, and we'll see you fresh Tuesday morning.
All right, ladies and gentlemen, brothers and sisters, we are continuing with the prior testimony of Jennifer Cave. We will continue with the cross-examination here, and we hope that you're enjoying the recap here, and we'll go forward into with what was day 15. That's where we're going right now, and give you a great view of that while we wait. So what do you think? What are we looking at? Guilty, not guilty, or a hung jury? What do you think? I mean, we're getting to that point right now where it's hard to say, huh? Hey, but the longer this thing goes, hung jury just seems like the way that falls out. And then we look at, well, where do we go from there? It's just a preview of a much longer trial, or at least the continuation, if you will, of this, that we could be talking about Karen Reed in this trial for some time to come, not just as a memory, but a second trial. What do you think about justice? What do you think about justice? The justice system. Do you feel like this is how it should be? Do you feel like this is fair? Fair for the family of John? Fair for Karen herself? Fair for the community? What do you think? Lots of variables to consider. All right, so we are continuing again with the testimony of Jennifer McCabe, and again, we were speaking of her style of testimony, right? How she seems to know so many details. Makes you wonder. And then if the jury itself is convinced by that style, it's going to be hard to deny. I hit him. You know? If you hear that, boy, it's pretty tough to just wipe that out of your mind. If you believe that she's being honest, then how do you not accept that information? I hit him. You know, and then the difference there between did I, could I have, right? But then at that point with EMT, I hit him 3 times. And, you know, Lolly had made it clear, you know, say, hey, was it the same? Did she say it in the same phrasing? You know, did she use the same phrasing as she did before? You know, more of a question, could I have? Or, you know, maybe I, you know, she says, no. At that time, it was clear. You know, I hit him. It's interesting, right? Very interesting. All right, we are back, day 15 now. Jennifer McCabe, part 2. It's also interesting looking at, you know, it's been reported in various ways, but one of the ways that, you know, it was put out there was as if Jennifer McCabe looked this up on her own, right? Just like, well, let's see, you know, how long it takes in the snow, right? Not that it was requested by Karen, that Karen was right there. And according to Jennifer's testimony, as I heard it, they're together and the question is being asked, well, hey, the directive, in fact, Google and find out how long it takes for someone in the snow. Well, that's very different than how lots of people had reported the way that went down, right? Like she was somewhere on her own and did this. Like Jennifer McCabe was, with the other group on the other side of the conspiracy, and on their behalf, this is happening. Not that it's happening right there with Karen. It's a very interesting moment of the testimony if you think about it. And then if you're a juror, right, and you believe that that's an honest moment, that that's legitimate, wait a minute. Karen may have even been the one to even ask her to do that. She didn't do that on her own. Karen was standing right there when she's trying to Google, how long does it take to die in the snow? How many people really heard it that way? How many people, when the story was retold to you and people are building the case for Karen's innocence, how many people told you that the story went that way versus like she was at the kitchen table with the other so-called co-conspirators, let's say, quote unquote, and then she was doing research on their behalf. Were you told that she was standing right next to Karen when she Googled that? Because Karen may have asked her to do it or told her to do it? Is that the way you heard that? Very interesting. Very interesting. You have to just, you have to ask these types of questions and see, wow, maybe that's why the jury's having such a tough time, right? Because if you find people like Jennifer McCabe credible, it's going to be awfully difficult, as I've said, it's going to be awfully difficult to say not guilty. Awfully difficult. Here we go. Hope you're enjoying. Don't forget to like, subscribe, hit the notification bell. Hang with us as we continue to wait for the verdict. We'll bring that to you live when it comes. And if it comes today, we shall see. May get another moment with the judge, but there's only so much she can do at this point, since she's already read the Tui Rodriguez. And we're entering now the 25th hour of deliberation. How much further? Will we get a verdict today? And will it be a hung jury? And is that justice? If we have a hung jury, will the state Commonwealth, will they try Karen again? What would you say? What would you do? Rhodes, Dogs of Conversation.
You know what? I'll be right back.
All right, please. Hey. All persons having business before the Honorable Beverly Cannoni, Justice of the Norfolk Superior Court, and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
22117, the Commonwealth versus Karen Reed.
Hey, good morning again, counsel. Good morning again, Ms. Reed. Good morning, jurors. I want to ask you those same 3 questions. Were you all able to follow the instructions and refrain from discussing this case with anyone since we left here on Friday?
Yes.
Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here on Friday?
No.
Everyone said no or should. Thank you very much. May we have Ms. McCabe, please?
So again, just be mindful of the step up.
You raise your right hand. You solemnly swear the evidence you give in court and jury in the case now here should be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Good morning. All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Ms. McCabe, family is important to you, is it not?
Yes.
As a matter of fact, it's probably fair to say that family is one of the most important things in your life.
Yes.
You indicated on Friday that you know John O'Keefe, or you knew John O'Keefe, and you considered him a friend.
Yes.
You also indicated that you know Miss Reed, and at some point you considered her a friend.
Yes.
But clearly, John O'Keefe was not family, was he?
No.
He was not a McCabe, correct?
No.
He was not an Albert.
No.
Karen Reed is not family, correct?
Correct.
Not a McCabe.
No.
She's not an Albert.
No.
Ms. McCabe, when you were at Waterfall on the evening of the 28th, going into the early morning hours of the 29th, you spent some time with John O'Keefe and Karen Reed.
Correct.
You didn't see any tension between the two of them at the time?
No.
Matter of fact, they seemed like a normal couple to you?
I didn't see them interact much.
They were both engaging with you, correct?
I had separate conversations with them.
So John O'Keefe, we've seen from several videos, I'm not going to play the video, John O'Keefe was situated for the most part over in that corner as the camera is looking, the right corner of the bar, along with you, the O'Keefe's, I think Matt McCabe was over there as well, correct?
I can't be sure, but I know I spoke to Karen in that corner.
And certainly you saw nothing to suggest that there was any tension or discord between and among those individuals, certainly between Ms. Reed and Mr. O'Keefe, correct?
Correct.
When you left Fairview, were you among the first to leave or among the last to leave?
I left with, there was 4 of us that left total. It was
Yes, were.
myself, my husband, Matt, Julie Nagel, and Sarah Levinson.
When you walked out, Karina Kolakithis was close by, close in town, correct?
Oh, wait, are you talking about leaving the waterfall?
The waterfall.
Oh, I'm sorry, I was confused. I was talking about Fairview. Leaving the waterfall?
Correct.
Yes, we were one of the last to leave.
All right. And Miss Karina Kolakithis was sort of in tow right with you as you were walking out, correct?
Yes,
And Karen Reed, my client, was also heading that direction as well, correct?
yes,
And you said something to Miss Reed, did you not? As you walked out.
we were in a conversation, yes.
Did you say specifically, you're coming with me to Karen?
No,
You didn't say that.
not exactly those words.
What exactly were the words that you used?
I said, why don't you come with me?
And you even waited outside in what was ultimately freezing cold temperatures for Miss Reed, correct?
Yes,
If you could take a look, Your Honor, with court's permission, Exhibit 53, I'd like to play about maybe a 15-second clip from that.
Okay.
Actually, it's a little bit longer than that. It may be a minute. Can we pause this, Mr. Davis? For the record, Your Honor, this is about runtime 12:10 and 17 seconds or so. If you could move that up, Mr. Davis, to 12:10 and about 45 seconds. That's close enough. Ms. McKay, do you recognize what's depicted in this portion of the video?
I see a car. It's kind of hard to see. I don't know what the thing on the white thing is.
Okay, let's go ahead and play it. Let's see if you recognize any of this. Pause, please. Oh, that's a terrible place to pause. A little further. It's also not super clear. Can you see a person in that video?
From where I'm sitting now.
It's a little tough.
Yes.
Let's go ahead and play it forward. Well, actually, we can enhance that just a bit. Did you see a person in the background right there?
Honestly, I can't make out what that is.
Let's play it forward and see if this helps. Okay. Now do you see a person?
Yes.
The lighting is terrible. I apologize. Not my video. Do you know who that person is?
I don't know.
That's you, isn't it?
I can't tell from that picture if that's me.
Okay, let's maybe play it a little bit further forward. Awesome. Now, with the flag out of the way, do you recognize anybody in the foreground down at the bottom right?
That looks to be John.
Mr. O'Keefe?
Yes.
Do you see someone to his right?
I do, yes.
And who is that person?
I cannot make it out in the photo.
Okay, let's go ahead and play it forward. And pause. You see the person with the sort of white shoes just above the car.
Yes.
Does that appear to be you?
I can't make that out that it's me, but I know I was there, and I know I spoke with them.
Okay, so you do recall walking outside and sort of waiting and hovering in about that area, correct?
I was talking with them.
Okay. Does it appear that you're talking with them in
No.
this frame?
That looks like they've walked away.
Right. As a matter of fact, it looked like they walked away without talking to you outside, correct?
Well, do you have video of moments before that when I was standing talking to them?
Well, see, this is the point where I get to ask the questions and you get to answer. So I'm
Okay.
asking you, do you see yourself standing in the parking lot after John and the person to his right had walked away?
Yes.
Okay. Let's play it for just a few more seconds. Apologize. Go ahead and pause. And what do you appear to be doing at that point?
Walking to my car.
Okay, so you turned around and left after Mr. O'Keefe and the person to his right walked away, correct?
Correct.
As you sit here, even though the video leaves a little to be desired, you know that John O'Keefe left with Karen, correct?
Yes.
So the person to his right, the more petite person with the long hair, that would be Karen.
I would assume.
Okay, so you waited out in the parking lot for a few minutes after you said or joked, "You're coming with me," or something like that, correct?
I wouldn't, no, I was speaking to them, and then I walked to my car.
You didn't say to Mr. O'Keefe, "You're coming with me." You said to Karen Reed, "You're coming with me," or something to that effect, correct?
Mr. O'Keefe was not outside when I said to Karen, "You're coming with me." I told Karen, "You're coming with me," because John was still in the bar with Matt.
So you asked Karen to come with you in your car,
Yes.
to give her a ride,
Yes.
separate from John O'Keefe.
Yes, I figured he could go with Matt because they were still in the bar.
Was there a reason why you wanted to separate Miss Reed from Mr. O'Keefe at that moment?
No.
Why not just walk to your car with Matt and go where you're going to go?
Matt was still inside.
So you thought it was important enough to make the statement, "You're coming with me," or something to that effect, to my client, to separate her from John O'Keefe, even though your testimony is John O'Keefe was just inside the bar.
Objection.
Sustained as to that form. Ask it differently.
Sure.
You know, it is quite interesting if depending on what side you're on in this whole equation, because, you know, I mean, if you're on the side of yeah, well, she's guilty, then as you listen to Brother Jackson, you feel him leading. You feel and hear him, leading. And some might say, manipulating, right? So you can see when we go back through this and you look at the various people involved and what their perspective was at this time, it can be quite illuminating as you imagine the difficulty accepting the other side. If you think she's guilty, accept that she's not guilty, vice versa. It's very difficult because it would appear you're like, man, this is Jackson's, well, if you're for Karen's innocence, you're saying, my, he's doing a great job. Look at how, he's masterfully dealing with the witness. Now, if you are believing that Karen's guilty, your view of Jackson is like, oh, she didn't say it that way. You're trying to put words in her mouth. Oh, you see? And so this is part of the skill set that we talk about on this channel is, can you separate yourself from just your own view and look at it from different angles? Do you have the ability to do that? And if you are able to do that, then what Jackson was doing in the past few minutes is quite distasteful to you. You're almost like, leave her alone. Why are you doing this to her? She's not on trial. Why are you trying to twist her words like that? Why are you doing that? And if you have that type of distaste, now what happens after weeks of listening to this guy? Once you have developed that, so now you're sitting in here listening. So, you may be jaded towards everything that Brother Jackson says from this point forward, or you may have already had come to that conclusion just from the fact that you believe she did it. So yes, very intrinsic. I mean, you can get to see how people can certainly get concretized into their position. You can see it. And how are they going to just break free from that? Very, very difficult. Very difficult.
Did you believe it was important at that point to ask Miss Reed to come with you, which would
Let's go
separate
back just
her
a
from
little
John?
bit.
There
You
was
can appreciate the other side of this. I mean, because you can hear where he's trying to lead her to, you can certainly hear it. And again, if you think that Karen
Pause, please.
is
Okay.
guilty,
Chair, please pause.
then, your respect does not really go up for Brother Jackson. You're a little offended by
It's
by his
also not
technique.
super clear. Can you see a person in that video?
from where I'm sitting now.
It's a little tough.
Yes.
Let's go ahead and play it forward. Well, actually, we can enhance that just a little bit. Did you see a person in the background right there?
Honestly, I can't make out what that is.
Let's play it forward and see if this helps. Okay. Now do you see a person?
Yes,
The lighting is terrible. I apologize. Not my video. Do you know who that person is?
I don't know.
That's you, isn't it?
I can't tell from that picture if that's me.
Okay, let's maybe play it a little bit further forward. Awesome. Now, with the flag out of the way, do you recognize anybody in the foreground down at the bottom right?
That looks to be John.
Mr. O'Keefe?
Yes,
Do you see someone to his right?
I do, yes.
And who is that person?
I cannot make it out in the photo.
Okay, let's go ahead and play it forward. And pause. You see the person with the sort of white shoes just above the car.
Yes.
Does that appear to be you?
I can't make that out that it's me, but I know I was there and I know I spoke with them.
Okay, so you do recall walking outside and sort of waiting and hovering in about that area, correct?
I was talking with them.
Okay. Does it appear that you're talking with them in
No.
this frame?
That looks like they've walked away.
Right. As a matter of fact, it looked like they walked away without talking to you outside, correct?
Well, do you have video of moments before that when I was standing talking to them?
Well, see, this is the point where I get to ask the questions and you get to answer. So I'm
Okay.
asking you, do you see yourself standing in the parking lot after John and the person to his right had walked away?
Yes.
Okay. Let's play it for just a few more seconds. Go ahead and pause. And what do you appear to be doing at that point?
Walking to my car.
Okay, so you turned around and left after Mr. O'Keefe and the person to his right walked away, correct?
Correct.
As you sit here, even though the video leaves a little to be desired, you know that John O'Keefe left with Karen, correct?
Yes,
So the person to his right, the more petite person with the long hair, that would be Karen.
I would assume.
Okay, so you waited out in the parking lot for a few minutes after you said or joked, "You're coming with me," or something like that, correct?
I wouldn't, no, I was speaking to them, and then I walked to my car.
You didn't say to Mr. O'Keefe, "You're coming with me." You said to Karen Reed, "You're coming with me," or something to that effect, correct?
Mr. O'Keefe was not outside when I said to Karen, "You're coming with me." I told Karen, "You're coming with me," because John was still in the bar with Matt.
So you asked Karen to come with you in your car,
Yes,
to give her a ride,
yes,
separate from John O'Keefe.
yes. I figured he could go with Matt because they were still in the bar.
Was there a reason why you wanted to separate Miss Reed from Mr. O'Keefe at that moment?
No,
Why not just walk to your car with Matt and go where you're going to go?
Matt was still inside.
So you thought it was important enough to make the statement, "You're coming with me," or something to that effect, to my client, to separate her from John O'Keefe, even though your testimony is John O'Keefe was just inside the bar.
Objection.
Sustained as to that form. Ask it differently.
Sure. Did you believe it was important at that point to ask Miss Reed to come with you, which would separate her from John O'Keefe?
There was never any idea of separating them.
Except for the fact the idea was, "You're coming with me," not "you two are coming with me," correct?
Incorrect.
By definition, if she came with you, you'd be separating her from John, wouldn't you?
We were standing outside
Question
talking.
could be answered yes or no. By definition, your statement to her, "You come with me," would separate her from John, wouldn't it?
It would not, because we were all going back to Fairview Road.
Not at the same time, ma'am, correct? Your idea is to bring Karen with you, separate and apart from John.
We were waiting for John to come out, and I said, "Why don't you just come with me?" It was innocent.
I'm not asking for your explanation. You'll get to that with Mr. Lowell. I'm asking for a yes or no question, or yes or no answer. By definition, your invitation would separate Karen from John, would it not?
Objection.
Right over.
Sustained. Move on.
Would it or
You know, it's interesting because one could argue if she's saying that she was talking to Karen outside and they were alone before John came, she's not separating. They're already separated.
would not separate John and Karen for the ride over?
Objection.
Sustained.
Now, when you arrived at Fairview, some folks were already there, correct?
Yes.
Who was already there?
Brian Higgins, Brian Albert, Nicole Albert, Caitlin Albert, Julie Nagel, Sarah Levinson, and Brian Albert Jr.
And then you arrived, as we saw, you walked through the parking lot, got in your car, you arrived, I presume, with your husband, Matt McCabe.
Yes, correct.
I want to ask a question about Mr. Higgins.
Mm-hmm.
You testified on Friday that you saw his vehicle when you got to the scene, correct?
Yes,
And you said that it was pulled up a little bit in front of the mailbox, correct?
yes,
Can we have exhibit 66 with the court's permission, please?
Okay.
This is a digital model of the location. Do you recognize this?
Yes.
Does it appear to be a relative scale model of 34 Fairview?
Yes.
This would be the front door, correct?
Yes.
And where's the mailbox? If you can point to it with the laser pointer. Okay, so you're pointing to an area just in front of a car that's in the driveway, correct?
Yes.
And then the driveway is to the right,
Yes.
and then along this line is the front lawn area and property line of 34 Fairview, correct?
Yes.
You indicated that that Jeep was just a little bit in front of the mailbox, meaning about there, correct?
Yes.
And the rear end of that Jeep would be butting up against the driveway,
Yes.
or at least the line of the driveway, correct?
Yes.
That's quite a bit of detail about where that Jeep was. Would you agree?
No, because I drove down the street and I took a left into the driveway and there was a Jeep there.
Okay. What I'm asking is, you didn't just say, your memory was not just somewhere in front of a house. It's literally right in front of the mailbox, the front end of it, adjoining the line of the driveway, correct?
Yes.
That detail obviously stuck out in your mind.
It did, because I was wondering whose Jeep it was.
Did you discuss that detail with your husband at any point?
Not sure.
You're not sure? You might have?
I'm not sure if I said, whose Jeep is that?
No, I don't mean then. I mean between then and now, have you and Mr. McCabe ever discussed where that Jeep was, or your memories of where that Jeep was?
Possibly.
You're aware that he put the Jeep in the exact same place that you did?
Objection.
Are you aware of that?
I am. Oh, wait, no. Excuse me. Repeat the question?
You're aware that he puts the Jeep in the exact same spot you just put the Jeep, right in front of that mailbox, correct?
I know he knows where the Jeep was. I'm not aware what he said in here.
Does he know where the Jeep was because you told him what to say about the Jeep?
Absolutely not. It's because we drove together in the car and I asked. I possibly could have asked.
One at a time, please, ma'am.
I'm sorry, I didn't mean to step on your words, I thought you.
That's okay. You can continue.
Thank you, appreciate that.
I don't think we got your answer, though.
Okay.
Yeah, I think Madam Court Reporter was asking for your answer.
Can you repeat your answer?
To the question of, did he know where the Jeep was?
Whether or not you told him where the Jeep was.
I did not need to tell Matt where the Jeep was. He knew because we were in the car together.
But you two discussed it.
When are you asking?
At any time between January 29th and today.
I'm sure we have, yes.
You were also interviewed by Trooper Proctor on January 29th, 2022, correct?
Yes.
And you were asked a series of open-ended questions. What did you see and where did you see it, correct?
Yes.
Nobody put any words in your mouth.
No.
Nobody told you what to say at that time.
No.
And you told Trooper Proctor that when you arrived at the scene, after you got there, you, quote, first observed the vehicle, meaning Miss Reed's SUV, parked on the street by the driveway facing the direction of Chapman, correct?
Do you have something I can look at to refresh my memory?
Sure. Do you not have a memory of exactly what you told Trooper Proctor?
Well, I know what
Yes or no? You need your memory refreshed?
I would like to see what the report says, please.
Permission? Yes. Thank you.
That's something that we don't see all the time. So, we have seen many times where a witness doesn't recall something and the attorney says, hey, would it help refresh your memory if I showed you a document? Would it help refresh your memory? Blah, 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 blah. I mean, we've seen that many times, right? So here's a witness who, again, seems to be quite prepared, for better or worse, who's so in tune that she's requesting something. Well, do you have something that I can look at? I mean, you see, it's normally the other way around, right? If I showed you something, would it help? But she's saying, hey, do you have something that I can see? All right. But you see how Brother Jackson now uses the moment. So you're saying you don't remember. He didn't say, oh, sure. Yeah, no problem. Here, take a look at that. Yeah, you got it. Okay, now what's your, no. He's like, okay, well, if you want to do it that way, then I'm going to use this as an opportunity to let the jury know that, oh, so you don't remember. So here's something you're not sure of. Why aren't you sure? Why do you need something? You need to see something now? Why do you need to see something right now? And the likability factor is what we're showing here in this dynamic. It's just one of the things that, could sway certain jurors to be, very, very fixed in their position of guilt, innocent, or what have you, is how they view the testimony and the people behind the testimony, and also even the attorneys or even the judge, if they feel that the judge is on one side or the other, right? And so this is what I'm saying. If you were, believing, if you're a pro Karen, then you're, come on, Jackson, come on, get her, yeah, don't let her off, Jackson, don't let her fast talk you, man. Yeah, dude, but if you believe Karen's guilty, then you're saying, oh, this guy's, squirrely. This guy's a fox. This guy's twisting her around. This guy's just trying to get her agitated. He's not after the truth. He just wants to, he's just so disrespectful. He's so rude. And then that would could possibly taint how you see the evidence, because now you're trapped into personalities. It's another huge part of this legal process, right? Personalities. And that goes back to life again. That's another, one to grow on as far as life. How many times is that the case? It's not what you say, it's how you say it, right? People's sensibilities. Some people that just give it to me cold, man. Just tell me what's right, what's wrong, and I'm good. I don't need any of that fluff. I want to be on the side of what's right. I don't need, to go through all that. Other people, it doesn't matter if you're right or you're telling them the truth. It's how you present it to them. And if you don't present it to them in that certain way, then they can't even hear the truth. And you have all different types of people all mixed in between, you get all different types. And this is where we say, Jackson can be seen as your hero right now, but he could also be, if somebody's against this, he could be pushing them further and further on their side, on their team, just feeling like she's manipulating, he's beating her up. What do you think? I mean, he's doing his job. He's advocating for his client, but you have to be effective. You see, nobody says, he's gonna be disbarred because he's not pushing for Karen. No, he's fighting hard. He's bringing his tool set to bear. He's fighting hard, but you have to be effective. And that's where the jury and the subjectivity and reading your jury is so important, which is true in life. It's just true in life because, hey, maybe you have a certain, you realize you're not connecting with certain jurors. Do you have the ability to turn this side of yourself off? So Jackson right now, because he's got the whole team, right? So let's say one of his assistants, like Miss Little, let's say she's staring at the jury and she nudges them and says, hey, when you did that, it really turned off juror number 3, 9, and 7, So I don't, when she asked for something to refresh her memory and you kind of turn that on her, didn't seem to go over too well, bruh. Question is, does Jackson have the ability in his tool set, like a great boxer, let's say, to now maybe switch a stance, or instead of just coming with this punch, comes with that punch, throws combination, now, starts to use the jab more because that wasn't working. do you have the ability to adapt now? That's a whole nother thing in life, right? So, you can realize, wow, okay, I see that's not working, but maybe you're locked or trapped in your mind and you can only sing in a certain scale, right? Somebody changes keys on you and you're lost. Somebody, changes the rhythm a little bit and nowhere to be found. As long as they're in that certain key, you can jam. Get out of that key, you're in trouble. So to Brother Jackson's credit, he's fighting for Karen. He's certainly fighting for Karen, but we're approaching the possibility of a hung jury here. So it wasn't resonating with everyone. Holla if you hear me. I mean, it's self-evident. Everybody wasn't digging it. But at least now, if you're watching the channel, you're hanging with us, you can see possibly some of the things that led to that or made it so tough for them to break free from their position. Because once you get in that position and then the fertilizer gets put on it, if you believe in Jennifer and you believe in what she's saying, then therefore I hit him 3 times. And now the attorney was trying to beat her up. She just asked if I had something. She asked earlier, I catch the same thread, right? She asked earlier, well, do you have the part of the video that shows us talking? Now is the time for me to ask the questions. So for the people who may have been offended by his approach, see, it started back with that. Or it may have even started before then, but that didn't help. So she asked a question then, and she's asking for now to say, hey, do we have a way of getting to the truth? Not just what you're trying to get me to say. There's more to the story, and I'm just trying to get to the more of the story, and you're using it to exploit me a little bit, maybe a lot of bit. Interesting. We'll back it up a little bit. We'd like to know what you think, though. Back it up a little bit. We'll see how you feel about the flow of it. We'll go all the way back, a little bit more than a little bit. We'll go back to the Jeep conversation here. How do you know? Did you talk to him about it? Did you talk to him about it?
Correct?
Yes.
That's quite a bit of detail about where that Jeep was. Would you agree?
No, because I drove down the street and I took a left into the driveway and there was a Jeep there.
Okay. What I'm asking is, you didn't just say, your memory was not just somewhere in front of a house. It's literally right in front of the mailbox, the front end of it, adjoining the line of the driveway, correct?
Yes,
That detail obviously stuck out in your mind.
it did, because I was wondering whose Jeep it was.
Did you discuss that detail with your husband at any point?
Not sure.
You're not sure? You might have?
I'm not sure if I said, whose Jeep is that?
No, I don't mean then. I mean between then and now, have you and Mr. McCabe ever discussed where that Jeep was, or your memories of where that Jeep was?
Possibly.
You're aware that he put the Jeep in the exact same place that you did.
Objection.
Are you aware of that?
I am. Oh, wait, no. Excuse me. Repeat the question?
You're aware that he puts the Jeep in the exact same spot you just put the Jeep, right in front of that mailbox, correct?
I know he knows where the Jeep was. I'm not aware what he said in here.
Does he know where the Jeep was because you told him what to say about the Jeep?
Absolutely not. It's because we drove together in the car and I asked. I possibly could have asked.
One at a time, please, ma'am.
I'm sorry. I didn't mean to step on your words. I thought you.
That's okay. You can continue.
Thank you. Appreciate that.
I don't think we got your answer, though.
Okay.
Yeah, I think Madam Court Reporter was asking for your answer.
Can you repeat your answer?
To the question of, did he know where the Jeep was?
Whether or not you told him where the Jeep was.
I did not need to tell Matt where the Jeep was. He knew because we were in the car together.
But you two discussed it.
When are you asking?
At any time between January 29th and today.
I'm sure we have, yes.
You were also interviewed by Trooper Proctor on January 29th. 2022, correct?
Yes.
And you were asked a series of open-ended questions. What did you see and where did you see it, correct?
Yes.
Nobody put any words in your mouth.
No.
Nobody told you what to say at that time.
No.
And you told Trooper Proctor that when you arrived at the scene, after you got there, you, quote, first observed the vehicle, meaning Miss Reed's SUV, parked on the street by the driveway facing the direction of Chapman, correct?
Do you have something I can look at to refresh my memory?
Sure. Do you not have a memory of exactly what you told Trooper Proctor?
Well, I know what
Just yes or no? You need your memory refreshed?
I would like to see what the report says, please.
Permission? Yes. Thank you. I'm going to direct you to that sentence. Paragraph 3. This is the face page. You'll review that, especially the highlighted portion. Let me know after you've reviewed it. Just read it to yourself. Did you have that, does that refresh your recollection?
Yes, I know I told,
All I'm asking you, I'm so sorry to do this, I don't mean to be rude. I'm just asking you, does that or does that not refresh your recollection?
regarding,
What you said to
That was good awareness right there from Brother Jackson. So I appreciate that. So I just want to give him a little shout out right there. That was good awareness. So he's aware that there's a line there. And even though he's sticking it, you know what I mean? Even though he knows the Karen lovers are, really pumping it up like, yeah, get her. But he's obviously aware and he just showed it right there, I don't mean to be, it's good. There's a line there and it just goes to what we're talking about. You got to watch that stuff. You got to watch it because you need the jurors. You need them to see it. And if they're not going to see it or if they don't see it, because of how, some of your antics, where do you go from there? Right? So, very, very interesting. Very interesting. But shout out to Brother Jackson. He did hear it. And, he's aware that, he's approaching that little fine line. So it's good that he's aware.
Are you putting words in your mouth?
no,
They told you what to say at that time.
no,
And you told Trooper Proctor that when you arrived at the scene, after you got there, you, quote, first observed the vehicle, meaning Miss Reed's SUV, parked on the street by the driveway facing the direction of Chapman, correct?
do you have something I can look at to refresh my memory?
Sure. Do you not have a memory of exactly what you told Trooper Proctor?
Well, I know
Just yes or no? You need your memory refreshed?
I would like to see what the report says, please.
Permission? Yes. Thank you. I'm going to direct you to that sentence. Paragraph 3. This is the face page. You'll review that, especially the highlighted portion. Let me know after you've reviewed it. Just read it to yourself. Did you have that, does that refresh your recollection?
Yes, I know I told,
All I'm asking you, I'm so sorry to do this, I don't mean to be rude. I'm just asking you, does that or does that not refresh your recollection?
regarding,
What you said to Trooper Proctor on the 29th.
well, I know what I said to Proctor Trooper on the 29th.
Okay, I have to do it this way, it's court rules. Does that help you with your recollection of what you told Trooper Proctor?
I didn't tell I told Trooper Proctor the car was outside when I looked at the front door and was straight outside.
Okay, can't quite get the answer I'm looking for. The court is going to require me to ask this question again. Does that refresh your recollection, yes or no, as to what you told Trooper Proctor? Yes.
I did not say this to Trooper Proctor, no.
It doesn't help.
No.
Okay. May I approach?
Yes.
Thank you. So you did speak to Trooper Proctor on the 29th, correct?
Rules of evidence, ladies and gentlemen. Rules of evidence. So many things involved with this stuff. So many things. You know, so many. Justice is it really blind, or do you need all these things to help it be blind? You know, it's kind of weird, we're going to reread the portion that the judge ruled. Miss Maud, she didn't read the alternate, she read the first version. So we're going to take a moment for those who are just joining us to just go over what was read to the jurors. And we have the version. We also put it in the chat if you'd like to download it. It's also in the description. The instructions that were read as we appeared to be leading towards a possible hung jury. So we're going to have the mod reread that first section, not the alternate, just the first, and we can follow along here the instructions that were read to the jury. Now again, at this point, you know, everything is very specific, and once the judge finds that there has been due and thorough deliberation, the parameters change. And, you know, she's got to say certain things. She has, what we understand from the Commonwealth, she has two options of what she could have read. And she chose to read the standard version that we'll have the mod read to us again. And essentially now at this point, there are some exceptions, but if the jurors come back and they're still at an impasse, then we are effectively at a hung jury, a mistrial. If they come back and ask a question, then the judge can either answer or refuse to answer or refuse to grant whatever they may have needed, and then send them back. So she can send them back if they just have a question, or if it's their own choice. Okay, you follow that? So if it's their own choice, she can send them back. If they have a question, she can send them back. But as long as they have had what she believes is due and thorough deliberation, that key phrase, as long as she puts that on the record, she can't send them back. So if they come back and she doesn't feel like it's been due and thorough, that's different. Okay, but she has already put on the record. See, Friday she didn't say due. She said it wasn't due and thorough deliberation, but she said it today. There's something happening outside the court. It may just be going to lunch. We may have to cut live for a moment. I've got another feed going for us, ladies and gentlemen, brothers and sisters. So we may let's get a live feed right quick and just confirm. Hold on, brothers and sisters. Okay. We are looking just to keep monitoring for you. So we're still fanning it up. We're fanning it up still. So nothing's going on. We're still waiting. So we'll keep you abreast, because none of us want to miss the big moment if it happens to happen. Okay, so we're good. So we'll keep checking in for you. Don't worry about that. All right. So again, due and thorough deliberation, and at that point, the judge has to allow this to come to an end. Now, if they come back and they have a verdict, then, then all bets are off then too, right? I mean, if they've got a verdict, they have a verdict. But if it's another impasse, then the rules of which and how that gets, the process of which is pre-established and supersede any one person. That's already a framework for that. That's already established, and the judge followed it and read it, and this is what we'll go over right now. Okay, Mr. Mod, let me bring you up. Give me a moment, please, to bring up the mod, and then we'll go back through. All right, ma'am, show is yours.
Yes, sir. When jurors cannot agree. Our Constitution and laws provide that in a criminal case, the principal way for deciding questions of fact is the verdict of a jury. In most cases, and perhaps, strictly speaking, in all cases, absolute certainty cannot be attained or expected. The verdict to which each juror agrees must, of course, be his or her own verdict, the result of his or her own convictions, and not merely an acquiescence in the conclusion of the other jurors. Still, in order to bring 6 or 12 minds to a unanimous result, you must examine the issues you have to decide with candor and with a proper regard and respect for each other's opinions. You should consider that it is desirable that the case be decided. You should consider that you have been selected in the same manner and from the same source as any future jury would be. There is no reason to suppose that the case will ever be submitted to 6 or 12 persons who are more intelligent, more impartial, or more competent to decide it than you are, or that more or clearer evidence will be produced on one side or the other. With all this in mind, it is your duty to decide this case if you can do so conscientiously. In order to make a decision more attainable, the law always imposes the burden of proof on one side or the other. In this criminal case, the burden of proof is on the Commonwealth to establish every part of it, every essential element, beyond a reasonable doubt. If you are left in doubt as to any essential element, the defendant is entitled to the benefit of that doubt and must be acquitted. In conferring together, you ought to give proper respect to each other's opinions and listen with an open mind to each other's arguments. Where there is disagreement, these jurors who are for acquittal should consider whether a doubt in their own minds is a reasonable one, if it makes no impression on the minds of other jurors who are equally honest, equally intelligent, and who have heard the same evidence with the same attention, with an equal desire to arrive at the truth, and who have taken the same oath as jurors. On the other hand, those jurors who are for conviction ought seriously to ask themselves whether they may not reasonably doubt the correctness of their judgment, if it is not shared by other members of the jury. They should ask themselves whether they should distrust the weight or adequacy of the evidence if it has failed to convince the minds of their fellow jurors. I would ask you now to return to your deliberations with these thoughts in mind.
Cool. Appreciate that. Appreciate that. All right. So that takes us to where we are now, and we will continue to delve into our analysis of Jennifer McCabe. I appreciate our mod, and she has the chat warmed up for sure. So those of you who want to express yourself, jump right in. She's asking very good questions, waiting for you to respond. But the questions are there. Certainly good to prompt your thoughts and spark good debate. Algorithm. I'm telling you, man, there's some people missing out on some big value here. I got to tell you, there's some huge value going on, and you know, I talk a lot. You know, we share on this channel about looking into things like what's really going on. There's certainly some value here, and you know, more people need to be able to benefit from it. Algorithm. I mean, what is going on? But what people have said historically, people have said that hitting that like button, engaging in the chat, etc., helps to train Mr. or Mrs. Algorithm, whichever it may be. Somebody needs to take it to school when it comes to Rhodes, dogs, and conversation, because we offer something extremely unique and powerful and deep and engaging. And, you know, just wait till we start getting people vocalizing and communicating their disbelief and their opposition to what your boy is saying. You know, hey man, that guy, I just don't agree with that guy, Sidney. Okay, let's hear it. Let's hear how you disagree, why you disagree, and we can respectfully make the program even more entertaining. You know, you might get me like really, really thinking, and my head starts shining and glowing. That'd be a sight to see. Might go viral. All right, thanks for joining us. This is the cross-examination of Jennifer McCabe. Keep watching out for, you know, how the dynamics between Jackson and McCabe, and if you can see which side you may have been on, and you can appreciate how the other side, you know, was digging in and feeling more and more secure in their position. Guilt, not guilt, right? Guilty, not guilty. And, you know, say, I don't like that guy. I didn't like how, you know, she testified. I don't find her credible. So all evidence is not the same, right? All witnesses are not the same. So much subjectivity. Here we go.
And Trooper Proctor asked you some very specific questions about where things were, correct?
Correct.
Focused on Miss Reed's SUV, didn't he? Asked you questions about where Miss Reed's SUV
If you
was.
can show me in the report.
Just read it.
So just off of what I just read, is that what you're going off of? Yes?
I'm asking for your memory. You're testifying.
Yes, so my memory is exactly where the car was.
Hold on. So it's very important that both of you, one person at a time, speaks.
Okay.
Madam Court Reporter has to do what you're both saying, and she can't do it simultaneously. So the best way to do that is, Ms. McCabe, just let counsel ask the question and
Okay.
then you answer. And if it takes a lot more time than we expect it to take, it does.
Okay.
So just
Thanks.
go ahead, Mr. Jackson.
Thank you, Your Honor. I'll slow it down. Did you talk to Trooper Proctor about where the SUV was?
Yes.
Thank you. And he asked you questions about where it was situated outside, correct?
Yes.
And you told him that you first observed it parked on the street by the driveway facing the direction of Chapman, correct?
I told him that when I looked out the front door, the car was straight ahead. And yes, it was facing up Chapman.
But you left out a little part by the driveway, correct?
That could have been his interpretation or an error on his part.
I see. So Trooper Proctor is wrong about what you said.
Objection.
No, I'll let him have it. Do you think he's wrong about what you said?
I 100% said it was straight out the front door.
Okay, next question, please.
Thank you, Your Honor. And during the course of that conversation, you never once, Ms. McCabe, not once, mentioned a several-ton Jeep with a snowplow attached to it, did you?
I'm not sure if I did or not.
Let's take another look at the report. Would that refresh your recollection to see the report?
Objection.
Do you think that will help you?
I'll take a look at it.
Okay.
May I?
Yes.
Direct your attention once again to paragraph 3. You've had an opportunity to review
I
it?
have, yeah.
May I approach, Your Honor?
Yes.
That looks like a report from Trooper Proctor of your interview, correct?
Correct.
That interview was taken on January 29th, correct?
Correct.
That interview was taken just a few hours, not days or weeks, hours after the events in question, correct?
Correct.
And you were asked what you saw, what you observed in front of 34 Fairview on that morning, correct? I'm sorry, the night before, correct?
He asked specific questions about Miss Reed's vehicle.
Okay. And when you said where you remember Miss Reed's vehicle being, you placed it in the exact spot where you're now saying there was a Jeep with a snowplow on it, correct?
Incorrect. I never placed Miss Reed's car in the spot where Mr. Higgins' vehicle was.
So as Trooper Proctor was taking notes about what you were saying, he just got it wrong.
You'd have to ask Trooper Proctor.
I will. And you never mentioned, according to that report, not one word about a Jeep, right?
I may never have been asked about a Jeep.
So if you weren't asked about a Jeep, you also weren't asked about a Nissan Altima. Mention that?
No.
Right. Because what he asked you was, what did you observe in front of the house? Ma'am, that's what he asked you, wasn't it?
No.
And you said, I observed her car by the mailbox.
No.
And you never mentioned the Jeep, did you?
You are not portraying what the conversation was.
Did you or did you not mention a Jeep sitting on that, right by that driveway, Trooper Proctor? Yes or no?
It's not in the report. I don't recall if he asked me about a Jeep.
Now, following the events of January 28th, 29th, you spoke extensively to Chris and Julie Albert, correct?
What do you mean by extensively?
Did you speak at all?
Yes, we did.
Between then and now, to Chris and Julie Albert.
Do I speak to Chris and Julie Albert
Have you spoken to them about these events between then and now?
about this case? Is that what you're asking?
Yes, Ms. McCabe, I'm asking about this case.
Of course, I speak to them all the time about the vicious harassment we are all receiving.
Okay, that wasn't my question. My question was, did you talk to them about this case, Ms. McCabe?
Yes.
I realize you want to give additional answers and editorialize. I'm asking you very specific questions.
Objection.
Okay, so objection as to the form. We've talked about this at sidebar, Mr. Jackson.
You've talked to them about the details of that night, correct? The 28th going into the morning of the 29th.
Yes.
You've talked to them about what happened at the bar, correct?
We've spoke about how we were all at the bar and Karen and John came in.
Is that yes or no?
Yes.
Okay, you've spoken.
Ladies and gentlemen, brothers and sisters, as you know, I got to be like the last person to start watching this trial. It's like everybody else was already in the know, right? But golly, this gets thicker. The Jackson McCabe, the tangle. And I saw the seeds of it, and I was bringing it out to you, but now it's like full-blown clash of exactly what I was trying to say to you. So I hope you appreciate what I was giving you, especially not having seen this before. But now would have been the time to like really expose it, like to really talk about it. But maybe you just think we already watched it all, and it was I was just acting like I saw what was going to happen. It doesn't really matter to me, because the reason I brought that up is because our mod has put just probably the best comment in the chat. I mean, that's the one. That's the one right there. You don't have to believe You can test it for yourself. Jump on it. Jump on it. Say, man, this dude is out of his mind. Yeah, he probably watched that video 30 times and then he said, that, okay. Oh, okay. He ain't really know. I understand. I understand. Feel free. Feel free. How we running? How we running? We live with a link in the chat, in the description, on more than one occasion, about more than one subject. Just bring it on. See, this is what I'd just be like, man. I'm about to that bald head dude, man. I'm about to put it on him. I'm gonna put it on him. But be careful. I might be the real deal. Then what you gonna do? But maybe not. It might be your civic duty to expose me. Maybe your purpose in life. Don't just, push a button and try to have cancel culture. Don't just push a button. Expose the man with your knowledge and wisdom. See? Don't take the weak way out. I just push a button. I just report. I don't like this. See, that's some weak stuff. Meet me on the battlefield of ideas. Meet me on the battlefield of the discourse of wisdom. Supposedly this is democracy. I'm talking about meet me in Athens. Meet me the streets. Huh? Aristotle, meet me in the streets meet me in the public square. Let's debate. What you scared of? Now, I know you're not hearing it right now because of the algorithm. But maybe you'll hear the replay. Maybe at some point in life you'll hear, It might be like that song that everybody else was listening to, and then finally you heard it, and then, okay, now I see what it's, okay, So maybe you'll catch it then. And God willing, we'll still be here. There'll be a different stream, and you just come on. You just come on. Say, hey, Miss Moderator, I want to jump in. Get me in there. I'm raring to go. This dude don't know what he's talking about. Oh, as I was saying, that's a great chat comment. I mean, that's just, so to the mod, that's the one. That's the one. Oh, so be it.
About a Jeep, right?
I may never have been asked about a Jeep.
So if you weren't asked about a Jeep, you also weren't asked about a Nissan Altima. You mentioned that?
No.
Right. Because what he asked you was, what did you observe in front of the house? Ma'am, that's what he asked you, wasn't it?
No.
And you said, I observed her car by the mailbox.
No.
And you never mentioned a Jeep, did you?
You are not portraying what the conversation was.
Did you or did you not mention a Jeep sitting on that, right by that driveway, Trooper Proctor? Yes or no?
It's not in the report. I don't recall if he asked me about a Jeep.
Now, following the events of January 28th, 29th, you spoke extensively to Chris and Julie Albert, correct?
What do you mean by extensively?
Did you speak at all?
Yes, we did.
Between then and now, to Chris and Julie Albert.
Do I speak to Chris and Julie Albert
Have you spoken to them about these events between then and now?
about this case? Is that what you're asking?
Yes, Ms. McCabe, I'm asking about this case.
Of course, I speak to them all the time about the vicious harassment we are all receiving.
Okay, that wasn't my question. My question was, did you talk to them about this case, Ms. McCabe?
Yes.
I realize you want to give additional answers and editorialize. I'm asking you very specific questions.
Objection.
Okay, so objection as to the form. We've talked about this at sidebar, Mr. Jackson.
You've talked to them about the details of that night, correct? The 28th going into the morning of the 29th?
Yes.
You've talked to them about what happened at the bar, correct?
We've spoke about how we were all at the bar and Karen and John came in.
Is that yes or no?
Yes.
Okay. You've spoken to them about your memory of what happened at the house at 34 Fairview that night, correct?
Yes.
You've spoken to them about who was at the bar, not just what happened, but who was there, correct?
Correct.
You talked to them about the timing of the night, correct?
I don't think specifically, no.
When people came to the bar, when they left, when people got to Fairview, when they left Fairview, things of that nature.
Well, they were at the bar, so they know who was there and when they left.
I didn't ask if you know what they know. I'm asking if you've ever spoken to them about these issues. Yes or no?
I can't be sure if we've spoken about the timeline.
And you've talked to them about when they got there and when they left.
I have no idea when they arrived at the waterfall.
Once again, Ms. McCabe, that's not what my question was. Do you understand my question? Have you spoken to them about their memory of that night and when they came and left?
They have not shared with me when they got there or when they left.
In the 2 years or 2.5 years since this event, you've had extensive conversations with your friends and family about this circumstance, correct? That's
Correct. Yes.
You've told them your observations of your story, correct?
Correct.
Your observations of the night,
Correct.
and they've told you their observations of the night, correct?
Correct.
So y'all have compared and contrasted your perspectives of what happened that night, correct?
We've tried to figure out what happened to John, our friend.
And you've talked to them extensively about your observations and what your story or your version is. Is that right?
To be honest, not extensively. Speaking about it is very painful and difficult.
What does extensively mean? More than twice?
Well, you tell me.
I'm asking the questions, Ms. McCabe. That's how this works.
I understand, but extensively would mean almost every day.
Do you talk to them almost every day?
I do, but not about the case.
Do subjects about this case come up every day?
The harassment of the case does, yes.
What about the specific facts of the case?
No, it's the facts aren't spoken as much as the vicious harassment is spoken about.
Understood. So you've told them your version of the events, correct? And they've told you their version of the events.
Correct.
And remind me.
It is interesting that she's allowed to give that extra phrase or two, like she's doing. Jackson, who we know has a deep skill set, the fact that he's not asking Sister Bev, Your Honor, please direct, non-responsive, just answer the question, that we're not hearing that happening where, the judge is focusing Jennifer to not give the extra, just only answer the questions being. But maybe again, because of Jackson's skill set, maybe he feels like he pushed it too far, and now maybe just go ahead and let people dislike her on their own. Maybe he feels like it's playing that way because you're seeing a different side of her, Jennifer, that is. And maybe he, is banking on it may tarnish somehow the way she appears, like, showing her maybe a little more erratic, showing a little more emotion, a little passion, maybe a little anger. And that anger might play, so he's allowing her to bring in the phrases of harassment. He's allowing her to continue to do that and not really jumping on that and stopping it. Or at least he hasn't been so far. So what was his rationale for allowing it to keep, because he keeps kind of walking back into it, and she exploits it. He walks back into it, and she exploits it. And for an attorney at his level, you can ask the questions in a different way, and you can ask the judge to direct the witness. And there's a lot of things that can happen, and he's not doing that. You know, he's still leaving himself open to that. So the question, I'm just giving him the benefit of the doubt, but maybe he's also a little put off. Maybe he didn't expect her to snap back the way she is. You know, so maybe he really didn't have a plan right now. Maybe he's caught off guard. Maybe he legitimately is like, whoa, you know, I didn't expect her to turn it on me. I expected, you know, I'm gonna just, you know, oh, you need to look at it. Oh, you don't remember? You know, I could give her little quick remarks, and, you know, and she just kind of, but now she's, yeah, the harassment that we received. Yeah, this is what we talking about every day, dude. Just like you doing to me right now, dude. And look at the jury. Yeah. See, this is what we going through. This is what y'all putting us through, man. Yeah, we talk about that. Well, how frequent? We don't do it too much because it's painful. What you're putting me through is painful, man. Oh, shucks. Good Lord. Yeah, I mean, we'll see how it plays out in the next couple of moments, but maybe Brother Jackson's a little caught off guard, ladies and gentlemen, brothers and sisters. Did Jennifer put it on him like that? She got a little woody? Does she have a little woody to her little woody? Does she have a little bit of it?
To them extensively about your observations and what your story or your version is. Is that right?
To be honest, not extensively. Speaking about it is very painful and difficult.
What does extensively mean? More than twice?
Well, you tell me.
I'm asking the questions, Ms. McCabe. That's how this works.
I understand, but extensively would mean almost every day.
Do you talk to them almost every day?
I do, but not about the case.
Do subjects about this case come up every day?
The harassment of the case does, yes.
What about the specific facts of the case?
No, it's the facts aren't spoken as much as the vicious harassment is spoken about.
Understood. So you've told your version of the events, correct? And they've told you their version of the events.
Correct.
And remind me, Chris and Julie Albert are, in fact, Colin's parents.
Correct.
At some point, you became aware that
She may have won that exchange, ladies and gentlemen.
your daughter,
She may have won.
Allie, was
Brother Jackson's moving
involved
on.
in
He
this
getting out of there.
matter to
He's
some
getting out of
extent,
there.
Correct?
Yes.
You became aware that there was an extraction of your phone that revealed some data about her whereabouts.
That's not how I became aware now.
Like 360?
Yes, I know what that is.
Okay, that's what I'm asking about. You became aware that you know your phone was extracted, correct?
I willingly handed over my phone.
Oh, we'll get to that.
Oh, okay.
You know that your phone was extracted.
Yes, I handed it over.
And you know that your daughter's whereabouts were revealed based on data on that phone, correct?
That is not how I became aware of my daughter's whereabouts.
You testified at the state grand jury, questioned by Mr. Lally, correct?
Yes.
You were asked about the Life 360.
Yes.
You answered those questions very fluidly.
Yes.
Yes, I know what Life 360 is. I use it all the time. It's an app, etc.
Absolutely.
Okay, let's go over that for a second. You admitted that it works as a, quote, GPS as far as where people go and everywhere that you go, correct?
Correct.
You indicated that it works as a reliable, quote, unquote, tracking device, was your testimony.
Correct.
You indicated that you rely on it, quote, so you know where your kids are at all times. Is that right?
Correct.
And you even said that it's a, quote, unquote, good parenting tool. Is that right?
Correct.
And the reason you said that is because it's accurate in your experience and it's reliable. Is that right?
It's a good tool, but it is not always accurate.
But you said, when you testified in front of the great grand jury, that it's accurate and it works as a GPS as far as where you go and everywhere you go, correct?
Objection.
Did you say that?
Can I see it?
Sure.
He didn't give the little quick remark that time. Sure. Oh man, why didn't they report on this? the mass media, you know, the little quick stuff I was seeing, you know, Jennifer McCabe, that, you know, they were running her through the mud. You know, they didn't tell me that she was up here throwing punches. Ain't nobody told me that. Okay, and maybe millions of people didn't know that because you ain't really watching, you ain't really listening. You just, you know, taking little brief excerpts and stuff. You got to watch this stuff. You got to study this stuff. Or you can just come to Rhodes, Dogs, and Conversation once the algorithm gets right. But I guess, I guess you can get it that way too. You know, we'll help you get it.
You said 13 through 15?
Yes, ma'am.
Mm-hmm. Okay.
May I, Your Honor?
Yes.
Does that refresh your recollection?
It does, yes.
Question and answer?
Well, I just don't see the word accurate on there. I don't know if I missed it.
Ms. McCabe, does that refresh your recollection as to the question and answer about whether you said it works as sort of a GPS as far as where you go and everywhere that you go?
Correct.
And your answer was, yeah. Correct?
Yes.
Okay.
So the word accurate wasn't there, is what we can glean from that. Ouch, Brother Jackson. The word accurate wasn't actually there. And she caught it. Those of you that this is too tedious for, you may, you know, take a break. I'm going back to how he led up to that point. Because I've been patting Brother Jackson on the back, but it's clear, it is clear that he is in trouble right now. It's clear. If the word accurate's not there, and he has the document, and he was even referring to it, and then she asked for it, and because of how he did the little quick remark before, he had to just say sure and give it to her, and she read it and it wasn't there. Ouch.
To them extensively about your observations and what your story or your version is. Is that right?
To be honest, not extensively. Speaking about it is very painful and difficult.
What does extensively mean? More than twice?
Well, you tell me.
I'm asking the questions, Ms. McCabe. That's how this works.
I understand, but extensively would mean almost every day.
Do you talk to them almost every day?
I do, but not about the case.
Do subjects about this case come up every day?
The harassment of the case does, yes.
What about the specific facts of the case?
No, it's the facts aren't spoken as much as the vicious harassment is spoken about.
Understood. So you've told them your version of the events, correct? And they've told you their version of the events.
Correct.
And remind me, Chris and Julie Albert are, in fact, Colin's parents.
Correct.
At some point, you became aware that your daughter, Allie, was involved in this matter to some extent, correct?
Yes.
You became aware that there was an extraction of your phone that revealed some data about her whereabouts.
That's not how I became aware now.
Life 360?
Yes, I know what that is.
Okay, that's what I'm asking about. You became aware that you know your phone was extracted, correct?
I willingly handed over my phone.
Oh, we'll get to that.
Oh, okay.
You know that your phone was extracted.
Yes, I handed it over.
And you know that your daughter's whereabouts were revealed based on data on that phone, correct?
That is not how I became aware. of my daughter's whereabouts.
You testified at the state grand jury, questioning by Mr. Lally, correct?
Yes,
You were asked about the Life 360.
yes,
You answered those questions very fluidly.
yes,
Yes, I know what Life 360 is. I use it all the time. It's an app, etc.
absolutely.
Okay, let's go over that for a 2nd. You admitted that it works as a, quote, GPS as far as where people go and everywhere that you go, correct?
Correct.
You indicated that it works as a reliable, quote, unquote, tracking device, was your testimony.
Correct.
You indicated that you rely on it, quote, so you know where your kids are at all times. Is that right?
Correct.
And you even said that it's a, quote, unquote, good parenting tool. Is that right?
Correct.
And the reason you said that is because it's accurate in your experience and it's reliable. Is that right?
It's a good tool, but it is not always accurate.
But you said, when you testified in front of the great grand jury, that it's accurate and it works as a GPS as far as where you go and everywhere you go, correct?
Objection.
Did you say that?
Can I see it?
Sure.
Wow. Wow, Brother Jackson. Wow. Wow. And what if Jennifer McCabe didn't question it? What if she just went with it and allowed it to be? And she never even said it according to the document, according to the testimony. Wow. Tricky, 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 Brother Jackson. Tricky, tricky, tricky.
May I approach you? Honor?
Yes.
Lines 13 through 15.
You said 13 through 15?
Yes, ma'am.
Okay.
May I, Your Honor?
Yes.
Does that refresh your recollection?
It does, yes.
Question and answer?
Well, I just don't see the word accurate on there. I don't know if I missed it.
Ms. McCabe, does that refresh your recollection as to the question and answer about whether you said it works as sort of a GPS as far as where you go and everywhere that you go?
Correct.
And your answer was, yeah. Correct?
Yes.
Okay. So where did Allie go after she supposedly dropped off Colin Albert?
She went nowhere.
Did you check her Life 360 app to verify that she went, quote, nowhere?
At that point, I had no reason to check her.
So the answer is no, you didn't.
No.
Okay. Did you ever verify through the Life 360 app that in fact Allie did not go home, but rather was out driving until after 1:30 a.m.? You ever check the app and see that?
Did I ever check Life 360 app for that?
Yep.
No.
Okay. But you believed her when she said she came home.
Yes.
And just like you believed her when she said she picked up Colin, dropped him off, and then came home.
Yes.
Okay. The Alberts had a dog, pardon me, correct?
Yes.
What was the dog's name?
Chloe.
You indicated that on the morning of January 29th, after 6 a.m., when it was still relatively dark out, you burst into the bedroom of Brian and Nicole Albert's home, correct?
Yes.
You did that specifically to wake up, according to you, Brian Albert and Nicole Albert, correct?
Yes.
Where was Chloe?
I don't know.
So you'll agree that, at least from their perspective, you walked in the front door unexpectedly, correct?
Yes.
You walked upstairs unexpectedly, correct?
Yes.
Still dark outside, right?
Yes.
You walked through their door, and you said you burst into the door into a dark room where they were sleeping, correct?
Yes.
Mr. Albert said that you were somewhat hysterical. Would you agree with that?
Yes.
You were loud, right?
I was trying to wake them up.
You were somewhat chaotic.
Yes.
And you don't remember a 70-pound German Shepherd having any reaction.
No.
Matter of fact, you don't remember the dog being there at all, correct?
Correct.
You never saw that dog, correct?
I have no memory of seeing that dog.
Okay, so as you sit here today, you cannot say that the dog was here because you don't have a memory of ever seeing it,
I
right?
did not see it, no.
And remind me once again, when you were leaving that night, that early morning before, who was the last person to leave? Was it Caitlin?
I believe she left after us.
We've talked about this, and I want to get into a little bit more detail about it. You indicated that at some point you looked outside and you saw Karen Reed's SUV in front of the house. Safe to say, correct?
Correct.
About what time was that you first saw it?
I can just give you maybe approximates. I know I texted when I saw them, so whatever time that was.
All right, let's see if we can narrow that down just a little bit. You also indicated that you saw Ryan Nagel's vehicle outside.
Saw lights.
Okay. Lights belonging to the vehicle, right?
Yes, I knew there was another vehicle outside.
And where was that in relation to Miss Reed's vehicle?
It was behind it. I didn't pay much attention to it.
Okay, and where was the Jeep in relation to Ryan Nagel's vehicle and Karen Reed's SUV?
I remember seeing Karen Reed's SUV straight, and then I saw the lights of Ryan Nagel. I did not pay attention to where it was. I was just looking at Miss Reed's vehicle.
Was Ryan Nagel's vehicle and those lights that you remember, were they in front of the Jeep or behind the Jeep?
I am not certain.
Haven't you testified previously that you remember the Jeep being between Ryan Nagel's vehicle and the SUV?
I am not certain where Ryan Nagel's vehicle was.
So as you sit here now, you don't know if it was in front of the Jeep as you placed it by the mailbox.
It would
Let me
be,
finish my question. Behind the Jeep or somewhere in between?
it definitely was not in front of the Jeep.
Definitely was not in front of the Jeep.
No.
So it was definitely behind the Jeep.
Behind or to the side, I'm not sure.
Well, if it's parked on the street in front of the house, it's not going to be beside the Jeep, right? That's going to be in the middle of
It
the road.
would have been in the middle of the road, correct. So if it's pulled over, it's behind the Jeep.
Okay, so now we've narrowed that down. It's Karen Reed's SUV. As we're looking at the property, Karen Reed's SUV. To the right of that, as we're looking at from the street, at the property, to the right of that Jeep, behind that Ryan Nagel's vehicle, correct?
Correct.
You sure about that?
If my memory serves right, yes.
If your memory serves you. Okay. So you were asked about the arrival of Mr. Nagel's car at the state grand jury. Do you recall that?
I believe so.
That was in April 26th, 2022. Just
Okay.
remember. Okay. Does that sound about right? I
Yep.
don't expect you to
Yes.
memorize that date.
Yes.
you were asked, what time did you see Ryan Nagel's vehicle arrive at the location? And you indicated that it was 12:23. You remember that?
Do you have it?
I do. Yeah.
Yes.
Take a look at lines 21 on the highlighted portion. Let me know when you're.
Okay.
May I interrupt?
Yes.
You were asked, do we know what time the brother came? Meaning Ryan Nagel,
Okay.
correct?
Correct.
And the question from Mr. Lally was, that was from a grand juror, the question from Mr. Lally was, if you know, correct?
Correct.
And your answer was, I believe he was out front at 12:23. Is that right?
Correct.
And the reason you could be so precise with that time, Ms. McCabe, is because you had asked Julie Nagel to give you her text messages with Ryan for that night, and you had refreshed your recollection about the time, correct?
Correct.
All right. And you've also testified that as soon as you saw Ms. Reed's SUV, you texted John. Is that right?
Correct.
Here, exclamation point, question mark. That was the first text, right?
Correct.
But your text to John was at 12:27. You recall that?
Yes.
That's 4 minutes after you know Ryan Nagel arrived at the scene, correct?
Correct.
Since Karen Reed arrived before Ryan Nagel, she and John had to have been there 4 to 5 minutes before you ever saw her SUV, correct?
Objection.
I'll let him have it.
Is that right?
Ryan Nagel texted his sister at 12:23 here. And then he texted again that he was going to leave. Then Julie Nagel went outside
Ms.
and
McCabe, that's not my question.
I'm explaining what happened in the 4 minutes.
You can explain at another question. My question is very specific. Given the fact that Karen Reed, by definition, arrived at the location before Ryan Nagel, and Ryan Nagel arrived at 12:23, that means, and you didn't notice the SUV until 12:27, that means her car was there for at least 4 minutes before you ever noticed it, correct?
Objection.
Is that correct? Can you answer that question?
Correct.
The snow condition. We've heard a lot about the snow condition. I'm not going to beat that dead horse. But it's safe to say that you would agree with me that it was a light dusting of snow, correct? I should be specific about the time. It was a light dusting of snow at or around 12 to 12:30, 12:45, something like that.
It was starting to accumulate.
Okay. And accumulate means stick to the ground, not just fall and melt, right?
Yes.
So it was starting to turn like a very thin blanket of white.
Yes.
You indicate that, or you indicated on Friday that you saw some sort of tire tracks. Is that right?
On Friday? I don't believe.
I thought in your testimony to Mr. Lally on Friday, you indicated that you saw some tire tracks. I could be wrong.
Yes, I don't remember that.
Okay, well, let me ask you, did you see any tire tracks?
At one point, yes.
Okay, when was that point?
I'm not sure.
Was it before Ms. Reed's vehicle got there? Was it after? Let's use that as a barometer first.
I believe it was after Miss Reed's vehicle was there because that's why I was drawn to look outside.
And what did those tire tracks look like? How would you describe them?
Almost like as a wave went like this. So
like a half J?
To my recollection, it was almost like started, if Miss Reed's vehicle's here, let's pretend, it was kind of like that. Like a bit of a wave. So if you started on coming towards her, it'd be more of a wave,
Okay.
like this in the road.
What it sounds like is perhaps, I don't want to put words in your mouth, but perhaps what you're describing is tracks in the middle of the road. If someone is pulling off parallel, they would pull to the right and then stop. And those are the tracks that you saw? That's the wave that you saw?
It wasn't up to her car. It doesn't look like your description.
Okay, fair enough. I'm just trying here. So if it didn't go up to her car, those tracks belong to somebody else.
Well, when I saw her car, it had already moved up.
Well, wait a minute. You already said that when you saw her car, it was directly in front of you.
And then it moved at one point.
Right, that's not what I'm asking about. Let's just take the point at which you first saw the car. Is that yes?
Yes.
Okay. When you first saw the car, that's when you saw the tire tracks. You just said that.
No, I did not say when I first saw the car, I saw the tire tracks.
I thought you just said a couple of questions ago that you saw the tire tracks because your attention was drawn to her car. That would be the first time you saw her car, correct?
I'm saying I saw the tire tracks because I was looking out at her car. I never said when I saw the tire tracks or where her car was when I saw the tire tracks.
Well, I thought you just said, because I asked, when did you see the tire tracks? You said, I saw the tire tracks when I looked and saw her car because my attention was drawn to her car. And I saw the tire tracks. That would be the first time you looked at her car, correct?
Doesn't have to be the first time I looked at her car. I looked out multiple times.
Did you see the tire tracks the second time?
Well, I'm not exactly sure.
Did you see them the third time?
Again, I'm not sure.
Okay, so it could have been the first time.
Could have been.
But they didn't lead to the back tires of her car, did they?
No.
Let me have just a moment, Your Honor.
Yes.
In addition to Trooper Proctor interviewing you on the 29th, you also gave extensive testimony on April 26th, 2022 in front of a state court grand jury, correct?
Correct.
And you were asked about the location of Miss Reed's vehicle. I'm still staying with that for just a quick second, if you don't mind. Is that right?
Correct.
You were asked where the SUV was in relation to Ryan Nagel's car. Is that right?
Would I be able to look at it to refresh my memory, please?
Well, let's start with this. Do you remember being asked about Karen Reed's SUV and Ryan Nagel's truck?
To be honest, I've had a few grand juries, so if you could show me what you're talking about, I would greatly appreciate it.
All right, we need to get some scorecards here. Who's getting the better of this? Jackson or Jennifer McKay?
Let me have just a moment, Your Honor.
Yes.
May I approach?
Yes.
Try to speed things up, Your Honor, if I may have just a moment.
Okay, take your time.
May I approach?
Yes.
Thank you.
Thank
That's
you.
the entirety of your state court grand jury.
Okay.
I'm going to direct your attention to pages 182 to 187. You can probably scan those pretty quickly and just let me know after you scan those.
Okay.
Those pages, I should say. May I, Your Honor?
Yes.
Thank you. Thank you. Did you have an opportunity to glance at those pages?
I did, yes.
As you glance at those pages, my question is a relatively simple one, but I wondered if you have an opportunity. At no point, when you were describing the vehicles that were out front, in front of 34 Fairview on that night, at no point, under oath, in front of that grand jury, did you ever mention a Jeep? Did you?
I was not asked about any other vehicles out front.
So when you were talking about the vehicles that you saw in front and with some painstaking detail, talking about the black SUV and Ryan Nagel's truck, you just left out the Jeep because nobody asked you about it.
I didn't read anything in that about Ryan Nagel's vehicle.
Did you miss it?
I must have.
Okay.
Is it in there?
Yeah, it is.
Okay,
You were,
what,
in fact, asked about Ryan Nagel's Jeep, weren't you?
if you want to show me.
Well, I don't want to sit here and, did you want to review your
I
transcript?
just read it all. I didn't see it.
Ms. McKay.
Objection.
You can't interrupt when I'm talking.
Okay.
I will do the same for you. Okay? As you reviewed those pages, you were asked about the cars that you saw in front, did you not?
I was asked about Miss Reed's vehicle.
Okay. And at no point did you mention a Jeep being behind Miss Reed's vehicle, as you testified today, correct?
The questions were all about Miss Reed's vehicle.
At no point, my question is this, it's yes or no. You did or you didn't. Did you mention ever in that grand jury that there was a Jeep behind Miss Reed's vehicle? Yes or no?
I'm not sure. I'd have to read it all.
As you sit here, do you recall mentioning the Jeep?
I was asked about Miss Reed's vehicle, and those are the questions I answered.
I can't, you need to keep your
Okay.
voice up, please.
Sorry.
Let's try this again. As you sit here, do you recall mentioning the Jeep, ma'am?
I would have to reread the transcript.
You don't have to reread the transcript to answer that question. Do you recall mentioning the Jeep? If you don't, you don't.
The problem, ladies and gentlemen, after we saw the inaccuracy of the last time this happened, problem is it looks like she was never asked. And so he's not going to let her read it. And that's not too cool, Brother Jackson. It's not cool, man. I mean, you're putting it out there to the jury and to the world. And this is the second time it would appear that you're setting her up, and you're putting it out there that something was said or not said, and it's not in the transcript the way you're trying to paint it. This, man, seems a little low budget. No, Brother Jackson.
Their vehicles out front.
So when you were talking about the vehicles that you saw in front in some painstaking detail, talking about the black SUV and Ryan Nagel's truck, you just left out the Jeep because nobody asked you about it.
I didn't read anything in that about Ryan Nagel's vehicle.
Did you miss it?
I must have.
Okay.
Is it in there?
Yeah, it is.
Okay,
You were,
what?
in fact, asked about Ryan Nagel's Jeep, weren't you?
If you want to show me.
Well, I don't want to hear it. Did you not review your transcript?
Just read it all. I didn't see it.
Ms. McKay.
Objection.
You can't interrupt when I'm talking.
Okay.
I will do the same for the security. Okay? As you review those pages,
He could just show it. If it's there, just show it. That's what she asked
I was
for.
asked about Miss Reed's vehicle.
Okay. And at no point did you mention a Jeep being behind Miss Reed's vehicle, as you testified today, correct?
The questions were all about Miss Reed's vehicle.
At no point, my question is this, it's yes or no. You did or you didn't. Did you mention ever in that grand jury that there was a Jeep behind Miss Reed's vehicle? Yes or no?
I'm not sure. I'd have to read it all.
As you sit here, do you recall mentioning the Jeep?
I was asked about Miss Reed's vehicle, and those are the questions I answered.
I can't, you need to keep your
Okay.
voice up, please.
Sorry.
Let's try this again. As you sit here, do you recall mentioning the Jeep, ma'am?
I would have to reread the transcript.
You don't have to reread the transcript to answer that question. Do you recall mentioning the Jeep? If you don't, you don't.
I may not have been asked about the Jeep, so I did not mention the Jeep.
Fair enough. Did you and Mr. Higgins between
Ain't no fair enough. Ain't no fair enough, brother. What kind of junk is that? Fair enough.
then and now, between the date of the incident and now, have you ever had a conversation with Mr. Higgins about where his Jeep was parked?
No.
Have you ever had a conversation with Mr. Higgins about anything having to do with this case?
I do not believe so.
Did anyone, leaving Mr. Higgins aside, did anyone tell you anything about Mr. Higgins' Jeep and what he testified to?
No.
Were you ever asked by anybody to mention a Jeep being behind Ms. Reed's SUV in this trial?
Can you repeat the question, please?
Were you ever asked by anybody to make sure you mention a Jeep being parked behind Ms. Reed's SUV in this trial?
Not that I recall, no.
After you arrived and you noticed this SUV outside, you started paying somewhat close attention to it, did you not?
I went to the front door and looked out the window at the vehicle, yes.
As a matter of fact, you texted as soon as you saw the vehicle, that 12:27 here, correct?
Correct.
And then a few minutes later, at 12:31, you texted, "Pull behind me," to John. Is that right?
Correct.
And then at 12:40, you texted, "Hello," correct?
Correct.
And at 12:42, you texted, "Where are you?"
Correct.
And at 12:45, you texted, "Hello," correct?
Correct.
So that's 5 text messages, and each time you texted him, you were walking to the door and looking out at the vehicle as you're texting, correct?
I know for the first two I was.
You testified at another hearing, another proceeding, on June 8th, 2023, correct?
Correct.
In that other proceeding, did you testify that you got up and sat down and got up and sat down every time you were texting?
Possibly.
Okay. So if you got up and walked over to the door and you see the SUV and you text, and then you walk away from the door and sit down for a second, that would be one text and one view of the SUV, correct?
Yes.
So if you did that at 12:27, 12:31, 12:40, 12:42, and 12:45, you'd agree that's 5 times that you were up and down looking at the SUV, correct?
I'm not sure if I did it 5 times.
How many times do you think you did do it?
I know I definitely did it the first when I said here. I know I definitely did it when I said pull behind me, because that's when the vehicle had moved up a little bit.
And then did you see the vehicle move up again? A second time?
Yes, that's when I told him to pull behind me.
Okay, so that's the first time. So just so we're clear, when you first saw the SUV, it was stationary, correct?
When I first saw the vehicle, it was straight ahead out the front door, stationary.
And you texted here.
Correct.
Then you walked back over to the window, or I'm sorry, to the door, to the storm door, and you said, pull behind me, correct, at 12:31?
Correct.
All right, at that point, you saw that it had moved up a little bit, is that right?
Yes.
Okay, so if you saw it move up a second time, which you just said you did, then that would be a third time that you had to have seen it and texted, correct?
Why would that be third time?
Because it only moved once so far. You saw it move twice.
So the first time I saw it, it was here. And I said here. And then the next time I texted, I said, pull behind me. So that was 1 time, 2 times.
Keep going. You said you saw it pull up again, a second time. You said you saw it move twice.
From one place to the flagpole to further up.
Right, so that's 3 times that you're up to the door.
Okay.
Is that yes?
I'm telling you, my memory is twice to the door.
Mr. McCabe, it's not a trick question. You just testified that you saw the car move twice. By definition, that has to be you looked at it 3 times. Stationary, move once, move twice.
Maybe I used the wrong wording.
Maybe. Let me have just a moment, Your Honor.
Sure.
So, when you testified in front of this other proceeding, didn't you testify that you walked up and sat back down 5 different times, watching that car and texting every single time?
Would you be able to show me that?
It's going to take a minute. Can I have one here? Thank you. May I, Your Honor?
Yes.
Take a look at those 4 pages. For the record, that's pages 780 to 784,
Okay.
bait stamped. After you've had a chance to review that, just look up and let me know.
While we have a moment in our virtual present, our live past type thing we got going on, I just want to let the mod know that her background is quite cool. Good upgrade there from the mod. Yep. It was. Yep. She's back. Yeah. Nice scenery from our mod. Well done, well done.
May I?
Yes.
You had an opportunity, Ms. McCabe, to review those few pages from your testimony in June of 2023.
Yes.
Did you talk about, you were asked about getting up and sitting down and looking at the SUV several different times and texting?
Yes.
In fact, you indicated that you got up and looked outside through that storm door several times, correct?
Yes.
And as a matter of fact, you looked every single time that you texted, you indicated that you looked out at the SUV and saw something that prompted you to text something, correct?
Correct.
And then after the last time, which would be 5 times, 5 texts, 5 looks, after the last time you texted, you got back up, which would be a 6th time, and the SUV was gone. Just chronologically.
Correct. My husband and I were both getting up and looking, so
I didn't ask you about your husband.
okay.
Just about you. The answer is correct.
Yes.
Okay. So you're indicating that you were trying to communicate with the occupant of the SUV that was sitting, what would you say, 30 feet outside the front door?
I'm not good with distance.
It's further than you and I are from each other, correct?
Correct.
At least double that, right?
Correct.
Okay, so could you give me, maybe yards are easier, like 10 yards, 15 yards?
Again, I'm not good with measurements.
Okay. Just right outside the front door, though. Within,
Straight outside, yes.
well, straight outside until it moved.
To the front door. Of the front door is where it was.
Ms. McCabe, straight outside until it moved, according to you, correct?
Yes, and then it moved. Correct.
And then moved a second time, correct?
Correct. It moved to the flagpole, and then it moved up again.
Okay. Then you indicated that you had an absolutely clear view of the SUV. You were asked those questions, correct?
If I had a clear view,
Clear view.
I could see the car out front. Yes.
You were asked, you were looking out the front door of the house, Your answer was, uh-huh. You were asked, and there's a window in that door, right? Answer, it was opened. Yeah. Question, so you had a clear view outside. Answer, a clear view outside. Yes. Remember that?
Yes,
Okay. And is that your memory? You had a clear view?
I had a clear view of Karen's vehicle outside, correct?
And then you reiterated that with the following exchange. Question, was the amount of snow coming
Objection,
down
Your Honor.
sufficient?
So let's hear the question.
Was the amount of snow coming down sufficient to obstruct your view of the vehicle, or did you have a clear view of it? Answer, I had a good view of it.
Objection.
The objection is as to the form of the question and the reading.
No, that's okay. I'm going to allow the question.
Was that your testimony?
Yes,
So not only did you have a clear view, you indicated in your words you had a good view of it, right?
correct.
Then you noticed that the SUV was gone after the 12:45 text, right?
Correct.
So you're looking at that SUV over the course of between the beginning text and the end text. It's about 19 minutes, right? 12:27 or so to 12:45, 18, 19 minutes, something like that, correct?
Correct.
You maybe add a minute because you got back up and didn't text, and the SUV was gone, right?
Correct.
So you would agree, you do some basic math, you're looking at that SUV on average about every 3.5 minutes.
I guess I'm, if you want to pull out the times and you can look at them.
Well, we talked about the times, and you agreed that you were texting between 12:27 and 12:45,
Correct.
right? So if you were just to divide that by 5 times, getting up and looking, I don't know, I'm doing the math in my head, maybe it's every 3 minutes or so.
Correct.
At no time did you hear any noise or sound outside that was unusual? Caught your
No.
attention? You didn't hear any squealing of tires or squealing of brakes?
No.
You didn't hear any screaming or yelling?
No.
You didn't hear any loud voices or foul language or doors slam?
No.
You didn't hear any verbal argument or the revving of an engine, anything like that?
No.
As a matter of fact, you didn't hear any collision or crash, did you?
No.
As a matter of fact, the entire time that you looked out at that vehicle with that clear and that good view, you didn't see anything out of the ordinary, did you?
No.
And you would agree with me, as you looked at the SUV, you're looking over the lawn to the SUV out at the street, correct?
Correct.
There was no obstruction between you and the SUV. You've already testified to that, is that right?
Correct.
And you could see everything in your field of view.
Correct.
And then you saw the SUV gone. It had driven away after 12:45.
Correct.
So I have a question, kid.
Mm-hmm.
Where was the body?
I have no idea. I'm assuming the body was on the front lawn.
The problem with that is you were looking at the front lawn, weren't you?
I was looking at the vehicle and where it had moved.
Do you know what field of view is?
Would you like to explain it?
You had a clear and good view across that lawn to the SUV, didn't you?
When it was straight out, I did, yes.
You had a clear and good view of that SUV the entire time until it left, didn't you?
I could see the black SUV, correct.
Nothing was obstructing your vision.
I wasn't looking at the ground.
I didn't ask you about the ground yet. We'll get to the ground. Nothing was obstructing your vision, was it?
No.
So you had a clear and good, your words, not mine, a clear and good view of the SUV
Yes.
and everything in front of it.
I never said everything in front of it. I saw the SUV. It's black. It has lights on. And as it moved, I could see it with its lights.
And you had a clear view of everything between you and the SUV. All the things closer to you and the SUV.
I wouldn't say that.
So your view was obstructed on what was between you and the SUV, but not obstructed on the SUV?
That's not what I was saying.
No, of course not, because if you had a clear field of view to the SUV, you could see everything in front of it as well, meaning between you and the SUV as well.
If I'm looking straight out at an SUV, I'm not looking down at the ground.
Let me ask you a question about that. You're focusing right now on my face
Yes.
as you're answering these questions. You think you'd see, I don't know, an alligator sitting in front of me if it was there?
Objection, Your Honor.
You think you would see something? Can you clearly see that there is nothing between you and me except a podium?
Yes. Well, there's a table.
And you don't have to look down to see that, right?
Correct.
You're looking directly in my face, but you can see things that are between you and me because you have a field of vision, right?
Objection.
Thank you so much for your service. I want to see counsel at sidebar for just a minute.
Be seated for a second.
All right, I'd like to pick a status date to find out what our next move is. So I'd like to come back. I'd like to pick a status date to find out what our next move is. So I'd like to come back sometime maybe the end of July. I understand people have vacation schedules. Can we come in the week of the 21st?
That's fine.
No, I'm just looking at my calendar. Could we do the 22nd at 2 p.m., Your Honor? And I would appear for my client.
All right, is there another day that week? Could you do the 25th or 26th?
Unfortunately, I think I'm supposed to leave for vacation on the 25th.
Okay, the 22nd and the 24th are not great dates, so.
What about the 19th and 9th? Is that whole week?
No, that week's not good. Teaching that I cannot get out of.
Can we do August 7th, 8th, 9th, any of those days?
No, we'll do the 22nd. We'll go back to the 22nd at 2. I can't let it go that long.
Your Honor, so for those, Ms. Lou and I are not available on the 22nd. We have a hearing in Los Angeles on the 22nd.
Okay.
We're proposing to appear remotely anyway.
Okay.
But for a status conference, I don't want the court to think it's disrespectful to the court, but Ms. Lou and I probably will not appear.
Okay. So you and your client will be here in person, Ms. Giannetti?
Yes.
All right. All right. Thank you. We'll see you then.
All rise.
And now we have an official ruling in the Karen Reed murder trial. It is a mistrial declared, and you see there Karen Reed hugging her father shaking Alan Jackson's hand. Behind him in the red tie is attorney David Yannetti. And you can see off with their backs turned, that would be the O'Keefe family, who seemed, that's his mother right there in the blue and white striped shirt in the far background that you can see also hugging. They seemed rather emotional today. A mistrial after 2 notes. The first one came in at 11:30, saying in part, we find ourselves divided by fundamental differences in our opinions. The divergence in our views is not rooted in a lack of understanding, but deeply held convictions that each of us carry, ultimately leading to a point where consensus is unattainable. The judge, however, Judge Canody, sending the jury back using the Tui Rodriguez rule, also known as the dynamite charge, which has her strictly saying to them, please, there is no jury who can do a better job than you can. We need a verdict in this case. They came back then at 2:30, and the note says, despite rigorous efforts, our perspectives are firmly divided. And they went to go on to say some feel very strongly that there has been proof beyond a reasonable doubt Others, the exact opposite, that there has not been proof beyond a reasonable doubt. This indicates that most likely it is more than just one juror who is the holdout in the division among these 12 jurors, 6 women, 6 men. And it says, since adherence to our convictions are deeply held beliefs, that this would not be worthwhile to continue to deliberate. This is after 9 weeks of testimony, more than 600 pieces of evidence, 29 days of testimony, and they spent about 5 days deliberating. The Commonwealth was charging Miss Reed with second-degree murder, motor vehicle manslaughter while driving under the influence, leaving the scene of a collision causing death. Manslaughter was also, as you see, motor vehicle manslaughter, but the lesser included charges were in there as well. The jury's instructions from the judge was that you can't argue with the law. It's not what you want it to be. It's what it is. The presumed innocence of Miss Reed, unless proven beyond a reasonable doubt. She doesn't have to explain herself or provide any evidence at all. That is up to the prosecution. And again, what it appears to be, and until we hear from the jurors or Judge Cannoni herself, what it appears to be is that there was a deep division, more than one, within this jury of 12 who could not come to an agreement as to her guilt or innocence. She went on to make sure that there must be unanimous under reasonable doubt, proof beyond all possible doubt. You need to have moral certainty. If after looking at all the evidence, you do have reasonable doubt, then the defendant is entitled to the benefit of that doubt and must be acquitted. Still, despite all of that, they could not come to a conclusion. They had a half day of deliberations on Tuesday after closing arguments by both the prosecution and the defense. They deliberated Wednesday, let off a little early around 4, all day Thursday, all day Friday. Matter of fact, extending their deliberations until 4:30. Asked to think about it over the weekend. They came back and it did not take long. They were in there at 9 by 11:30. That was the first note to the judge, that they just couldn't come to an agreement. And once again, around 2:30, once again, the judge got that same similar note that despite their rigorous efforts, their perspectives are firmly divided and that further deliberations will not budge one side or the other. Judge Cannoni then declaring a mistrial. On July 22nd, they will be back in court at 2 p.m. to figure out what is next. In terms of Karen Reed's lawyers, David Yannetti will be back with Karen Reed in the courtroom. And as for Mr. Jackson and Ms. Little, they're not available. They'll be out in L.A. We have our courtroom insider, Sue O'Connell, on the phone. Sue, can you give me a feeling in that
Okay, we'll break down what we're hearing. We're going to continue to listen to the commentary here, and then we will add our commentary
I think you
following.
can pretty much feel the relief
So,
of the
here's
jurors
the update
when the judge declared this mistrial. There's
from
been one
Boston
juror
10.
who has been crying on a regular basis when she goes into the courtroom.
Sue, we're gonna cut in and listen to Alan Jackson. Hold one moment. All right, we can't seem to hear it. We are recording this right now. Of course, we'll get it to you. Sue, continue to talk to me about the relief that you say the jurors felt, or at least
I mean,
appeared
they
to
have
feel.
they have been a pretty poker face looking crowd all through.
We're going
I
to
mean,
stay with
occasionally,
this
as
for a
we've been
little
reporting
while,
on Canton
and then we
Confidential,
will provide
we
our
see
analysis.
faces, they make motions, and we can only, guess what we think that is based on our human experience. But today they actually came in looking bleary-eyed, looking like they had the weight of the world on their shoulders. And when they came in this afternoon, there was absolutely no doubt about it that they had tried as hard as they could. Everyone in the courthouse, all the people that I've talked to, have talked about how hard this jury has worked, and that there should be in no way, shape, or form any look at that they didn't complete the task that was given to them for whatever reason. Obviously, we will learn more about what went on in the jury room when we find out who the jurors were and if some of them would like to talk to us. But there was a feeling of relief. And also, some jurors looked really pained when they were walking out. Certainly, again, we don't know what the issue was. We don't know how many people are split, but they walked out feeling, I think, by looking at them, that they had worked really hard, and some of them were pained and looked disappointed that they didn't get to the conclusion that they were hoping for, JC.
Sue, what about the O'Keefe family? I could see Mrs. O'Keefe in the background. She's been she's been emotional, but not overly so. I imagine that she saw this coming, as we all sort of did, based on the note that was sent to the judge on Friday and then again this morning. But did you get any sense from the O'Keefe family what this verdict meant to them?
I saw them when they walked into the courtroom, JC. I didn't get to see their faces when the judge declared the mistrial or basically said that the jurors were stuck and they weren't going to go further, and then declared a mistrial. But, you know, coming in, you can just imagine the trudging in back and forth, waiting to see if there's going to be the answer that you hope for. They did look like that this has been really just wearing them down. You could probably hear the cheers in the distance of the Karen Reed supporters, but all in all, this has been just very difficult for them, and you could tell by the weight of the world has been on their shoulders as well. I talked to a number of law enforcement outside today, and they were just saying that regardless of the verdict, the fact that they're not going to get any sort of closure or idea of what might have happened to John O'Keefe is really part of the great tragedy here. And as we have tried to keep doing, keeping the idea and that John O'Keefe is the victim here. He died tragically, and at this moment, we're not going to know why, and at this moment, no one is being held accountable, JC.
Sue, stay right there. We have Michael Coyne, our legal expert, on the phone. Michael, Judge Cannoni did say that they would reconvene July 22nd at 2 p.m. to figure out what comes next. So you tell us, what comes next in something like this?
Well, the prosecution will have to decide whether they want to retry her or not, and I expect that they will decide to retry her. It's the death of a police officer, and the prosecution feels strongly that their case is correct, that they've got the right defendant. And so then the question becomes, will the defense attorneys be able to come back? Can they fit it into their schedule? The financial issue becomes a question as well. And then ultimately, how do their schedules all work as to when this might be retried? There's always the possibility that the government might decide not to pursue a second trial. I don't think that's likely. There's also an unlikely possibility that they could strike a deal as well. Again, I think that's an unlikely possibility here, JC.
Let me just ask you, how much say does the O'Keefe family have when it comes to the prosecution's decision whether or not to retry?
Not a lot. I think obviously the district attorney would take into account their feelings, but either whether they were strongly one way or the other wouldn't necessarily be dispositive. As the chief law enforcement officer for Norfolk County, he has a responsibility to everyone involved to really take a hard look at the case and see whether it makes sense to go forward again.
All right, Michael, joining me now on the set is Glenn Jones. Glenn, as you heard, that has been declared officially a mistrial, which is where we were leading based on the jury's note to Judge Cannoni on Friday late in the day, and then this morning, and then here we are, 2:30, they came in and declared yes.
I suppose at this point we can't be entirely surprised that this is where things ended, especially with how eloquent and articulate the notes were from the jury. And here we go. I expect, as Michael Coyne just said, that we'll be here doing this again because, of course, there is a victim in this case and there's no accountability yet for his death.
Michael, are you still with us on the phone? Michael,
I am, JC.
I just wanted to ask you, and this is a Monday morning quarterback kind of question, but it's also just off the top of your head. This was a 9-week trial with more than 70 plus witnesses. If this were to be retried, could we think that the prosecution might have the ability to cut that in half and perhaps take a slightly different approach to this?
I think you're absolutely right. If it's tried again, they have to cut it in half. They have to boil it down to the essential parts of the case as they see it, which should be the excessive drinking, the driving, and then obviously tying his death more closely to her actions than they did in this case, in all likelihood. The fact is that the jury must have struggled with some of these issues, and so the government gets a chance to have a do-over here and fix the mistakes made. To me, this is a win for the government simply because the defendant's resources were likely drained at this point. Most of us thought that this would likely be a not guilty verdict. So to have the chance to correct the mistakes that we saw during the first trial, this is, if they're going to retry her, they all, in almost all likelihood, will have a significantly different case that will be mightily pared down from the last case.
Okay, Michael, thank you. Stay with us. Let's go now to Denham and NBC 10 courtroom insider Sue O'Connell braving the weather conditions there for us, Sue. We've been talking on Canton Confidential about the likelihood that this jury had to wade through so much evidence, and of course that is still true. But I wonder, Sue, what you think was happening in that jury room now that we know that people were kind of dug in on their personal beliefs and the rhetorical arguments that must have been ensuing inside that jury room.
Right. What we heard, Glenn, from the juror's note, right, was that it wasn't about the evidence. It was a different interpretation of the evidence. It was, if I remember it, what they said correctly, that some felt it met the burden of proof and some said that it left too much reasonable doubt. And we had heard earlier I think the note from this morning from the jury that there was a deeply held convictions, or there were deeply held convictions, that it wasn't that they hadn't worked hard enough. It wasn't that they hadn't evaluated the evidence. It wasn't that they hadn't thought hard about this, that one, two, we don't know how many jurors had come down to a decision that the other jurors disagreed with, and there was no moving them. So some immediate questions I have about that was that if there is indeed some deeply held conviction, and remember, we don't know if they were disagreeing about charges, the lesser charges, we don't know if they were disagreeing about guilty or not guilty, we don't know what the numbers are in the split. But, and I also think that the foreman was also being somewhat diplomatic by the way that the letters were written, the notes were written. We can't intuit what the numbers are there. So having said that, saying someone has, or some jurors have, a deeply held conviction, I'm wondering if that was something that maybe should have been vetted out during the voir dire of the witnesses. For example, I'm a commentator, so I could tell you this. I'm against the death penalty, so I would be unable to serve on a jury if death penalty was on the table. That's fine, that's the law of the land, but I would be vetted out of that. So I'm curious to find out what this strongly held conviction is that one or more jurors have. And I'm also just really very curious to find out if it breaks down between a not guilty versus guilty, or if there were some of the lesser charges that really broke it up. Glenn and JC. All right, Sue, thank you very much. You know, now we want to just go out to what the defense had to say when they walked out of court. Sue, take a listen in, as well as our viewers here. Okay.
Judge Cannoni, despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of the charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. I'm not going to do that to you folks. Your service is complete. I'm declaring a mistrial in this case.
Folks, this is what it looks like when you bring false charges against an innocent person. The Commonwealth did their worst. They brought the weight of the state based on spurious charges, based on compromised investigation and investigators, and compromised witnesses. This is what it looks like. And guess what? They failed. They failed miserably, and they'll continue to fail. No matter how long it takes, no matter how long they keep trying, we will not stop fighting. We have no quit. Go ahead.
I just have two things to say, folks. Number one, I am in awe of the strength and courage of this remarkable client that I've had the privilege of representing since day one. And number two, I want to send a message to all of her supporters out there. Your support was invaluable. We are touched, and we ask for your continued support. I'm not from Texas, like my colleague here. I'm a Boston kid. But I'll repeat what he said, which is, we ain't got no quit.
There you were hearing from the defense team, both David Yannetti and Alan Jackson, which, by the way, Alan Jackson is based out of Los Angeles. Whether or not he will continue on the case, there was a reporter who yelled that out. We
charges.
Well, first of all, thank you all for being with us during this process. We have come to a hung jury, a mistrial, and it looks like we're going to have a lot to say about this, not just now, but later. It's a little obvious to me that the family of John O'Keefe, that we should continue, as with any person who is grieving and has been through extreme trauma, we should certainly remember them and send good blessings their way for the trying times, to which we know right now it will continue. No closure today. So we put that in the universe. Positive vibes to that family. As it relates to the jurors, as you know, if you've been following us live or on the replay, we've been exposing the intricacies of the legal system, of negotiation in general, and the different variables. And no one should be surprised. You may be emotionally struck by the mistrial, but if you've been listening to us for the hours and hours that we've been with you during the verdict watch, you can't be surprised. Well, I guess you could be, but shame on you. I've been painting the picture for you. I've been showing you how this is possible. Day after day, I've been illuminating to you the subjectivity, the intricacies. It's not just so-called evidence. It's not just your belief and you shut down and don't see the other side. There are so many wrinkles. And I've spent hours showing you that. And I did a quick look in the chats and the messages around the globe. I mean, people, it's hysterical. They're hysterical with grief and all types of other things. Not if you've been with this channel, you may, again, you may not like what's happened, but you shouldn't be surprised if you've been listening. We've walked you through the possibilities of how this can happen. Even today, as we're exposing the testimony, as we're listening to how you could easily see how people can get fortified in their position. For instance, day 14 and 15 with Jen McCabe. If you find her credible, if you find her style, if you find her answers, if you find what she's saying credible, then you come down to, I hit him, I hit him, I hit him. Now, how do you back off from that? And I posed that question to you hours and hours ago. How do you come to not guilty if you find her credible? And people just dismiss. They don't even want to deal with it. They don't even want to ask the questions. They don't want to deal with it at all. And now you're forced to. I mean, you could have done it voluntarily and just had the thought experiment as I'm coaching you and helping you to see, look at the other side of this thing so you can appreciate the possibilities here. No, you don't want to do it. No, you don't want to do it. Now how is it possible? What do you mean, how is it possible? I've been showing you how it's possible. I'm glad we also stuck around, and shout out to Boston 10, shout out to them, shout out to them, shout out to them. And they brought in another legal analyst, could be right, could be wrong. He made a couple of great points, one of which, the resources. Says, well, the defense is probably tapped by now, and we don't know if these guys are going to stay on. That's real talk. That's your justice system. This stuff will break you. You know, they say OJ, now, there you go, your emotions again. I'm all right with that. They say OJ was signing footballs in his jail cell during the trial of the century, signing footballs, autographs, to help pay for his legal defense. That at night, they'd bring him a bunch of deflated balls and he would sign. That's what he would do at night. We'd watch the trial during the day, and then at night he's signing, and they would sell them so he could afford to keep up the defense. So when those homeboys were talking about, hey, she's going to need your support. She's going to need your continued support. When homeboy just said that, her defense attorney, yeah, he knows what he's talking about. We're going to need your continued support. She's going to need your continued support. These cats got other cases. You know, there's fresh money out there. This stuff ain't charity, y'all. But again, people want to believe what they want to believe. And now you're wondering how and why. I also heard, and you heard it as well, that the inside reporter that Boston 10 has, 10 Boston, says the jurors had the look of relief in that from their perspective, these jurors had been 10 toes deep. I mean, they had been pushing. So if that's true, shout out to them, man. Because that's one of the things that we were certainly concerned about on this channel is the pressure that they were under. And it looks like they held strong. I got to respect that. Man, I got to respect that. I spent a lot of time talking about, you know, hey, they already did their part. They came to you and they told you we're stuck. Now you're putting pressure on us to try to change what we believe. And they didn't. At least it doesn't sound like enough of them did. If anyone did, enough of them didn't do it. I mean, we have to be honest about that too, right? Someone may have changed. This one may have changed. That one may have changed. But ultimately, you still didn't get to unanimous. So much respect to the jurors. We also talk about what happens next. And we brought up some of those contingencies earlier in the program. And yes, it's going to be tough. It is a stain on the community. These are accusations that people may want to just sweep under the rug and move past and not have the spotlight and the press and all the hoopla back in Canton and dealing with all this stuff again. And, you weigh that against, hey, there's still a dead police officer and justice must be served, right? I mean, that's what we believe. And the Commonwealth has the money, your tax dollars, they have it. It's just the decision to use it. Karen, on the other hand, added to which, there are people who heard the testimony. There are people who were there in that courtroom called jury members day after day after day after day, and they say she is guilty beyond a reasonable doubt. So you Karen lovers out there are people, members of the community who heard the evidence, and they didn't all say, this is a conspiracy. She's being framed. How can we even have a trial? This thing should have taken 2 seconds. There are members of that community who are diametrically opposed to that way of thinking. There are members of the jury who have proven, even under pressure, that they are not going to change their view. Beyond a reasonable doubt, she's guilty. I'm going to take one more step, at least, but not too many more today, because we're going to continue to talk about this, obviously, now, right? We're going to continue to talk about this. But I mentioned OJ in his cell signing those footballs. Should I feel, I'm posing it as a question, like me, dislike me, but I'm posing it as a question. Should I feel some kind of way that the woman was heard saying I hit him or something like that and still was allowed to drive away that night or morning? Should I feel some kind of way as a brother man that here's somebody who had been extremely intoxicated, as it would appear, said things that may mean that she murdered someone, vehicular homicide of some degree, and she's allowed to drive away? Should I feel some kind of way as a brother man in America? I'm asking the question now, because this is Rhodes, Dogs, and Conversation. Should I feel some kind of way that I just watched that woman walk out? I mean, I know she had bail, so she's been going back and forth. I understand that, and I already know I could feel a certain way about that. But now there are even members of the community, members of the jury who have said she is guilty, and yet she can just walk out until the next go round. We cover other trials, etc. Cats can't go nowhere. They locked down. Do you hear me? I mean, bunches and bunches and bunches of them locked down with more money than Karen has. But they can't just walk out and be like, okay, we holler at you on the next time we holler at you. Oh, I got a trial date. Okay, I'll show up. Should I feel some kind of way? I know you didn't even look at that. I know you didn't even look at that because maybe you're used to sitting in that high chair. I just posed a question. Should I feel a certain kind of way about that? The Commonwealth says that she killed a police officer. They believe they have the right person, is what we understand. And there are people in the community who have stamped that. Yes, that's true. Beyond a reasonable doubt. She's the one. And she could be out driving right now as we speak. Right now, driving. In fact, she could be drinking and driving. I'm not saying she is. I'm not saying she is. But she could be celebrating and throwing them shots back right now, driving down, and your kid could be playing in the park and run out and chase a ball. I haven't heard that she can't drive. I mean, I might have missed that part, that somebody has her keys and she's being chauffeured around and she can't drive until this case is over. I haven't heard that. So not only is she able to walk around and do her thing and greet her supporters and all that, I mean, who gets to do all that? And she's being accused of murder. Now, when I ask you if I should feel some kind of way about that, if you've been following our channel, one of the things you should hit me back with is, yeah, that's deep, but what about the next level, Brother Rose? And I'll be like, yeah, what's that? What you got for me? What you got for me? Yeah, maybe the fact that they let her do all that. See, you can enrage the community. You ain't ready for me. Y'all not ready for me out there. You're not ready for me. I had you seeing things that I had your head just like the weight of it. You can't even hold your head up no more. It's like, man, pick your head up. Come on, lady, pick your head up. You can't do it. I'll mess you up. I'll mess you up. I had you thinking, yeah, let her out there the way she is, Miss Effervescent. Give her bail. Let these other police officers see her smiling, dancing, clapping, yelling, screaming, running her mouth, going around town because she don't know how to play it humble. She don't know how to play it humble. Let her be out there running her mouth while 20 police officers look at her who all knew John and loved John. Let them keep seeing that in the community. Y'all ain't ready for me. Y'all ain't ready for me. Yeah, let her out. She don't know how to play it cool. She gonna be out there doing her thing. Look at how she dressed in court. She don't know how to keep it smooth. Knowing I'm out free right now. And these cops watching. Knowing John was a good dude by almost everybody. And she out there living the life. In this small community where everybody know each other, grew up with each other. And she just doing her thing. Doing her thing. Karen style. And got y'all in love with her. Karen style. Should I be feeling some kind of way if she was darker doing that? Would y'all really love her as much? Or would you be saying, how dare she? Who does she think she is? I'm asking the question. You do what you want to do with it. I'm asking the question. We'll talk more about it. Let me know how you think. Boy, if this algorithm opens up, y'all in trouble. We're not going to be able to keep up with the chat. Speaking of which, throughout this whole process, our mod, let me show you who we talking about here. Our mod has been hanging in there with us and a part of what's been going on, and we appreciate you. So to our mod, thank you for your wonderful efforts. Had it not been for you, I was not watching this read thing, as she knows, and as you know who've been watching. I couldn't tell you nothing about this doggone case a few minutes ago. Not a doggone thing. But she hit me to it, so thank you. And for those of you who think that I had some kind of inside information on it or been watching it, heck, nah, I ain't know nothing about it. So when I say I'm watching this stuff for the first time, it's just the way it is. But it's the way it is at Rose Dog Conversation. We like to shock you with some insight that you might not see coming. It's what we do. It's what we do. We bring value to you. So speaking of value, we appreciate our mod and her efforts to inform you and ask so many engaging questions. It certainly ain't her fault. It ain't her fault. She's been doing the do in the chat, and we appreciate it and the insight and the information. Now we are running over to the YSL fiasco and all the foolishness going on over there. So if you've been appreciating her efforts and you want to stay up with her and begin to communicate more with her and watching replays, you'll be able to catch her with the YSL trial, catch her on future streams and other things that we're doing here at Rose Dogs and Conversation. And for those of you, you heard her reading the background, this, that, and the other, but you also need to know that she has her own opinions about things. So we're gonna let her wrap up and offer some closing thoughts on where she is with the trial and the mistrial as it was, and any other thoughts that she may have as we position ourselves from here to possibly doing this all over again, and also the YSL and the like. So to her, again, welcome to the stream and your closing thoughts, at least for now, on the mistrial and your vibes on our coverage of it so far, and your thoughts about shifting back over to the YSL. All right, the floor is yours, Ms. Mott.
Well, thank you. I think it's very unfortunate that this did end up in a mistrial. It just leaves, as you said, there's no closure for anyone. Watching Officer O'Keefe's mother as the mistrial was being declared, that's just heartbreaking. You know, even though if there had been, you know, a decision one way or the other, it still may not tell us exactly what happened, but I think it would help with the closure. So the pain that that family is still going through, I think it's so unfortunate. Pretty amazing that no one, or at least, at least as far as we know, those who could not come to an agreement originally seem to have stuck their ground. They would not allow themselves to be swayed. They did not acquiesce to the majority or to those with whom they did not agree. And I have to give props to people who, it may have been one, it may have been two who just said, nope, this is what we're standing on. And that's hard. That's hard for a lot of people, I think, to not just give in to what the majority thinks, and maybe feeling some pressure to change their mind. So I give great credit to the jurors, no matter which side they were on, that they really stood their ground, held true to themselves, based on what they had heard through this whole trial. And so now, yep, to some other insanity with the YSL trial, and some more courtroom shenanigans we hope you'll join us for. Hopefully we can also get some dogs for you to see pretty soon here. Spend some time with them and share them with you. Might even have some pups in the next several weeks to share. So we hope you've enjoyed your time with us. Please like, subscribe, hit that notification bell. And if you're ever feeling brave enough, whether you agree or disagree with what's happening, we look forward to some conversation. And if you disagree, that's even more fun for some people I know. So thanks for joining us. We look forward to seeing you soon. Have a wonderful day and peace out.